ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
ಕಬ್ಜಾ ಮಾಡಿ ಅದನ್ನ ಇಂಡಿಯನ್ ಹಾಕಿ ಪಂಚಾಯತಿ ಅವ್ರಿಗೆ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡೋದು ಬಿಡ್ತಾ ಇಲ್ಲ. ಅದನ್ನ ತಹಸೀಲ್ದಾರ್ ಆ ಪ್ರಾಪರ್ಟಿ ಎಂಟರ್ ಆಗಕ್ಕೆ ಬಿಡ್ತಾರೆ, ಸರ್ವೆ ಮಾಡೋದು. ನಾವು ಪಂಚಾಯತ್
ಸಬ್ಮಿಷನ್ ಮಾಡೋದಕ್ಕೆ ಸರ್ ಅದು ಜಯಮೋಹನ್ ತಾರೀಕು ಫೈನಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋಗಿದೆ. ಪಾರ್ಟಿಷನ್
partition office objection judgment preliminary hearing on orders
ನಾವು ಗೊತ್ತಿಲ್ಲ
ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ? preliminary hearing file ಅಲ್ಲೇ ಇದೆ ಅಂತ ಓಡೋಕೆ
23 ಅಂತ ಅಂದ್ರೆ ಕೊಡ್ತೀವಿ.
23 ಹೇಳಪ್ಪ ಎಲ್ಲಿಂದ ಇದೆ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಂದ FTP ಮುಗಿಯಕ್ಕೆ 3 ವರ್ಷ 4 ವರ್ಷ. ಗಿರೀಶ್ ಬಿಟ್ಬಿಡಪ್ಪ ಬಿಟ್ಬಿಡು.
19 ಹೇಳ್ಬಿಡು.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅದಿಂದ 57 53 67 55 39 74 10
90,
Hmm.
81,
Hmm.
57, 87.
ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
74,
Hmm.
21, 21,
Hmm.
28, 98, 58, 51, 49, 86, 71, 49, 46, 30, 38.
ಇನ್ನೂ ಇದೇನು ಫೈಲ್ ಬ್ಯಾಗ್ ತಂದು ಕೊಡೋದು ಉಲ್ಟಾ ತಂದು ಕೊಟ್ಟವನು ಬ್ಯಾಗ್ ತಂದು
ಟ್ಯೂಷನ್ಸ್ಗೆ ಹೋದ್ರೆ ನಾಳೆ ಇಲ್ವಾ ಕಮಿಷನ್?
ನಾಳೆ ಅಲ್ಲ 5ನೇ ತಾರೀಕು
ನಾಳೆ ಅಂತ ಇತ್ತು.
ಅಲ್ವಾ
5ನೇ ತಾರೀಕು ಇದೆ ಬಟ್ ನಾಳೆ
ಎತ್ಕೊಂಬ.
ಸೆಂಟರ್ ಕೊಡ್ತಾರೆ.
ಅವ್ನು ಬರೋಷ್ಟಲ್ಲ ಅದೊಂದು ಚೆಕ್ ಆಗೋದು.
58,
ಆಯ್ತು
89, 47, 29, 78,
78 ಒಂದೇ ಫೈಲ್ 76 ವರೆಗೂ ಆಗಿದೆ. ಪ್ರಿಲಿಮಿನರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಯ್ತು. ಪ್ರಿಲಿಮಿನರಿ ಬಾಕಿ ನೀವು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹೇಳಿ 35. ಆಯ್ತು. ಇನ್ನು ಗೀತೆಗೆ ನಾನು ನೋಡು. ಕೊಡಿ.
ಪ್ಲೇಟ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಇದೆ.
ಒಂದು ವಿತ್ಡ್ರಾವಲ್ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಪಿನ್ ಮಾಡ್ಕೊ ಬರೀವಾಗ. ಎರಡನೇದು ಮೊದಲನೇದ್ರಲ್ಲಿ ಇದೆ. ಅರ್ಜೆಂಟ್ ಇಲ್ದೇ ಇರೋ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ. ಕೊಡಿ
ಸರ್ ಮೂವ್ ಮಾಡೋದಕ್ಕೆ ಬಂದಿಲ್ಲ.
ಕೊಡಿ ಸರ್, ಅದನ್ನೇ ಪರ್ಸ್ಯೂ ಮಾಡಿ. ತಿರ್ಗಾ ಮೂವ್ ಮಾಡಕ್ ಹೋದ್ರೆ ತಿರ್ಗಾ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ. ಆ ಮೆಮೋ ಬುಕ್ ತಗೊಳ್ಳಿ, ಅದು ಯಾವತ್ತು ಹೋಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ, ಅದನ್ನ ಪರ್ಸ್ಯೂ ಮಾಡಿ. ಅರ್ಜೆಂಟ್ ಇದ್ದವ್ರು ಮಾತ್ರ 10 ದಿವಸ ಕೊಡಮ್ಮ. ಅಲ್ಲೇ ಕೊಡು. ತಗೊಳ್ರಿ ಅರ್ಜೆಂಟ್ ಇಲ್ದೇ ಇರೋ ತಗೊಳ್ಳಿ. ನೆನ್ನೆ ಏನೋ ಬಂದಿತ್ತು ನಿಮ್ ಮ್ಯಾಟ್ರ್.
ಅದೇ ಬಂದಿತ್ತು
ಅಲ್ಲ ಹೌದು
ಇನ್ನೊಬ್ರು ಇದ್ರಲ್ಲ,
ನೆನ್ನೆ ಇತ್ತಲ್ಲ.
ನಿಮ್ ಕೊಲೆಗೆ ಇದ್ರ 69
ಇದ್ರ ಅದೇ ಮ್ಯಾಟ್ರ್ ಹೆಂಗೆ
ಇಲ್ಲ ಅದೆಲ್ಲ ಇದೆ.
OS 2226 225 ಅಂತ ಹಾಕ್ತಾರೆ ಅವರು. 2 ಬೇರೆ ತಂದು ಹಾಕಿರ್ಲಿ. ಇದಕ್ಕೆ ಅದಕ್ಕೆ ಪಿನ್ ಅದೇನೆ 226 ಎಲ್ಲಿ ಹೋದ್ರ ಅವ್ರು ಮೇಡಮ್?
One matter, my lord.
Back to more matter, my lords, for 2:30 today, the learned trial judge has imputed fraud on the plaintiff, my lords, and imposed costs. And then, my lords, further listed the matter tomorrow for if I have not complied it, then has passed a peremptory order to vacate the temporary injunction order, my lords.
Tomorrow. Yes.
2:30, my lord, end of the list, my lords.
Tomorrow.
The matter is tomorrow, my lords, in the trial court, end of the list.
Sir, we'll see. Yes. In the trial court, Lord, this matter, fresh matter, dismissed for non-prosecution, filed IA for restore the matter. Kindly out. Already
Next week.
moved the memo already.
Yes. Next week.
But a suit for partition,
Application
madam.
has been rejected by the Alanabad trial court, my lord. Matter is list ಆಗಿತ್ತು. ಅದು ಒಂದೇ ಸಿಂಗಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು, ಅದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ 230 ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಸರ್ ಎಲ್ಲ ಈ ಕಡೆ ಬನ್ನಿ.
Your Honor, in this case, amendment plaint of the dismissed in the trial court, Your
Wait,
Honor.
wait, ma'am.
Case is final argument.
Defendants are trying to disperse me from a position, my lord.
I Tuesday, third, Tuesday.
My lord, sir, suit is of 2011, my lords.
So much space is there, why? Witness.
Trial court dismissed the amendment plaint, Your Honor, and case is posted the final argument 3/2/2025, Your Honor. Kindly.
No,
post
what is
it.
that order you are challenging?
Plaintiff, amendment plaint, Your Honor.
When it is rejected?
Rejected date 16/12, Your Honor.
Now it is posted for what?
Final argument, Your Honor, 3/2/25, Your Honor.
Yes, witness.
Yesterday I gave the memo, my lord, but it's long date. It's a fresh matter, my lord. Finally,
What is that urgency, madam?
like, final order is 3 to 2 next Monday ಇದೆ.
ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
FTP, madam. I filed application on section 2 of Partition Act, madam. It's one property, one age shares, my lord. So ಅದು ನಾವು ಆಕ್ಚುಲ್ ಅಂದ್ರೆ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ ಅದೇ ಶೇರ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಬಟ್ ಅದು ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಸೊ ಆ ಚಾಲೆಂಜ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಆರ್ಡರ್.
Now why it is posted third?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ಬಟ್
Why matter has been posted before the trial court, madam? Third next.
ಫೈನಲ್ ಆರ್ಡರ್ ಮೇಲೆ.
Yes, witness.
ಮೇಡಮ್ ಸರ್
Witness, yes.
ನೆಕ್ಸ್ಟ್ tomorrow or Saturday.
Witness, witness. Yes. Yes, Monday. Yes, Monday. Yes.
Suit is of 2011, my lords.
Let it be. We'll pass an order on Monday.
Is of 2011, my lords. ಈ ರಿಪಿಟೇಷನ್ ತುಂಬಾ ಡಿಲೇ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ, kindly have it.
Yes, next week I'll tell us. Yes.
ಕೊಡಿ, urgent ಇದೆ.
Written statement? No, written statement is filed when? When matter is posted for argument. No, when you have filed an application for permission to file a written statement. No, what is the stage in that matter, Mr.? After evidence you have filed it. No, you have filed a permission to file a written statement. When it is rejected. After that evidence is over.
Directly has filed a memo stating that I got the automatic copy.
Judgment without evidence.
Yes.
How can it be? Tomorrow, let us see. Tomorrow,
Judgment is.
we'll see without evidence, how can that judgment can be pronounced? Yes.
ಎರಡು.
Yes, next week alone, date put.
ಎರಡು ಒಟ್ಟಿಗೆ ಪಿನ್ ಮಾಡ್ಕೊಂಬ ಕೊಟ್ಟಿದ್ದೀನಿ.
7 dates are below the order.
Wednesday. No, we are giving in a date, mister. No, we are giving in a date, Wednesday, it will come on that Wednesday. We have instructed that whatever the date it is mentioned, it has to be posted. Yes. Not sending memos simply, we are giving a date with that memo. Yes. Yes. Thursday.
Some condition would not be, this was closed by vide.
Tomorrow. Tomorrow, yes, tomorrow. Afternoon, some parted matters are there.
For page wise adjournment, list number 1, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 13. Page number 3, serial number 14 to 21. Page number 4, serial number 22 to 30.
22, 21 to, 21 is there.
24.
23, 24, 25, 26, 2 weeks. 27, 2 weeks. 28, 2 weeks. And 29, 2 weeks. 29, ಏನದು?
Sir, third time office of election.
Yes, ಅದೇ ರೀತಿ ನೋಡು. Yes.
Page number 5, serial number 31 to 33.
Fourth time also let it be there.
Sir. Page number 5, serial number 31 to 33. Page number 6, serial number 34 and 35. Page number 7, serial number 36 to 38. Page number 8, serial number 39 and 40. Page number 9, serial number 41 to 46. Page number 10.
46, my lord, I appeal for the petitioner.
Yes,
The parties are discussing settlement terms, my lord. Parties are discussing settlement terms. Would your lordships please have it
Yes.
after a week? my lord?
Yes, at the request of counsel for the petitioner.
Both parties, my lord. Let it be a joint
Both
request.
circle, yes. Counsel for both the parties has placed time. This matter of 2 weeks.
Please, please, oblige.
Page number 10, serial number 47 to 50. Page number 11, serial number 51 to 56. Page number 12.
Serial number 56, my lord.
2
weeks, I will file a C.
Appeal for petitioner, my lord. Last time ಸಹ ಹೀಗೆ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಮೂಡ್ ದಿ ಮೆಮೋ ಮೈ ಲಾರ್ಡ್ ವಿತೌಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಟೇಕ್ ಅಜರ್ಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್. ಕೈಂಡ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ.
Senior is not well.
Not well ಅಂತ
ನೋ ಮೈ ಲಾರ್ಡ್, ಸ್ಟ್ರಾಂಗ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಮೈ ಲಾರ್ಡ್.
1 week,
Urgency
Your
is
Honor. I will
something.
file
Stay
a
there.
objection, Your Honor, please.
No, he
No,
said
my lord.
senior is not well.
1 week, Your Honor, please.
At the request of learned counsel for the respondent
1 and 2, my lord.
1 and 2, suggest that arguing counsel is not feeling well. Use this matter next week.
10th or 11th, my lord, my request, humble request.
10th,
Please.
yes.
Page number 12, serial number 57 to 64. Page number 13, serial number 65 to 68. Page number 14, serial number 69. List number 1 for preliminary hearing.
ಅದ್ಯಾಕ್ರಿ RFA ಗಿರಫೆಗಳನ್ನ ಹಾಕಿದ್ದಾರೆ, ಅವೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿರುತ್ತೆ. ಓನ್ಲಿ RP ಹ್ಯಾಸ್ ಟು ಪೋಸ್ಟ್. ಇವೆಲ್ಲ ಎಲ್ಲಿದ್ದಾವ್ರಿ? ಅವೆಲ್ಲ ಮುಗ್ದೋಗಿರೋ ಕೇಸ್ಗಳನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರು. ಲಾಸ್ಟ್ ವೀಕ್ ಇದ್ದಿದ್ದು ಈ ವೀಕ್ ಹೆಂಗ್ರಿ ಬರ್ತದೆ? ಇವು RPಗಳು ಹಳೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದವ್ರಿ. ಇನ್ನೊಂದು RP ಅದು ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರ ಜೊತೆಗೆಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. ಎಸ್.
List number 1 for preliminary hearing, serial number 1, Chetan Desai for petitioner.
Lordship, the appellant, the petitioner is seeking a mandamus, your lordship. The petitioner had filed an IA under Order 39, Rule 1 and 2, and it came to be heard and resolved for orders on 5/9/2024. And since then, about 8 dates have been given, and no orders has been passed.
No, the suit for
partition and separate position. And suit is for the year of 2024, and issues are still not yet been framed. And IA orders on IA is
No,
pending.
you are the plaintiff.
I am the defendant, one of the defendant. And
Who
I
has
had filed an IA seeking an interim order against the other defendants who have taking advantage of their name in the revenue records, are trying to sell the property. And hence I filed an IA to restraining them seeking a temporary injunction, restraining them from alienating the property and creating a third party interest. And that IA came to be heard on 27/8/2024. And it been, since then, it has been 8 dates have been passed.
No, where is your application?
For my application is at page number. Suit for partition in separate position. My IA is at page number 18, your lordship.
Yes.
Page number 18.
Where is that order sheet?
Order sheet is at, the typed copy is at the relevant page, your lordship, wherein the order came to be resolved.
Yes.
He is at page number 60, your lordship.
60.
60. Sir,
Yes, when it
62,
is
62, 62, Your Lordship, 62 at the bottom end. Heard for orders call on 5/9/2024.
62
Page
date
16. Date 27/8/2024.
27/8/2020, definite number
Right,
3.
right. Last.
Which IA you have filed? IA number?
IA number 4, Your Lordship.
Early the IA number 4 mele. IA number 5 under section along with the so and so plaintiff records. 27/8/2024 IA number 4 mele elide.
ಅದು hearing ಅಂತ ಅಷ್ಟೇ ಮಾಡಿದ್ರು.
Huh?
Hearing, Lordship, it may be found at page number, Your Lordship, previous page, 60 page, Your Lordship.
60.
In the top corner, Your Lordship, learned counsel for D2, D25 filed IA number 4 under order 39 rule 1 and 2 read with section 151 of CPC. For objection on IA. And it came to be heard and orders came to be reserved on 5/9/2024. Your Lordship.
5/9. ಎಲ್ಲಿದೆ 5/9 ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ವಾ?
5/9 order sheet. 62 and 63 is the 5/9, same order sheet.
61, 62, 5/9 ಅಲ್ಲಿ ಇದೆ ರೀ. 22/11. ಓ ಇದು ರಿವರ್ಸ್ ಆರ್ಡರ್ ಶೀಟ್. 5/9
Yes, Your Lordship.
62 ಅಲ್ಲಿ. ಇದೆ 5/9 ಅಲ್ಲಿ ಇದೆ ರೀ. 22/8 ಇದೆ. 27/8. 8/12. 22/9. 17/8. ಆಮೇಲೆ 6 ಇದೆ. 9 ಅಲ್ಲಿ ಇದೆ. Where is that, Mr.? In this writ petition is filed by. This writ petition is filed by defendant number 25, seeking direction to the trial court to dispose of IA number 4 already, IA number 5 antira. Prayer IA number 4 ಅಂತ ಹೇಳಿದೆ.
ತಪ್ಪಾಗಿದೆ Your Lordship. IA number 4, Your Lordship, at page number 45.
4 or 5 correct ಹೇಳಿ.
4, Your Lordship.
IA number 4 filed under order 39 rule 1 and 2 for temporary injunction in OS number 977 of 2014. Seeking direction to dispose of that IA number 4 filed under order 39 rule 1 and 2 in OS number 977 of 2014. In view of the above, issue notice to the respondent is not necessary. Plaintiff has filed in a suit for partition and separate position. During the pendency of the suit, defendant number 25, petitioner defendant number 25 has filed an IA number 4 under order 39 rule 1 and 2 for temporary injunction. Learned counsel appearing for the petitioner has submitted that IA filed on.
IA came to be filed on.
Filed on 19/3/2023. Same was heard and reserved for orders. Even today, the order is not passed on that IA. Therefore, he sought for seeking a direction to dispose of that IA. In view of the above, without expressing any opinion on the merit of the case, trial court is directed to dispose of that IA number 4 filed by petitioner defendant number 25 under order 39 rule 1 and 2 as expeditiously as possible, not later than end of February 2024. 25. Yes.
Please, Lordship, suit may be disposed as expeditiously as possible.
First INA dispose agdan 6 ತಿಂಗಳಾಗಿದೆ ನಿಮ್ ಸೂಟ್.
2014 matter.
Yes, ಬರ್ಲಿ.
Serial number 2, Rajeshwara PN for petitioner, CM Kempegowda.
RPO for the petitioner.
Yes,
The defendants with petition, my lord.
yes.
Plaintiff has filed suit for declaration and consequential relief of permanent injunction, my lord. Filed an application for temporary injunction. The plaintiff is claiming rights only based on the revenue entries, my lord. Injunction is granted based on the revenue entries, my lord. Whereas defendants, my lord, defendant number 2 to 6 are claiming their rights under a registered sale deed in the year 1947, my lord. The total extent is 30 guntas, my lord. Defendant number 2 to 6 are claiming 15 guntas. Defendant number 1, my lords, is claiming 15 guntas, that is ancestral property, my lords. Defendants are in possession of the property, my lords. What happened is, my lords,
What is that order you are challenging?
Annexure A and B, my lords. Annexure B is the injunction order granted by the Honorable Trial Court, my lords.
What is that injunction order granted?
Restraining the defendants from interfering with the possession of the property.
Yes.
It starts at page number.
Now, during the pendency of the appeal before that appellate court, you have any?
No, my lords, what happened, my lords, although the order is in favor of the plaintiff, my lords, but when it comes to the operative portion of the order, my lords, it is written as the IA is dismissed, my lords.
Where?
Uh,
By which court?
by your trial court, my lords, page number 53, my lords.
53.
Page number 53. IA filed with the plaintiffs under order 39 rule 1 and 2 read with section 151 of CPC is hereby dismissed. But
No, you are a plaintiff or a defendant?
I am defending, my lords.
No, IA is dismissed. Then
No, my lords, the findings are in favor of the plaintiff, my lords. It is only the typographical error that has crept in, my lords.
no, why you are saying that it is typographical error? Have they corrected it?
The plaintiff preferred MA, my lords.
They have filed an MA.
MA, that is order annexure A, my lords. In the order at annexure A, my lords, Honorable First Appellate Court holds that it is only the typographical error, and the Honorable Trial Court has made findings in favor of the plaintiff and sets aside the OS order and allows the appeal.
Yes, heard.
And I,
Issue notice.
but they are in caveat, my lords, I'll serve the caveat copy.
Who is the
Respondent, Kempe.
parties are directed to maintain status quo in respect of, what is that property, madam?
My lords, it is agricultural property. They are running their alemane, my lords, so Jaggery units. Now it is season, my lords.
Parties are directed to maintain status quo in respect of suit property till next date of reference.
Serial number 3,
I
Sachin
is
PS.
permitted to carry out the agricultural unit.
Whatever status quo in respect of possession, that's all.
ನಾವು ಕಟಾವ್ ಮಾಡ್ಬಿಟ್ಟು ಆಲೆ ಮನೆ ನಡೆಸ್ತಾ ಇದ್ವಿ. ನಿನ್ನೆ ಬಂದು ಗಲಾಟೆ ಮಾಡಿ ಕಾರದ ಕೂಡಿ ಕೂಡ ಹೆಚ್ಚಿದ್ದಾರೆ. ಇವಾಗ ಸ್ಟೇಟಸ್ ಕೆಲಸ ಮಾಡಕ್ಕೂ ಬಿಡಲ್ಲ. ಅದು ಬಂದಿರೋ ಮೆಟೀರಿಯಲ್
No, you can see. I said status quo in respect of possession.
ಪೊಸಿಷನ್ ಅಂತ ಹೇಳಿ.
Status.
Carry out the.
No, that if you are there, you are doing, you do it. I am not giving any permission. Yes.
Please.
Serial number 3, Sachin PS.
Yes.
Page 17. The court has refused to grant me ex parte attachment order. Suit is for recovery of money for 1 crore and odd. Well, it's court has just issued a notice. Page 17 is the order to the extent of refusing to be granted an ex parte.
What is that ex
Attachment.
parte injunction order?
Well, it is not ex parte injunction, ex parte attachment before
Parte,
judgment.
Before judgment.
Order 38 rule 5, where it speaks that conditional attachment order can be passed. And in extraordinary situation, when suit is for recovery of money, 1 crore and odd. Now the defendant is trying to alienate the subject property, my lords.
Where is your
My-
affidavit?
Please, my lords, in a,
Affidavit along with that.
my lords, my application, my lords would find it at page number 35. My lords, I have specifically stated in the pleadings, page number 35 is the application. My lords, at page number 38 is the affidavit, my lords,
Have a nice day. Yes.
page number 39, my lords, I clearly spelled out saying that there is every likelihood of alienating the subject property.
Likelihood, is there any materials to show that he is alienating that?
My lords, all, because my lord, what had happened was that there are 3 schedules which sought to be attached, 2 coffee agriculture property and 1 is Mercedes-Benz car. Insofar as the Mercedes-Benz car, my lords, there is already wherein he has handed over the registration certificate, which my lords would find it at page number 21. Form number 29, 30 is already been issued. And in addition to this, my lords, Kerala High Court judgment, my lords, I have placed on record, that is page number 41. Now kindly see order 39, rule 5 of CPC.
Order 38.
Order 38, rule 5 of CPC, my lords.
Wait.
I'm sorry.
Yes.
My lords, I'm harping upon order 38, rule 5, subclause 3 provides for that.
Yes.
Subclause 3, I'm sorry, sir.
Yes, read.
My lords, order 38, rule 5, where defendants may called upon to furnish security for production of property, where at any stage of the suit, court is satisfied by an affidavit or otherwise that the defendant, with the intention to obstruct or delay the execution of any decree that may be passed against him, is about to dispose of the whole or any part of his property, is about to remove the whole or any part of his property from local limits of the jurisdiction of the court. The court may direct the defendants within the time to be fixed by the either to furnish security in such sum as may be specified in the order to produce and place at the disposal of the court. When required, the said property or the value of the same, such portion thereof may be sufficient to satisfy the decree or to appear and show cause why he should not furnish security. Next, the plaintiff shall, unless court otherwise direct, specify the property required to be attached and estimate the value thereof. Subclause 3, this would be relevant to my case is concerned. The court may also, in order, direct the conditional attachment of whole or any portion of the property so specified. Now, this provision is interpreted, my lords, Kerala High Court at page number 41 may be looked into. Kerala High Court judgment, page 41. My lords, got it, my lord?
Yes.
My lords, in that relevant para, page number 43 may be looked into, my lords. Page 43. Page 43, para number 7, my lords.
Yes.
My lords, got it? Page 43. The law also take notice of extraordinary situation where urgent or immediate action is deemed necessary. That is why sub-rule 3 of rule 5 provides that court may also direct the conditional attachment of property. There may be cases where the court is satisfied that if a court waits for the defendant to furnish security or to show cause, the property may disappear in meanwhile. In a such or similar circumstances, court is empowered to direct the conditional attachment. In other words, court can secure the attachment of the property pending furnishing security or appearance of defendants. Kindly mark this.
If court satisfied.
Yes, ma'am. Now, my lords, all that my lords, now having regard to the facts of the case is concerned, my lords, there was an agreement also entered by the defendant to owe the money for which he doesn't pay it.
What is the transaction?
My lords, transaction, my lords, he obtains the loan for business purpose for which he doesn't repay. To that extent, an agreement also is executed. Kindly see page number 27.
Financier.
Yes, since he is a friend, I had given him money, my lords. That is one thing. And in addition to that, check was also issued as a security, where I presented the check which was dishonored. This conduct which implies that, my lords, he is likely to alienate the subject property is concerned. Therefore, I immediately proceeded to attach the property. All that I am requesting, my lords, is to direct the parties to maintain status quo in respect of subject property. Let the trial court decide my application in accordance with law.
Now, where is that order of the trial court?
My lords, trial court, my lords would find it at page number 17.
Yes.
Court has just issued notice to the respondent. Page 17, my lords would find it, page number 17. The order is 6/1/2025.
What are the properties used?
My lords, property, my lords, there are 3 schedules which is sought to be attached. That is page number 35 may be looked into, my lords.
Yes.
Page 35.
Yes.
Schedule A consisting of agriculture property. Schedule B also is consisting of agriculture property. Schedule C is Mercedes-Benz.
Now that, what is that scheduled A? 1 acre, 35 extra?
Correct.
What
My
is
lords,
that?
I have stated that insofar as the schedule A, 1/2 undivided right, title and interest in respect of 1/2 undivided, my lords, kindly see my application, page 35. For the reasons stated in the accompanying affidavit, the petitioner prays this honorable court may please to pass an order of conditional attachment before judgment in respect of 1/4 right, title and interest of the immovable property described in the Schedule A below, one of undivided right and interest of Schedule B Coffee Estate, and and Mercedes-Benz in respect of Schedule C below of the defendant number 2 pending disposal of the suit, and pass an ex parte order of conditional attachment to the above said
What is
effect.
that amount which is due?
My lord, so amount due, my lord should find it page number 24, 1,12,13,425. My lords, kindly see, now in respect of Mercedes-Benz, my lords, he has also issued form number 29 and 30, defendant to the petitioner as a security. My lord should find it at page number 30, annexure D.
Yes, heard. Issue notice. Who is that respondent?
My lords, respondents are defendants, they are contesting matter, my lord. It's
Why
contest-
there are two?
My lords, different, father and son.
Both are taken that.
Yeah, my lords, the son borrows money and the father gives as a, these things, a surety.
The respondents are directed to maintain status quo in respect of petition scheduled property. Only in respect of their share is concerned.
Great.
Serial
In
number
state
4,
of hearing.
Shilpa Shah.
Milord, imprint order is at annexure A, milord. It starts at page 27.
Who are you? You are a
Milord, I am
judgment.
the judgment detainee.
What is that degree?
Milord, it was arbitral award.
Arbitral award.
Yes, milord.
Hmm.
And that enhancement compensation has been disbursed along with interest.
Hmm.
And then decree holder has approached executing court.
Hmm.
Milord, I request your lordship to look at page 34, milord.
Yes. Yes.
Page 34,
Hmm.
7th December 2024
Hmm.
order. Learned counsel for DHR and JDR present. Learned counsel for JDR submits that JDR has deposited the correct amount before this court, but on calculating the compensation amount as per the order of, it was paid even prior to filing execution, but court has said that deposited here, but on calculating the compensation amount as per the order of deputy commissioner is arbitrator.
Yes.
The DHR due in a sum of rupees 3,429,000, JDR is hereby directed to pay the said balance amount on the next date of hearing, failing which DHR is take necessary steps hence column.
Hmm.
Now, my lord, this just one date above 15/11, my lord.
Yes.
Learned counsel for DHR and JDR present. DHR has produced the clarification from the concerned authority and had filed same to the court. Learned counsel for JDR to properly calculate compensation. Now, I request your lordship to look at the this deputy commissioner's clarification.
Award. Yes.
Now, clarification, which they are, this is referred here in 7th
Yes, yes.
December.
Hmm.
That what DHR said, because they are saying they have paid, I will get it calculation from arbitrator himself.
Yes.
And he has produced that, that is annexure H, page 97, my lord. Last page, 97.
According to you, there is no due.
No due, my lord, no, we have calculated that for just few days, we have calculated 5,000 is due.
Yes.
5,000, and that calculation we have already produced before the court, that 5,000 is due. That calculation also I will just show to.
No,
This
yes, annexure H, what is this?
Annexure H, my lord, this is DHR approach arbitrator and said, give me calculation that how much they should pay. Then arbitrator has given calculation.
8 lakhs.
Comes to 8,66,094.
Hmm.
Now I request lordship to look at the payment voucher, how much we have paid. Page 68, my lord, annexure D, my lord.
Yes.
Page 66. 8,89,000, last column, my lord, in that one tabular.
68,
my lord.
Yes. Hmm.
That is
8
one
lakhs,
table.
89,700.
Yes. Which we have paid more than what this is calculation is.
No, through what you have paid it?
No, we paid directly to her bank account, my lord.
By cash or their
Her bank account.
bank account?
Yes, my lord, RTGS.
RTGS.
Yes,
You
my
have produced any documents to show that the amount has?
My lord, and there is no dispute about it. There is no dispute about it.
Then how can they claim excess then?
That is what, and like, and court also is saying that court is looking at these two documents. And then court is saying 7th December, page 34, my lord.
Yes.
Learned counsel for JDR submits that JDR has deposited a correct amount before this, but on calculating the compensation amount, as per the order of deputy commissioner, the DHR due in a sum of rupees 3,429,000.
How they have come to this?
That is what the DHR is asking, and she is saying that without any reason, without any, I mean, it's very clear, just from looking at these two numbers, that we
Yes.
have paid more than what Deputy Commissioner, and she is
How
relying upon
issue
Deputy Commissioner's order.
stay of? What is that you are seeking?
Lord, stay
Yeah.
of proceedings in execution 90 of 2020
90 of 2023,
pending before.
pending in the file of first additional district and session judge Kolar till next date of it.
Obliged.
Serial number 5, KV Narasimhan for petitioner.
Yes. Yes.
Yes, my lord. The interpretation is on the word, any person, my lord, that has been employed in the said.
No, I have
provision.
seen that judgment which,
Yes, my lord.
yes.
I'm citing 3 judgments.
No, that judgment which have told you have
ಇಲ್ಲ, ಅದ್ ಯಾವ್ದು ಗೊತ್ತಾಗಿಲ್ಲ.
gone through.
From Srinath Asgar and my lord Jini.
Hmm.
3 judgments, my lord, I'm citing.
Hmm.
There, my lord, the interpretation is on the word, any person that has been employed in Order 21 Rule 97.
And then table ಮೇಲೆ. Where is that? Table ಮೇಲೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಮನೆಯಿಂದ ತಂದಿದ್ದು. Supreme Court judgment. Yes, what is
My lord,
that?
the first judgment, my lord, Srinath judgment.
Hmm.
There, I request my lord to kindly take page number 5, my lord.
Hmm.
Ali, the any person until that it starts. This may be the first
Page
paragraph.
number?
Page number 5, my lord. Page numbers are written at bottom.
Why-
5 of.
Yes,
This may be, that's how, my lord, it starts with.
yes, 5.
This may
Para?
be,
Para?
my lord, para 8, my lord, commences from the previous page.
Yes, yes.
It is the continuation of
yes.
that paragraph. Yes, my lord. This may be either by the person bound by the decree, claiming title through judgment debtor, or claiming independent right of his own, including tenant, not party to the suit, or even a stranger. A decree holder in such a case may make an application to the executing court, complaining such resistance for delivery of possession of the property. Subclause 2 after 1976 substitution empowers the executing courts when such claim is made to proceed to adjudicate upon the claimants upon the applicant's claim in accordance with the provisions contained herein after.
No, any person.
Yes, my lord.
ಕೊಡಿ ಅದು ಇದು ಕೊಡಿ. CTC ಕೊಡ್ರಿ. CTC ಕೊಡ್ರಿ. Order 21 rule next.
Ali, we find the expression anta barutte, my lord.
No, execution of the degree
Yes,
by any person.
yes.
Executing of the degree by any person, not
Ala-
by that.
No, the obstruction by any person, my lord. 97-1, my lord. Where the holder of a decree for possession of immovable property or the purchaser of any such property sold in execution
wait.
of, pardon.
Yes. Where
Where-
that holder of the degree.
Please, my lord, for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person
Hmm.
in obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction.
Who has to make an application?
That is what, my lord, is stated in the next in the preceding lines.
Where that holder of the degree for the possession of the immovable property
Please, my lord,
or that purchaser of such property sold in execution of the degree
please.
is resisted or obstructed by any person.
Yes, my lord, please.
See, this is an obstruction to that degree holder
Yes,
by any person.
yes,
In obtaining the possession of the property,
please.
he make an application to that court compelling of such an resistance or obstruction.
Yes.
Who has to make?
Now, this is,
Degree holder has to make to show that somebody has been obstructed. That is what that meaning.
that is what the apex court, my lord, interpreted and said. And in fact, the word used is, no wonder it starts with this preposition. But an overall understanding would mean that the claims of the stranger as well as the decree holder are to be adjudicated under Order 21, Rule 97.
No,
That's the
here-
interpretation that is given.
See, if degree holder,
Please.
not only against the judgment debtor,
Yes, my lord.
any person is obstructed or restrained, he can file an application, but there is no power for you to file an
No,
application.
that's what, my lord, was the plain reading of the statute.
Hmm.
That is where, my lord, in all the 3 judgments, my lord, the interpretation that is placed is,
No, the applicants are whom? They are the strangers.
they are
Or
the
the degree
strangers.
holder.
They are the strangers. They make an application, my lord.
Now you read that any person
Yes, my lord.
that may either by the persons bound by the degree claiming the title through the judgment debtor,
Or claiming independent right of his own,
his
including
own,
the tenant.
include the tenant, not a party to the suit, even a stranger,
Stranger.
degree order in such a case may make an application.
Yes,
May make
madam.
an application.
Yes.
Yes. Now
That
what is
is-
this?
Now, what has happened now?
But anyhow that you just take out this,
Yes, my lord.
civil appeal number
Yes, my lord.
4649 of 2022, 6th July 2022.
Yes, my lord.
Just go through that also.
Yes, my lord.
Yes, now what is this case?
Lord, what has happened here is a money recovery suit, my lord, was filed
Hmm.
against my vendor.
Yes,
The suit, my lord, is decreed.
yes,
The suit, my lord, came to be decreed for a sum of rupees 3,71,390 with interest.
yes.
Thereafter, execution, my lord, is sued out. Now, my property, my lord, which has been agreed to be sold in my favor, which is subject matter of a specific performance suit, was sought to be, my lord, sold in the execution for recovery of the amount.
Yes.
That is where I make this application.
Yes,
And all that I am saying is, I will pay the amount on behalf of the judgment debtor.
Pay that.
I am ready to pay the amount. So I wanted an entry into the execution. So Order 21, Rule 97, along with which, my lord, application has been filed under Order 21, Rule 59B to defer the sale or to cancel the sale.
Your application is dismissed.
My application is dismissed because I did not say this before the executing court that I am prepared to pay the amount. I only said that I have already filed this.
Application for making in a party has been dismissed. Why?
It has not been dismissed. Order 21 Rule 97 is still pending. Order 21 Rule 59, my lord, is what I filed for cancellation of the sale deed on the ground that there is a suit that I have filed and it is for specific
And
performance.
if you are going to comply that, there could have been.
My lord, that is where I'm making a submission, my lord. Now, the due, my lord, is 3,50,000 is the due.
3,50,000.
50,000. I'll deposit, my lord, 50% now and 50% immediately after they come before this honorable court. And I give an undertaking before this
So
court
you
that
deposit entire amount.
sure, Allah adjust ಮಾಡ್ಕೊಂಡು my lord, out of 3,50,000, my lord, 2,50,000 I'll pay now within a week's time.
Yes.
Balance, my lord, immediately after they come, my lord, I'll pay it.
Third, issue notice. Stay of further proceedings in execution number 96 of 2009, pending in the file of civil judge JMFC Pandapura till next date of hearing, subject to condition. Petitioner has to deposit how much you are?
2,50,000 I'll deposit
2,50,000 before this court. When?
within 10 days time, my lord, I'll deposit.
On or before 7th
Please.
February.
Yes, my lord.
Yes.
Grateful. Lord, hand delivery.
Yes.
Serial number 6, VB Shivakumar.
Suit for injunction. Defendant files an application for appointment of a commissioner.
Wait. Yes.
Now, the property is a site
Yes.
with a constructed building.
Hmm.
There was an interference from the defendant, therefore, the plaintiff petitioner filed the suit for injunction.
Hmm.
But the trial is yet to complete.
Hmm.
The learned judge goes to the extent of saying, conducting inspection, etc. and all that. But that is impermissible until trial is concluded. Application for commissioner ought not have been.
No, that law is changed now. Now that
Even then.
now it can be appointed at any stage.
No, that is one aspect,
Hmm.
not on that. Kindly look at the plain.
Yes.
Plain at page 42 is the schedule.
Yes.
House in site number 50.
Hmm.
Out of converted survey number 8/4, 8/7,
Hmm.
Kanigara Palia, Hosanli village, Uttaradi Kopi.
Hmm.
He is residing in that house. And there has been an interference. Now look at the application. Application that is filed
Hmm.
is at page 24.
Yes.
Item, identification of the suit schedule item lies in 8/5 or 8/7, same is to be considered. That's what is his application. Now, could the house which is in existence for more than 30 years could this application now be sought to be filed?
No, he can find out that whether he is in residing there or not. That is what that latest,
That I have
Have you-
produced the documents to show.
no, even court cannot see that it is for a collection of evidence, it has to be appointed. You just see that latest judgment. ILR 2023 Karnataka 3983.
Virupakshas.
Not Virupakshas. Justice Anant Hegde's judgment, latest judgment.
Yes.
Not, yes, there they said at any stage it can be appointed. Even that it is for a collection of evidence, it can be appointed if court wants to see that it will assist for the court to disposing of the matter. That is what that now,
Even if the written statement is looked into, he does not dispute all those aspects.
yes, then how it will cause any harms to you? Let it be there.
Should a permanent injunction suit, where I have proved my case insofar as house constructed, everything is done. Should all this be done, even?
No, that's what court said. It can save the court time giving an all evidence to prove that. Instead of that, get in a commissioner report. Have you read that judgment?
No, I have not read that.
You want to go through that? You see that?
Let me have a day after.
Then guidelines has been issued to that trial court and all. Now that they have no other options when there is an high court directions and all. Yes. Who is this matter next week? Yes.
Serial number 7, Pradeep Naik K.
I am for the petitioner, my lord.
Yes.
An impleading application has been filed in a suit for partition, which came to be dismissed against this, the present petition is
Suit for
filed.
partition. Who are you?
Partition. I am the agreement holder. The suit schedule property item number 1 is a self-occupied property left by one NLN Murthy.
Come to that plain. Page 18.
Page
Yes. Who is the plaintiff? Page 18. 18 is the plaint.
Yes, my lord.
Yes, who is the plaintiff?
Plaintiff is the father of one CH-11 Murthy.
Defendant number 1 is that son.
Son.
2 and 3.
2 and 3, wife and the children of the deceased NLN
Yes.
Murthy.
Son has filed a suit
The
against
father has filed a suit against
son.
Daughter-in-law and grandchildren and daughter.
Daughter-in-law.
Partition.
Son was dead.
Son was dead.
Yes. Now you have purchased from whom?
Agreement has been, registered sale agreement has been executed by son during his lifetime.
Yes.
I filed a suit for specific for firm against the father and the daughter-in-law, wife. And
yes, what has happened to that suit?
that suit is pending. They entered appearance and filed the return statement.
Now that
They filed this
application, why it is rejected?
rejected only. Your lordship may kindly go to annexure A in page number 9, my lord.
Yes.
No reasons has been stated. Without, in the absence of the applicant also, the present suit can be disposed of since.
Yes, how issue
Only
notice.
the applicant.
Stay of further proceedings in OS number 5223 of 2020. Pending on the file of 6th Additional City Civil and Session Judge Bangalore till next date of hearing.
Much.
Serial number 8, Purna Chandra M. Puranik for petitioner, Prithvi Wadayar.
Lord, I may be permitted to appear for the petitioner,
Yes.
my lord.
Yes.
The last day,
My lord,
steps directed to give the copy of the appeal memo which they have filed before the assistant commissioner and
Yes, just give that brief facts. I forgot.
Lord, I'll explain your lordship.
Yes.
My lord, a suit for bearing, my lord, the scheduled property
Yes.
and many other properties
Yes.
belong to one Dasappa.
Yes.
My lord, he was holding a village office.
Yes.
My lord, on his death,
Yes.
my lord, he was survived by, my lord, 5 sons.
Yes.
The eldest son was Hanumant Rao,
Yes.
and the eldest son was Prahalad Rao,
Yes.
whose son is the present plaintiff. Now, my lord, your lordships are aware that the Village Office Abolition Act came into force in 1961. These lands in Shimoga, my lord, Shikharipura, they vested in the government in 1963. In 1975, there was a re-grant. The re-grant was made in favor of Prahalad Rao. He is the eldest son.
Yes.
Now, my lord, on his death, the plaintiff, my lord, files a suit for bare injunction against his cousin, that means father's brother's son, and says that I am a co-owner of the property. This is the allegation made in the plaint. I am a co-owner of the property. I am in joint possession. There was a partition that took place in 1965. Defendant is trying to interfere with my possession. Therefore, please grant me injunction.
Who are you? You are also that cousins.
Yes, my father and his father
is the
are
brother.
brothers,
Yes.
full brothers.
Yes.
Now, my lord, three things are there. The trial court, my lord, rejects the application for injunction on the ground, on 4 grounds, my lord. The first ground is that assuming for the sake of argument that there was a partition that took place in 1965, that 1965 partition, which is the document now that is sought to be produced, because in the appeal filed in the revenue proceedings before the assistant commissioner, I have said to have admitted that there was a partition in 65, that is considered by both the courts below. The trial court says in 1965, such a partition could not have taken place for the reason that
It is not yet re-granted.
it had not been re-granted. So between 63 and 75, nothing could have taken place. One. Second, the trial court says, since the plaintiff himself says that he is a co-owner, and he also says that the defendant is in joint possession, question of obtaining an injunction against a co-owner does not arise.
Yes.
The third reason that is given is there is a cloud as far as the title of the plaintiff is concerned. If you are claiming exclusive right, but still asking for injunction, you should really ask for a declaration, is the third. The fourth reason that is assigned by the court below is that plaintiff has brother and sisters. So even if Prahalad Rao died intestate, there are 4 sharers, they are all siblings. He is not filing the suit in a representative capacity.
Yes.
Therefore, the trial court says, in the light of all this disputed facts, trial has to be conducted, and therefore rejects the application, my lord, by the reasoned order. That is interfered with by the first appellate court, substituting its own reasoning, which, my lord, in my respectful submission, several judgments, my lord.
Yes.
My lord, there are
that parties are directed to maintain status quo.
your lordship may set aside and say status quo to be, and your lordship sees that adjoining land ideyala idakke, this is 38/2 old 38/1, 34/1 pakkad land ide. I have purchased that land, my lord, way back in my lord, and in dash in 1997, and in the schedule to that it says nimde aasti antane bardidaralli. So I mean, I'm not getting into all that, my lord. It is a case in which parties should be directed to maintain status quo. The appellate court order has to go. Please look at, my lord, the plaint for a minute.
That will decide later. Now that will grant the status quo to be maintained.
But what will happen is, my lord, what will happen is, my lord, I have already put borewells on the land. Way back in 1999, I have got electricity connection. All that is there. Now he is trying to, my lord, on the basis of the appellate court order, trying to interfere and.
We'll say that status quo as that today. Now that appellate court order cannot be implemented when I have granted an
Therefore, your lordship may, my lord, may I just point out just a minute, my lord, please look at the plaint at 88 for a minute.
Yes.
Plaint at 88. First paragraph itself.
Yes.
The plaintiff is one of the co-owners in possession of the immovable property. Page 88, plaint.
Yes.
My lord gets that?
Yes.
The plaintiff is one of the co-owners in possession of the immovable property, namely so-and-so, so-and-so.
Yes.
Then, my lord, please look at paragraph number 9 at 90. The plaintiff submits that the plaintiff's father was in possession and enjoyment, and after the plaintiff is jointly in peaceful possession of the scheduled property without any interference, anybody, including the defendant. Plaintiff submits the defendant is the cousin brother, has his own land adjacent to the plaintiff's land.
Which paragraph?
Paragraph 10.
Yes.
Plaintiff submits that the defendant is his cousin brother of plaintiff and has his own land adjacent to plaintiff's land. As said above, defendant or father had not even interfered with the plaintiff's joint possession over the land after partition, and both families were in great cordial relationship. Defendant, when in need, also supplied water to the plaintiff's land for adjacent land, etc., etc. Now, my lord, in the written statement,
No, that's all. You maintain status quo as on today. You will hear.
I'll make a submission.
Yes.
Day before yesterday, your lordship.
Please have a look at the trial court order at 146.
Yes.
It starts at 133. Just have a look at 146 for a minute, my lord.
No, that's what that, now that both of them cannot be claimed injunction against each because it's a co-owner. Now that status quo, that means to say, in respect of that joint family properties, whatever that position is there, it has to be there till that partition has to be taken place or that title has to be decided. Maintain status quo. Yes.
Your lordships kindly turn to the written statement at page 111, 111.
Yes.
Written statement. Kindly see the claim made by the defendant. Para 34, your lordship.
Yes.
The defendant most respectfully submit that the land in survey number 38/2 was standing in the name of father of defendant, late Hanmanta Rao, under MR number so and so. Subsequently, in the Jubani partition in the family made in the year 1950, for convenient enjoyment of the properties, the kata and mutation in respect of survey number 38/1 was made out in the name of late Prahlad Rao under MR number 1/6667. The shoot schedule property was one of the joint family properties of the father of plaintiff and father of defendant. They were enjoying the said property as one of their joint family property. Only for the purpose of convenience of cultivation, the kata and mutation in respect of the
That is what that, see,
I will come to, I will answer every questions which your lordships are posing, your lordship. To be made out in the name of father of plaintiff and regrant was made in his name on the basis of revenue interest thereof. The suit schedule property is one of the joint family properties and there is no partition as such affected in respect of the suit schedule property.
yes, how this will helpful to you?
The defendant is also one of
Kindly
the
see
co-owners.
kindly see next
Tell
paragraph.
you that,
Your lordship, kindly see next paragraph.
yes.
At one breath, the defendant admits that there was a partition, for whatever means, it for convenience sake or for any purpose, there was a partition. And also in the written statement, he has specifically admitted that cultivation also, he has mentioned the word cultivation.
No, cultivation in jointly.
Your lordship, kindly, no, your lordship.
For enjoying that said property as one of their joint family properties for the purpose of
next, you will
transaction and all,
only
kata
for
has been given to you. That is
only
what-
for the
that is what that in joint family property, kata will be stands in that one of the members. Then others are enjoying, but show me that you are in that position and you are enjoying.
Your lordships, kindly turn to next paragraph, paragraph 36.
Yes.
As a grant order was made in name of father of plaintiff and kata was standing in his name, the father of plaintiff
Yes.
had agreed to relinquish and his right over the suit schedule property in favor of the defendant and who was a co-owner thereof. The father of plaintiff had agreed to relinquish his right in respect of suit schedule property in favor of the defendant for a total consideration amount of ₹6,000 and had delivered the entire possession of the suit schedule property to the defendant and put him in possession of the said property as the absolute owner thereof in the year 1993 itself. Your lordship, kindly skip 37 and now even 37 also. At that time, the father of plaintiff had received a sum of ₹2,000 by way of advance amount. Subsequently, on 20/11/1994, the father of plaintiff had received the remaining balance consideration amount of ₹4,000 from the defendant. He had also received a sum of ₹3,000 towards the amount agreed to be paid in respect of relinquishment of right in respect.
ಅಷ್ಟೇ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ.
ಹೇಳ್ತಾರೆ.
93 ಅಲ್ಲಿ you have given a position ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದಕ್ಕೆ ನಾನು
Therefore, now there is a dispute.
Your lordship,
You maintain status quo.
ಅಲ್ಲ ನಾನು ಮೊನ್ನೆ ಅದಕ್ಕೆ ತಮಗೆ ಪ್ಯಾರಾಗ್ರಾಫ್ 16 ಆಫ್ ದಿ ಲೋವರ್ ಅಪ್ಲೈಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಓದಿದಾಗ ತಾವು ಅಪೀಲ್ ಮೆಮೊ ಕೊಡು ಯಾಕಾಗಿ ಅಂತಂದ್ರೆ ಇಫ್ ದಿ ಲೋವರ್ ಅಪ್ಲೈಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟೆಡ್ ಸಮ್ ಪೋರ್ಷನ್ ಆಫ್ ದಿ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಮೇಡ್ ಇನ್ ದಿ ಅಪೀಲ್ ಮೆಮೊ then I will grant entire stay or else.
Where is that? What is that lawyer appellate court?
40, your lordship, page 40.
Page 14.
40. Paragraph 16.
Yes.
As contended by the parties.
Yes.
Your lordship, the defendant number 1, Sri Vijayendra, preferred an appeal before the Assistant Commissioner of Sagar questioning the validity of mutation entry in favor of plaintiff and other legal heirs of Sri late Prahlad Rao in said appeal. The defendant number 1 has contended that there was a partition in the year 1966, 67, 68. In the said partition, the plaintiff's father, the defendant's father, and other legal heirs of late Shri Dasappa has got the specific share in the family partition. The relevant portion of statement is as under. ಮೇಲ್ಮನವಿದಾರರು ಮತ್ತು 2ರಿಂದ 5ನೇ ಎದುರುದಾರರು ಸಂಬಂಧದಲ್ಲಿ ದಾಯವಾದಿಗಳಾಗಿರ್ತಾರೆ.
ಮೂಲತಃ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಮೇಲ್ಮನವಿದಾರರ ಹಾಗೂ 3ರಿಂದ 6ನೇ ಎದುರುದಾರರ ಅಜ್ಜನಾದ ದಾಸಪ್ಪ ಇವರಿಗೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿದ್ದು, ದಾಸಪ್ಪನವರ ಪೌತಿ ಸಬೂಬು ಮೇರೆಗೆ ಅವರ ಹಿರಿಯ ಮಗನಾದ ಈ ಮೇಲ್ಮನವಿದಾರರ ತಂದೆ ಹನುಮಂತರಾವ್ ಹೆಸರಿಗೆ ಸದರಿ ಸ್ವತ್ತಿನ ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು MR ಸೋ ಅಂಡ್ ಸೋ ರಂತೆ ಬದಲಾವಣೆ ಮಾಡಲಾಗಿತ್ತು. 1967-68ರಲ್ಲಿನ ಮೇಲ್ಮನವಿದಾರರ ತಂದೆ ಹನುಮಂತರಾವ್ ಬಿನ್ ದಾಸಪ್ಪ ಮತ್ತು ದಿವಂಗತ ದಾಸಪ್ಪನವರ ಇತರೆ ವಾರಸುದಾರರಾದ MD ರಾಘವೇಂದ್ರ ರಾವ್, MD ಶ್ರೀಧರ್ ರಾವ್ ಮತ್ತು ರಂಗೂಬಾಯಿಯವರ ನಡುವೆ ಒಟ್ಟು ಕುಟುಂಬದ ಸ್ವತ್ತುಗಳನ್ನು ಜುಬಾನಿ ಹಿಸ್ಸೆಯ ಮೂಲಕ ವಿಂಗಡಣೆ ಮಾಡಿ ಹಂಚಿಕೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಈ ಜುಬಾನಿ ಹಿಸ್ಸೆಯಂತೆ ಮೇಲ್ಕಂಡ ಒಟ್ಟು ಕುಟುಂಬಕ್ಕೆ ಸೇರಿದ ಮಾಳೂರು ಗ್ರಾಮದ ಮತ್ತು ಬಿಳಿಕಿ ಗ್ರಾಮದ ವಿವಿಧ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿನ ಕೃಷಿ ಸ್ವತ್ತುಗಳೊಂದಿಗೆ ಮೇಲ್ಕಂಡ ಮಾಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ವಿಸ್ತೀರ್ಣ ಸ್ವತ್ತು 2ರಿಂದ 5ನೇ ಎದುರುದಾರರ ತಂದೆ ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಅವರಿಗೆ ಹಿಸ್ಸೆಯಾಗಿ ಬಂದಿದ್ದು, ಈ ಹಿಸ್ಸೆಯಂತೆ ಸದರಿ ಸ್ವತ್ತಿನ ಕಂದಾಯ ದಾಖಲೆಗಳು ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಬಿನ್ ದಾಸಪ್ಪನವರ ಹೆಸರಿಗೆ ಬದಲಾವಣೆಗೊಂಡಿದೆ. So Lordship, kindly turn to that appeal memo which I have now. This is the appeal memo, appeal filed by the defendant before the Assistant Commissioner challenging the mutation entry made in the favor of the plaintiffs. The mutation was changed way back in the year 1966-67 of subsequent to partition.
Want to show here.
Your Lordship,
What you have read in that,
not only that,
in the written statement.
No,
same
no.
They have stated.
here there is contradictory statement. Your Lordship, kindly see here.
Which is that paragraph?
ಪ್ರಕರಣದ ಸಂಕ್ಷಿಪ್ತ ಸಂಗತಿಗಳು ಅಂತಿದೆ.
No, page.
Second page ಇವರು appeal memo there.
Second page.
Second page. ಪ್ರಕರಣದ ಸಂಕ್ಷಿಪ್ತ ಸಂಗತಿಗಳು. ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಈಗ ನಾ ಏನ್ ಓದಿದ್ನಲ್ಲ ಅದು. ನೆಕ್ಸ್ಟ್ ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಮತ್ತು ಅವರ ಮಕ್ಕಳಾದ ಈ ಮೇಲ್ಮನವಿಯ 2 ಮತ್ತು 3ನೇ ಎದುರುದಾರರು 1994-95ನೇ ಸಾಲಿನಲ್ಲಿ ತಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ಸೇರಿದ ಸ್ವತ್ತುಗಳನ್ನು ಜುಬಾನಿ ಹಿಸ್ಸೆಯ ಮೂಲಕ ವಿಂಗಡಣೆ ಮಾಡಿ ಹಂಚಿಕೊಂಡಿದ್ದು, ಈ ಜುಬಾನಿ ಹಿಸ್ಸೆಯಂತೆ ಮಾಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 38/1 ಸ್ವತ್ತು ಖಾತೆದಾರರಾದ ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಬಿನ್ ದಾಸಪ್ಪನವರ ಹಿಸ್ಸೆಯಾಗಿ ವಿಂಗಡಣೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಮತ್ತು ಸದರಿ ಸ್ವತ್ತಿನ ಕಂದಾಯ ದಾಖಲೆಯು 2ರಿಂದ 5ನೇ ಎದುರುದಾರರ ತಂದೆ ಈ ಮೇಲ್ಮನವಿದಾರರ ಚಿಕ್ಕಪ್ಪನಾದ ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಹೆಸರಿನಲ್ಲಿ MR 12/94-95ರಂತೆ ಮುಂದುವರೆದಿರುತ್ತದೆ. 2ರಿಂದ 5ನೇ ಎದುರುದಾರರ ತಂದೆ ಪ್ರಹ್ಲಾದ್ ರಾವ್ ರವರು ತಮ್ಮ ಹಿಸ್ಸೆಗೆ ಬಂದ ಮಾಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ವಿಸ್ತೀರ್ಣ ಸ್ವತ್ತನ್ನು ತಮ್ಮ ಹಿರಿಯ ಸಹೋದರ ಹನುಮಂತರಾವ್ ಮಗನಾದ ಈ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ರೂ. ಮಾರಾಟ ಮಾಡಲು, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದೀಸ್ ವರ್ಡ್ಸ್, ಮಾರಾಟ ಮಾಡಲು ಒಪ್ಪಿ ಮುಂಗಡವಾಗಿ ಪಡೆದು ನಂತರ ದಿನಾಂಕ 20/11/94 ರೂ. 4,000 ಮೇಲ್ಮನವಿದಾರರಿಂದ ಪಡೆದುಕೊಂಡು ಹಣ ಸಂದಾಯದ ರಸೀದಿಯನ್ನು ಬರೆದುಕೊಟ್ಟಿರುತ್ತಾರೆ. ಆದರೆ ಈ ಬಗ್ಗೆ ಕಾನೂನುಬದ್ಧವಾದ ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರವನ್ನು ಈ ಮೇಲ್ಮನವಿದಾರರ ಹೆಸರಿಗೆ ಬರೆದುಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಅವರು ದಿನಾಂಕ 23/6/2000 ಮರಣ ಹೊಂದಿದ್ದು, ಅವರ ಮರಣ ನಂತರ ಪೌತಿ ಸಬೂಬು ಮೇರೆಗೆ ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ 38/1 ಸ್ವತ್ತಿನ ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು MR 9/2000 ಮತ್ತು 2001ರಂತೆ ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಅವರ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಕಮಲಮ್ಮ ಯಾನೆ ಪದ್ಮಾಬಾಯಿ ಅವರ ಹೆಸರಿಗೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಅದಕ್ಕೂ ಪೂರ್ವದಲ್ಲಿ, ಅಂದರೆ ದಿನಾಂಕ 97ರಂದು ಪ್ರಹ್ಲಾದ್ ರಾವ್ ಅವರು ಸಾಗುವಳಿ ಮಾಡದೆ ಖುಲ್ಲಾ ಬಿಟ್ಟಿದ್ದ ಸರ್ವೆ ನಂಬರ್ 38/1 ಸ್ವತ್ತನ್ನು ಈ ಮೇಲ್ಮನವಿದಾರರು ಅನಧಿಕೃತವಾಗಿ ಸ್ವಾಧೀನ ಹೊಂದಿ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ.
This is that both are claiming that cultivating. Here also they are that
ಕಲ್ಟಿವೇಶನ್ ಕ್ಲೈಮ್ ಮಾಡೋದು ಒಂದು, ಅವ್ರ ಇದು ಏನು ಅಂತ ಅಂದ್ರೆ ನಾನು ಹೆಂಗ್ ಪ್ರಾಪರ್ಟಿ ಬಂತು ಅನ್ನೋದನ್ನ ಯಾವ ರೀತಿ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
No, see, we are not deciding the title.
ಅಲ್ಲ, ಅದನ್ನ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
Now the dispute is concerned. See, they said that you are there, then you are agreed to sell, you are taken that advance amount, then you are given a possession. Now that only dispute is possession.
ಹಂಗಲ್ಲ, ಇಲ್ಲಿ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್ ಮತ್ತೆ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್
both of them claiming on that possession, showing the documents.
ಇದು ಎಲ್ಲಿವರೆಗೂ ಲೀಡ್ ಆಗ್ತಿದೆ ಈ ಸ್ಟೇಟಸ್ಗೂ ಅಂತ ತಮ್ಗಿದ್ದೆ. ಈ AC ಮುಂದೆ ಇವರು ಅಪೀಲ್ ಹಾಕ್ತಾರೆ, ಸ್ಟೇ ಕೊಡ್ತಾರೆ, ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡ್ತಾರೆ. ಅದ್ರ ಮೇಲೆ ನಾನು ಹೈಕೋರ್ಟಿಗೆ ಬಂದೆ, ಹೈಕೋರ್ಟ್ ಸ್ಟೇ ಕೊಡ್ಬೇಕಾದ್ರೆ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದೆ. I have given that copy also.
Where is that?
Along with that appeal memo.
That writ petition is pending.
That writ petition is pending.
Yes. then we'll post this matter along with that.
Yes, I think that will be best. my lord.
Yes, where there is an order,
Yes,
then
yes.
it will be in a conflicting that.
Yes.
ಅಲ್ಲ
yes.
ಹಂಗಲ್ಲ ಇದು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿರುತ್ತೆ ಅಲ್ಲಿ AC ಮುಂದಿರೋದು ಅಲ್ಲಿ ರೆವಿನ್ಯೂ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
No, no.
ಮುಂದೆ there is an order of this court in respect of the very same property. Let it be go
Yes.
before the, which is that writ petition.
No, he has just given. my lord. I have not yet received notice.
5352 of 2024.
Learned counsel for the party submitted that in respect of very same property, the writ petition number.
5352 of 2024.
Yes, call this matter along with that source. Let
My lord, status quo till then, my lord. Otherwise, it will become very difficult, my lord.
us see that we will call that matter.
My lord, status quo till then, your lordship may say, as on today.
No, we'll have it on Monday.
Monday, but Wednesday.
Wednesday. Yes.
Tuesday.
Is this matter on Tuesday?
Till number 9, M. Shiva Prakash.
My lord, could your lordship have Tuesday, my lord?
No, that, yeah. Yeah, which is that classification, Ray?
KLR.
KLR.
It's okay, there's a detailed order that is passed.
Yes.
Do you know about it or not?
Is this matter along with your so and so Wednesday?
Or
I thought
Thursday.
Monday,
Tuesday, I have some
Tuesday.
convenient.
Tuesday,
Tuesday, I will not be in station, your lordship. So
Wednesday.
Wednesday, yes.
Wednesday or Thursday.
No, Wednesday is fine.
I'm ready.
Wednesday, yes.
Till number 9, M. Shiva Prakash.
Yes, Shiv Prakash.
The matter arising out of in the execution proceeding,
Hmm.
the plaintiffs and defendants, there is a suit basically is for specific performance.
Yes.
Suit decreed in the, before the Humble Trial Court,
Hmm.
against which the defendant preferred an appeal in RFA before the Humble Court.
Hmm.
In the RFA, there is a joint memo filed by both the parties, my lord.
Hmm.
My lord will get it at Annexure A, page number 13.
Yes. Yes.
13, my lord. In page number 116, para 4, 5, 6 is important, my lord.
Yes.
Where in the para 4, it is both they have agreed that parties agreed to further dialogue and deliberations that plaintiff would pay additional sum of rupees 18 lakh to the defendant by way of deposit in the trial court within a time frame of 6 months.
Yes.
The defendant shall jointly execute the sale deed in favor of the plaintiff or his only son, Shri so and so, their nominee or so and so. Number 5.
Yes.
That the defendant further agree that they have no objection in plaintiff or his nominees to acquire right of the suit schedule C property from the appropriate authority.
Yes.
Authority is Government Revenue Department.
Yes.
Number 6 is that that there were some earlier litigation to which with respect to the schedule property regarding felling of tree, timber, etc.
Now, what is that you are challenging?
entitled along with the, now this order was passed on
Yes.
23/9/2010, my lord,
Yes.
before the sample court. Within 6 months, he shall deposit it. He did not deposit that amount. Till last day, again in the trial court, he went and deposited without notice to me.
Yes.
Then the trial court passed a detailed order, no, you have to go for execution court and you have to redress your remedy only in the execution. Now, the again decree holder has approached the executing court before itinerary court at Koppa.
Hmm.
My lord, may I kindly take my lord to the execution petition which he has filed. My lord will find it at page number 44, Annexure C2.
Forty-four.
44, my lord. My lord got it.
Yes.
Now, on one point, I am before the executing court, I objected this execution. Point is on limitation.
Yes.
From that's a date of decree in the before the Humble High Court is 13/4/2004. My lord, I have called out the date, the period. May I kindly pass out that?
Where is the limitation for filing an execution?
136. For a decree for execution, Article 136 is 12 years.
Yes.
May I kindly take the 136 provision, my lord?
Yes, put it. Limitation.
For the execution of any decree other than decree granting a mandatory injunction or order of any civil court 12 years.
Yes. Now that, what is that order passed by the trial court?
Now, I raised my objection on two grounds. One is 28(1) to rescind the contract as per the direction of the sample court has not complied in time. And second is on limitation. My objection, my lord, find it at page number is 59. 59 in the first, it's a first ground itself, that's item 3. The petition is barred by law of limitation and the relief claimed in the same cannot be granted in favor of the.
What is that order, Mr.?
Order, now the order, my lord, will get it at page number 72.
Yes.
Now, so far as on the application of 28 sub 1 for rescinding the contract, the court holds that on the last day he has paid it, 18 lakhs he has deposited it. So, the 28(1) may not apply. I cannot rescind the contract.
What about the?
I requested the Honorable Court to pass an order on the limitation. The Honorable Trial Court is silent on limitation. That's all the point.
For that main contention of judgment letter, that have you taken that contention in that application?
I've taken, my lord. That's what I want to.
Now the
Page number 59.
Now execution case is posted for what?
Execution case is posted for execution of the sale deed. Now, in respect of C schedule property, it's a Bagarukum land where he has undertaken that he will get a necessary.
Issue notice, say of further proceedings in execution petition 114 of 2022, pending in the file of senior civil judge CJM Innarpura, veterinary court at Koppa till next date of hearing.
Obliged, my lord.
Bill number 10, Kashinath JD.
Yes.
Preparing for petition. Suit for injunction, it's a plaintiff petition. The IA for ad interim injunction, my lord, has been rejected. And later on, my lord, the appeal is filed before the session, senior division. Same is confirmed. The grounds for, my lord, the dismissal. of
Suit for injunction.
Yes, my lord.
Yes.
The brief facts of the.
What is your sources of title?
Title is, my lord, I have purchased the property. That is not in dispute. We have constructed the engineering college, my lord, in the year 1980. And later on, my lord, the compound wall is constructed. And portion of the property is also acquired, my lord, for the widening of the national highway, Bangalore-Mysore National Highway. And later on, my lord, in the year 2021, Annexure D, my lord, for page 56. One, Shivkumar has submitted a complaint to the then ACP saying that I have encroached some portion of 5 guntas of the survey number 135. Based on that, my lord, the ACP has issued notice to the Tahsildar and ADLR, and voluntarily they have only called for a report from the ADLR. I have not issued with a notice to conduct any joint survey.
Yes.
And notice was issued, my lord, to remove the encroachment, that is compound wall, where the students are staying and boarding and lodging school is there, and more than 1,000 students are studying. Then I have submitted reply as per Annexure D1, my lord.
Yes.
Page 57. Thereafter, my lord, again, my lord, on page 60. On 11/11/2021, my lord, they have called upon some documents. I have submitted all the documents, license, sanction plan, everything. And thereafter, my lord, they came along with some men and material, my lord, to demolish the compound wall. Then I approached the trial court.
Yes.
Trial court has dismissed the IM loads.
Why?
On the ground, my lord, Annexure A, my lord, the order. Finding, my lord, at page 22 onwards.
Yes.
Page 23, my lord, is the relevant.
Yes.
In this case, the defendant number 4 is claiming the encroachment by plaintiff in the property of the defendant number 4. The plaintiff contending that it has not encroached the property of the defendant number 4 or any other property, being the reputed college having acquired the properties in peaceful possession and its own properties, and suit property is also one of them. When the question of encroachment is involved, detailed trial is required to ascertain the true facts. The plaintiff has filed this suit seeking relief of permanent injunction in the simpliciter. Therefore, the question of maintainability of the suit is also involved. This suit is filed by plaintiff seeking permanent injunction. The burden is on the plaintiff to prove its case. Detailed trial is required to come to the conclusion about the possession of the plaintiff. When otherwise the claiming about the encroachment of the plaintiff, both parties are required to undergo detailed trial and prove their contentions by leading cause and oral documentary evidence. At present, the plaintiff claiming temporary injunction order against the defendants from obstructing to its peaceful possession and enjoyment of the property. The plaintiff has filed the suit seeking relief of permanent injunction against the defendants. The prayer of the plaintiff in main suit and the interim relief are one and the same. That exactly the ground, my lord.
Injunction suit ಇನ್ನೇನ್ ಕೇಳ್ತಾರ್ರಿ main prior ಇದು. Then court has to decide whether prima facie case is made out. Here the court said that it has to be, yes, it has to be trial only. After trial only, finally it has to be decided.
Encroached 5 guntas is attached to 74/1, my lord.
See, that has to be decided now, whether it is maintainable, encroachment is there or not. The way now you are going to demolish, that shows that he is in the possession. That itself is enough for granting an injunction. Yes. Now that what is the position?
It's my lord, it is not at demolished. Change in the political color, my lord, they will. It is, my lord, one of the
Yes, you maintain status quo in respect of possession of the property as on today.
it is maintained, my lord, status quo. Compound wall is constructed in the year 1986, my lord.
Yes, parties are directed to. You will take notice, madam. Government advocate is directed to take notice for respondent number
1, 2, 3, 4, 5.
6 is that.
Yes, sir, I'll take it.
Yes, 1 to 5. Counsel for the petitioner is directed to serve 4 set of copies on government advocate. Issue amendment notice to respondent number 6. Parties are directed to maintain status quo in respect of petition scheduled property. The parties to directed to maintain status quo in respect of possession of petition scheduled property.
And structure, my lord.
That is what that. Position that they cannot be disturbed, that's all.
Yes.
Or parties are directed to maintain status quo in respect of petition scheduled property till next date of hearing.
Problem.
Yes.
Bill number 11, Raghunath MD for petitioner, Janardana G.
Here for the petitioner, please.
Yes.
Lord, an injunction suit is filed by the respondent against the petitioner herein on the ground that petitioner is trying to sublet the property.
Yes.
And he seeks an order of temporary injunctions in the first instance. Lord, after I have served summons, I enter appearance. On the day when I enter appearance, they file an application for seeking police protection. Lord, I file objections to that application. I sought some time to file written statement. The court insisted that I should argue the application for police protection, and I had to submit my arguments on that application.
No, that they have passed an ex parte injunction order.
Please, my lord.
I filed an application for vacating.
Subsequently, I filed written statement and objections to the application also.
Yes.
Without hearing those two applications, the court below allows the application for police protection. And by virtue of this order, my lord, I am not able to open the premises also. My lord, may kindly come to the order passed by the court below.
Where is that?
Please, my lord. At page 29, please.
Yes.
Page 29, Lord, 31, the order starts, please. Para 4. Heard the arguments of learned counsel, both the counsel's parties at length, and perused the materials on record. The learned counsel for plaintiff relied upon two decisions. I have bestowed my anxious consideration to the principles emerges from these respective decisions. In the light of above contention, the points that arise for my consideration are whether plaintiff has made out grounds to allow IA3 as sought for what order, affirmative and as for final order. On perusal of accompanying affidavit, objection and entire materials on record, the plaintiff has contended that the police have not taken any action on the order passed by this court. The defendant has contended that there is no sublet as alleged with the plaintiff. On perusal of materials on record, interim order on IA 1 and 2 are passed. In view of principles laid down in the judgments referred to above, and in the interest of justice and equity, it is
What is
just
that injunction order has been passed?
that I should not sublet the property and I should not put up any, I should not change the structure of the property.
Are you doing that?
I have filed the objection saying that I have not sublet the property. at
Then
all.
let that police, what the police will do then?
Lord, they are not allowing me to open the shop now because of this order. They contend that I have sublet the property. They contend that I am trying to change the nature of the building. If I go open the shop, they say that now there is police.
Yes,
protection
Mr.
order.
What is the difficulty for opening? He cannot
Kindly,
sublet.
Lord, I am submitting. But kindly see, Lord, she has already filed OS Lord, for injunction. He has already obtained the interim order of injunction against me. After the lease period is over, by filing OS 8313 of 2022, that order he has already obtained. But my client was in USA and he wanted to take advantage of the same, want to sublet the same. when he
That-
came to
that
know,
will restrict.
my lord, that is why. Now we came to know he is subletting the premises, kindly similar. I have a photograph, just have a look at, but how he is changing the entire premises and subletting to the some person who is
File a contempt.
kindly similar. That is why, my lord, I have kindly see that premises, he is subletting and entire changing the entire nature of the property and subletting. That is why, my lord, to protect my interest, but I also filed an eviction petition. Now today it is posted for my evidence. But he has raised some objection and my
No,
client has come.
See.
Yes. No.
You have an injunction not to
Yes.
change the nature.
Yes.
Not to sublet.
Yes. my lord.
If still he is doing,
Lord.
you have a remedy.
But that is why, my lord, that my lord, this court has said, while apart from that, my lord, I also could able to request the police to, my lord, implement the order. My lord, this court has taken a decision to that effect. So accordingly, the judge has done it. Now, two things, my lord.
No,
Now,
see,
yes.
police has to see.
But police have not come to the spot at all. They said, I have filed a complaint, but intimating the court order, but police never come to the spot saying that the matter is before the civil court. You adjudicate your rights in the civil court. They have not interfered. They have
Sorry.
let my learned friend file an
Excuse
affidavit
me, sir,
before
I
the
have
court
police,
that police have
phone
come and
recordings.
abducted him. Let
Police
us file an
called me.
affidavit, my lord. It is absolutely false statement.
You file
Yes.
an affidavit.
Yes.
Saying that you are not
Yes.
changing or altering that
Yes.
position, and you are also not alienating.
Yes. But
I
he is
cannot alienate, my lord.
but he is
I cannot
collecting.
alienate, I am only.
But he is collecting 50,000 rent by
Should not
subletting.
obstruct for that.
Yes.
Now, what is that in the shop?
Lord,
Not-
it's a
It was a
Hebar
condiment shop.
Hmm.
He was started with bakery business. There also my client has said quite because he wanted
Whatever
to.
that business.
Yes.
He is doing, let him do. He
Yes.
should not be.
Now kindly see, my lord, second photograph. What now? Kindly see that, my lord. Kindly see this photograph. Yes.
See,
Kindly
it-
see, this is subletting and giving to someone.
File a contempt.
And he, not that is one. Not precaution is better than cure. Not I want to stop.
No, we are
Prevent
saying
him from
that-
doing that.
No, even police protection, yes, rightly you are taken.
Yes.
But don't ask that police.
No, my lord, I am not asking the police to come and obstruct doing his business.
I will
My lord,
produce
what
the
I am telling is,
phone
he
recordings
cannot,
which the
my lord,
police
two
people
things.
have got
My lord,
us
he
and
has
bought us
sublet
to-
and collecting 50,000 rupees. He doesn't have a even business license to run the shop. And in spite of that, my lord, after the license has also been expired.
That injunction order.
My lord, OS 1813, my lord, he has.
No,
huh?
injunction order. is this.
Injunction order, my lord, not to sublet the premises. Not kindly see my learned friend's
I have
document,
produced an order.
annexure.
Annexure
I-
C,
Not-
what is served on me at page
Can you
17.
come to his writ petition, my lord? Just
No,
annexure.
we'll see that order,
Yes.
annexure C.
What is served to be.
I
is
request you all to kindly come to the agreement.
restraining
what
the
my lord-
defendant, his agents and servants from changing
Lord.
the nature of suit schedule property.
Kindly
Yeah.
come to his agreement, my lord. May I
No,
request?
I'm not on
Yes.
that.
Yes.
What is that injunction?
Not to sublet the premises and not to change nature of the property.
Where is that?
Lord, that order, my friend. has
No,
not,
I have filed objections. That application has to be
But I
considered.
place it
offense.
before the court, my lord. It is not.
Where is that?
my
This
friend
is
has
the
not
order.
brought it.
This is what is communicated to me by the court, please.
Training the defendant is agent servants from
Yes,
changing the nature of the suit scheduled property
yes,
till next date of hearing.
yes. And next one is not to sublet. There are two IS, my lord.
Yes,
Yes,
not to sublet and not to
Ah,
change that
yes,
nature of the.
yes.
Yes.
Lord, these are the there. Now, my lord, kindly see, come to the lease agreement.
Now
what-
I will
it is
record
a-
a statement that they are not obstructing for running the business
Yes, my lord.
by the defendant
But
in accordance. with-
Not by any other person, my lord. That is the
That is
thing.
what
my
that.
lord. Lord,
that-
kindly come to.
My
for a
lord,
moment.
if my learned friend says so, fine. I
Lord.
should not employ employees and
No, not
carry on
that.
the
No, but
business.
he can't. No,
It will
no.
be tough
he-
for me.
Lord, he is.
I will made it clear. It should be run by you
Please.
Yes.
and
Not by those persons who are all.
with law.
Lord, yes.
Yeah, because in accordance with law means it's covers license. and
Kindly
all.
come to the
If-
agreement, my lord. Kindly come to annexure, what my learned friend has produced, the lease agreement, registered lease agreement. Kindly come to for a moment, my lord. What he had done is like this. He want to take undue advantage of the same and he has produced the agreement. Kindly come to that agreement, my lord, for a
Page.
moment. Yes, that page. Annexure.
That lease to whom?
A lease agreement to someone.
Executed not by the
Yes.
respondent.
One,
but
I have
his mother.
stated, I have specifically stated one Riaz for whom he has let out, that board itself is showing blood, he was doing all sorts of
No, I
business.
will make it
Yes.
clear,
Yes.
except that if you wants to alienate
No, no.
or other than that, you can take in a police protection and implement.
And also trial court to be there to decide IA 1 and 2
But kindly come to
after
agreement
hearing me, please, my lord.
for a moment.
Because
my
without
lord,
hearing that,
Yes, that's all, mister.
I'll just 1 minute, no, I'll just.
Yes, I will
I'll
protect
agreement
your
one,
interest.
not annexure, But he has produced the.
Annexed A is the
Game,
lease agreement.
Mr.
Please agree.
Janardhan,
Yes.
even assuming that he is entering into that by alienating that property or creating third party interest, file in a contempt.
Not that I'll do it. Not now I am at the stage of protecting my property
No,
from
we are not
subletting.
saying that.
Kindly, not now.
I'm
Eviction.
saying that it
Yes.
has to be protected.
Not I'll do it. Not kindly come to para 5 minutes.
Why
Page
I
9.
have to see that?
No.
I will say interim order has to be protected by police,
Yes.
but in the guise of that interim order, don't obstruct for his.
Not what happened is the police, whenever we give a complaint, you go and manage with the police, and police, what they will do is, is the civil dispute is pending, go before the civil court. That is the stock answer.
In fact,
they
it
are
is
having.
contrary.
That-
They are
that's-
threatening me not to
All
open.
that I can, you go and agitate that.
Not I am already, I already filed an
No,
eviction
issue
petition.
which is not before me, why you are all arguing that?
Kindly come to page 9, just for a
What do you
minute.
want to show that in the?
Kindly come to page 9.
Yes.
Not he as on today, he is not paid the rents of 1 lakh.
I am
But he's
ready,
still due.
every day I am ready.
Kindly
They are not they are refusing to receive.
Is it that issue before me?
Not that, he is a defaulter, has no right to contest even before this court without even paying the rents also.
Janardhan.
Yes.
See, I don't know that why, see, the issue is that injunction has been granted not to alienate, not to create
Third
party
party.
interest
Yes.
or not to alter that.
Yes.
Instead of that, he's saying that police protection has been taken, his business has been, I said that cannot be done, interim order has to be protected as per
Not
that.
the police.
Rent has not paid, he has giving, that is not.
No,
the
not that.
issue.
What I am telling is, I am just showing to your lordship the conduct before the court, what is conduct, how he is misusing the lease agreement even after the expiry of.
I
the sale.
filed a memo
Yes.
before the court below,
Yes,
tendering rents also. They refuse.
See, that is not the issues. What is that interim order granted, that will be protected.
Yes, now kindly come to just for my satisfaction, para 5, page 9. Clause 5.
Yes.
The tenant shall use the premise for commercial purpose to run a shop and only so and so condiments only, and shall not use it for any offensive or objectionable purpose, shall not without consent of the owner sublet under the lease or part of the possession or make any alterations therein. He shall deliver.
See, all that,
Yes.
now you are submitting that, you have no objection for him to run that business during the pendency.
That is true. Now, another thing is that lease period, admittedly, it has come to an end by 23 August. In view of this reason, I filed an eviction petition. Now it is posted for evidence today. So in view of said reason, kindly protect my interest, because he should not take.
What I have to protect him?
What I am telling is, let my learned friend file an affidavit. He will not allow any third party to enter the property and do any business. And he is
But
doing.
from the beginning, I am telling that.
And he is doing the business with necessary license from the competent authority.
One
Yes.
sentence I
Yes.
said that.
Yes, that is.
He has to done the business in accordance with law.
Yes.
Simply you both are invested 15
Yeah,
minutes.
sorry.
time.
Not that,
Because
because
of
of
a
the
tolerant
problem is
contention,
created
I
to
have to
me.
divert.
At the moment he leaves India, he started with, because he all the way he come back to
No, you-
protect his property. That is the reason.
Where you have a right to do it, whatever, you have filed an eviction petition. Now you have taken interim order. Now
Yes.
you can file a petition that he has not paid the rent and all. All that
That is
issue
true,
is
my
not
lord.
before me.
That is true. But only thing is, this order, where as long as he is doing the business, this order will not come in the way. That
Now
is the
only, as
Yes.
on today, this is that
Yes,
interim order.
yes. But he, when the police
It
only
has to be
said,
implemented strictly. What is that
Yes.
order passed by? the
Yes.
court. That's all. Yes. This petition is filed by defendant challenging that order passed by order dated 28/11/2024, passed on IA number 3 in OS number 6518 of 2024 by 75th Additional City Civil and Session Judge, Bangalore, whereby IA is allowed. Where is that order, Mr.?
No, page 32 and 33, please. 33 is the operator.
IA for police protection filed by the plaintiff is allowed. Plaintiff has filed a suit for
Fair injunction.
I have filed a suit for, let him not sublet and also the.
where is that plaint?
produced
He have produced, kindly
next
come
year
to,
B,
Next year.
B, page 11.
not to sublet and also not to
Prayer
change
is
nature
at
of. the
paragraph, page 14, please.
Yes, filed in a suit for permanent injunction restraining the defendant from subletting the suit scheduled property and not to change that suit
Nature of
scheduled
the
property. ನಿಮ್ suit degree ಮಾಡಿದ್ರು ಕೂಡ there is no bar for him to run that business
I am,
because there is
no doubt, that is why I brought to the notice of the court. I already filed a suit for eviction, this is for evidence today.
different. Here even suit
is
is
true.
degreed also, you can't obstruct.
Not as a interim
Has to
measure, I
edit
have
you
done
only by
it.
due process.
Yes.
But I have filed OS number 7445 for
That is
24
different.
for eviction,
Yes.
because lease period is already over.
Yes. Suit for so and so. Along with that plaintiff, he has filed an application under order 39 rule 1 and 2.
2 IS I have filed.
He has filed 2 application under order 39 rule 1 and 2, restraining the defendant, his agent, servant from changing the nature of suit scheduled property and not to create third party interest. The trial court has granted an ex parte injunction order.
But it has been continued after hearing him filing a
Yes.
statement, yes.
Ex parte interim, ex parte injunction order granted later, it has been continued.
Yes. After hearing the other
No,
side.
no, my arguments are not been heard on IA1 and.
But it is, it is.
I'm sorry, let him not.
Kindly see the order, Miller.
Interim
no.
order is there as on today.
Is
That's
there.
the interim order, that's the, I have to be heard.
He filed a statement, he
It
argued
is
the
not been
matter.
heard.
I am not making any such observation. It is, see, 226. It will not take half a page to dispose, that's all. You are not giving any finding.
But
on
I'm
that.
only
It is
saying
only
it
on
did
the-
not be in, affect my interest.
Time to time it is extended, is it not?
Yes.
That's correct.
It is time to time, the interim order is extended. The contention of the plaintiff is that even though injunction order is in force, that defendants are violating the same, therefore, he has filed an application for police protection. Pursuant to that, the IA filed by the plaintiff has been allowed. Being agreed by the same, the plaintiff is before this court, the defendant is before this court. Learned counsel appearing for the defendant has contended that the injunction order is only not to create third party interest and not to alter that suit scheduled property. In the guise of injunction order, they are obstructing the defendant to run the shop by defendant himself. From the commercial law,
Commercial premises.
Commercial shop.
from the commercial shop, from the defendant. Learned counsel appearing for the plaintiff has contended that the plaintiff has no objection to the defendant to run the commercial shop in
In the name
accordance
of,
with law.
Miller, in the Hebbar condiments, that's for which it has been let out.
Yes.
Yes. What is
Yes.
mentioned in the agreement is that.
Yes, in accordance with law. And he further contended that he has also filed in a suit for eviction in OS number
In OS number 74,
744,
45 of
5 of
24.
24.
74, 45 of 24.
24. The same is pending for consideration. In this case, the grievance is only in respect of that injunction order granted, temporary injunction order granted by the trial court. As per that temporary injunction order, the trial court has restrained the defendant and his agent and servants from changing the nature of the suit scheduled property and also not to create any third party interest.
Sublet also.
Or create third party interest. Yes. In view of the above, the trial court has allowed that application for police protection to implement that order. In the guise of implementing that injunction order, the plaintiff or the police cannot interfere the petitioner to run the commercial business in the suit scheduled property in accordance with law.
Yes.
Till that further orders from the trial court. There may be any orders can be passed there.
My only request is IA 1 and 2 has to be heard by the trial court.
Yes. The trial court is directed to dispose of that application,
For injunction, IA 1 and 2.
IA 1 and 2. Disposed of that IA 1 and 2 in accordance with law as expeditiously as possible.
Please.
This is made clear that this court has not expressed any opinion on the merit of the case. Yes.
Cell number 12, Krishnamurthy T.
Petition, my lords. The totally 3 petitions filed, my lord. Permitted to take action. This is the third one.
Yes.
Connected along with.
Yes. Same order. Or issue notice. In addition, petitioner is permitted to take out hand summons to the respondents. All this matter along with their sons. 7-2. Yes, yes.
Cell number 13, B. Siddamalappa PM.
For the petitioner, Your Honor.
Hmm.
My lords, defend number 2's writ petition, my lords. Suit is for partition, my lords. I have filed the application under order 16 rule 6, my lords, requesting to summon register book maintained by sub-register office and also
Suit for
partition, my lords,
partition.
and also mortgage deed, my lords.
Why you want that?
Uh,
What is your defense in that suit, madam?
My lords, it is an ancestral property, my lords. Defendant number 4 as allegedly.
Now you come to that page 16.
Yes.
You are the defendant number?
2, my lords.
Defendant number 2. What is the relationship between that plaintiff and defendant?
In page number 18, there is a genealogical tree.
Yes,
my
you
lord.
just explain what is the relationship between the plaintiff and defendant.
Plaintiff and defendants are the brothers and sister, my lord.
Yes, sisters has filed in a suit against the brother.
Yes, my lord.
Yes.
And also, defendant number 4 is not a part of the family, my lord. Defendant number 4 is claiming that have executed a sale deed in favor of.
He is claiming that he is a purchaser.
Yes, my lord.
Who has sold that property?
Defendant number 2, my lord.
Defendant number 2.
Yes, my lord.
You are defendant number?
2, my lord.
You have sold that property. That
No,
is,
my lord.
no, that is his claim.
Yes, my lord.
Now what you want to in that application?
In that application, I'm requesting to summon the register book, which is maintained by sub-register office and also register mortgage deed, my lords, which is executed in the year 1/5/1975, my lord, to tally the thumb impression with the alleged sale deed, my lords.
Now court is not deciding here whether you have alienated that property or not. That is not the issue. It is only a partition.
Yes, my lord.
Among that, when he is claiming that, see, share, if you are, that is the case, you have to file in a suit for declaration that sale deed is null and void. Why that is not the issue? Where is that issue framed by the trial court in this case? Is there any issue in respect of that sale deed? Where is that issue?
Issue.
We produce that issue copies.
Yes, my lord.
Yes.
My lord, matter is posted for arguments as finally, my lord, tomorrow, a stay of further.
No, you show me that if there is any issue in respect of sale deed, then if it is required,
I'll produce it, my lord.
then only I can consider your, yes.
I'll produce it, my lord. Until then, stay of further.
Now, without come to that conclusion that whether it is relevant or not, what is that use in granting?
Kindly have it tomorrow, my lord.
Yes, you produce that. Use this matter tomorrow.
Cell number 14, B. Ramesh for petitioner, V. Chandrappa.
Petitioner.
Yes.
Lords, the
Serial number 14.
defendant's writ petition.
Yes.
Lords, an order passed under Art 23 Rule 1, permitting the plaintiff to file a fresh suit after a lapse of 16 years. Lords, on the ground that he has not pleaded some facts. Lords, the
Earlier suit for injunction.
suit for
Partition.
Lords, suit for partition and separate possession.
Yes.
Lords, initially the suit was filed by the father, that is Pillana. Lords, kindly refer to annexure A1, page Lords, 26.
Yes.
Lords, it was filed against his brother's legal representatives and one brother Kempanna.
Who has filed that?
Lords, Pillana.
Pillana. Now, who are you?
Lords, I am the legal representatives of Kempanna, that is defendant number 1 to 4.
Yes.
Lords, this suit was filed for partition seeking for 1/3 share. Lords, the suit schedule properties are at page 31.
Yes.
7, Lords, 11 items of suit schedule properties.
Yes.
This suit was filed on 2/9/2006. Lords, subsequently, a written statement was filed by the defendants contending that there was already a partition entered between the family members on 1/7/1991. Lords, subsequently, based on that pleadings, Lords, the evidence was commenced. Lords, kindly refer to the evidence of DW1, that is
What has happened to that suit?
Lords, now they have withdrawn that suit with the liberty to file a fresh suit by the legal representatives of the plaintiff.
Partition
Lords,
suit can be filed.
not my lord, not that, Lords, that there should be a formal defect under Order 23 Rule 1. Lords, the plaintiff, Lords, after the death of the original plaintiff, his legal representatives were brought on record. Lords, they filed an application for seeking for amendment of the return of the plaint, including certain properties. That is, initially, Lords, 11 items were shown in the plaint schedule. Subsequently, it was made as 21 items. There were 3 applications for impleading. Lords, now subsequently, the legal representatives of plaintiff, Lords, was examined as PW2. Lords, he also admits the partition entered between the family members in the year 1991. Based on that, Lords, there are certain sale transactions entered by the plaintiff during his lifetime. That is also been admitted. Now, Lords, kindly refer to the application. Lords, there should be a formal defect in view of the law declared by the apex court, Lords.
Yes,
What
well-
is that formal defect?
Yes,
Lords,
yes.
kindly refer to the application. 136 is the application.
Yes.
Lords, the affidavit is at page 137.
Yes.
Paragraph 5.
Yes.
Lords, whether it constitutes a formal defect in not including the properties and not including the some of the properties which are already been alienated prior to Lords, prior to initiation of the suit. Lords, I submit that.
Now, what is that order of the trial court?
Lords, order of the trial court is at annexure L.
Yes.
Lords, the learned trial judge extracts the entire paragraph 5 and says that it is a formal defect and allows the application.
Yes.
Lords, after a lapse, Lords, 2006 is the suit, initial suit. Lords, the order is passed in the year 2024.
Yes. Kodi, order 23 rule 1.
Lords, kindly refer to paragraph 5, 137, 138, Lords, in the affidavit filed in support of the application.
Yes.
Lords, I submit that Phil Kempanna, the wife of the first defendant, the father of this defendant number 2 and 4, 2 to 4, was the manager of the joint family, and during the subsistence of the joint family, out of the joint family funds, he has purchased survey number 5/5, 13 guntas, so and so in the year 1977. The land bearing survey number 4/3, 1 acre, 9 guntas, 71. Survey number 4/3, 10 guntas, 1990. Survey number 2/5, 20 guntas, and 90/1, 14 guntas, and survey number, Lords, in the year 1968. Lords, now survey number 57 in the year 1974. After the death of Pilla Kempanna, the wife and the children of Pilla Kempanna has sold the suit bearing survey number 5/1, survey number so and so in respect of Raghava Setu and Rahul Setu. Lords, without the consent and knowledge of the other family members, and sale transaction is not for the benefit of the family nor the legal necessity as such. Such transaction is no way binding on us and other family members. I submit that the suit framed by the earlier council, let's kindly remark this, is not proper and totally defective, and it cannot be curable, cannot be rectified for the simple reason the above mentioned necessary transactions are not being pleaded in proper manner, and the specific prior has not sought for, and not on the basis of the defective pleadings. This
Yes,
honorable
now
Court,
we come to that provision.
well, let's kindly refer to Order 23 Rule 1. At any time after the institution of the suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon a part of his claim, provided that where the plaintiff is a minor or other persons to whom the provision contained in Rule 1 to 14 of Order 32 extend neither the suit nor any part of the claim shall be abandoned without the leave of the court. Next, my lord. An application for leave under proviso to sub-rule 1 shall be accompanied by an affidavit of the next friend, and so on, so on, I will not read. Where the court satisfied Rule 3, mallards, a suit must fail for the reason for some formal defect. That there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or a part of a claim. If it may, as such terms as it deems fit, grant the plaintiff permission to withdraw from this such suit or such part of the claim with the liberty to institute a fresh suit in respect of the subject matter of such suit or such part of claim.
I thought, how it will prejudice to your
But
right?
it's not like that, my lords. Now the sale transaction, what they are pleading is of the year 1977. The father which has not been pleaded, the pleadings does not plead, is not pleaded by the father during his lifetime. Lords, he died during the pendency of the suit.
By
He was-
pleading itself, it's not,
Lords,
it has
not
to be
like that, my
proved.
lords. He could have amended that petition. He has sought for amendment of the plaint for 3 occasions, including the properties, my lords, including additional facts and additional properties. My lords, it cannot be a formal defect.
What is that judgment?
My lords, 2017, my lords, I have not, lords, I could not bring the judgment, my lords. 2017, 5 SCC, page 63 and 2.
You get that?
Yes, my lord.
When do you want?
Monday,
My recent submission,
because-
my recent submission. Admittedly, my lord, certain properties which are the joint family properties are not included. Suppose if it is not included, at the final stage, suit for partial partition may not be.
File an application for implementing.
No, that's my,
Amendment,
then
my
my
lord,
lord, if there is any admission by my father, he can make use of in the present suit also.
No,
Not like-
see, only property which is not included, even amendment is not necessary. Application can be filed for implementing. Even court
But
can ask to, that is the partition suit.
Even my lord, certain pleading is necessary, my lord.
File an,
Respect-
is no objection for amendment. You
No,
file it.
respect-
Yes, my lord.
No,
Petition.
certain pleadings cannot be amended also, my lord.
What is that?
We have, my lord, under
What
what
is that
circum-
you have stated in that
No, no.
affidavit? You
the-
cannot go beyond that. Affidavit you said, so many properties, it is alienated. File an amendment, we will allow them to amendment petition. Why do you want to file a fresh suit?
Then there are certain judgments that also, my lord, it is permissible. I can also let my learner.
Once, perhaps in the cross-examination of PW1.
Yes, you produce that.
PW2.
When do you want? Tuesday.
Yes,
Use this matter on Tuesday. Yes.
Till number 15, Girish, yes.
my lords, one more thing, my lord. Now they have filed a fresh suit. My lords, now they are want to prosecute that suit, my lord. Let them not
I thought-
prosecute that suit, my lord, till then.
How
Yes.
can it be in this present suit, my lord? He has to make separate application if necessary.
Now
that
that-
suit is there.
Fresh suit is filed. Yes, summons has to be issued.
Yes, it has been issued.
Has been issued.
Before passing the degree at any time, we can say that
Yes, ma'am.
permission has been given by the court can be set aside, then that suit will go. Wait,
Yes, ma'am.
nothing will happen.
Till number 15, Girish, yes.
Serial number?
15,
Yes.
Suit against defendant 2 to 8 million for specific performance. That suit can be declared million. That's ex parte decree.
Yes.
Based on the decree, I has filed an execution.
Hmm.
In that execution, I filed an application to as the obstructor to impede in that execution. That my application can be dismissed.
Who are you?
Actually, I'm in possession of the property.
Huh?
I'm in
When
possession
you
of
have come to that
property.
position?
No, from long back, my lord. In last time, directly to produce the document to show that my name in the RTC. Put in document.
No. How you have come to that position?
It's my father's property. My father's property, his property. And then unnecessary RTC agide. I put the document last time.
You come to that plaint. Ishurappa has filed a suit for specific performance.
Yes, sir.
Against whom?
That different number 2 to 8, the Gangamma and initially he filed against Gangamma.
Yes.
It
Who
was
are that
dependency.
defendant? Are they your relatives?
No, they are strangers.
Strangers.
They are our relatives.
Now that property is not concerned with that Gangama. They are nowhere connected with that property.
No, I have challenged that decree also. Even I have challenged that decree. What?
Whether they have any
they are
right
not
over the
concerned.
property.
Or
I have
consider
not
as
asked you to that whether you are challenger. Have they any right over that property? Gangama.
no, they don't have any right. They have collusively in question and sold the property. They have made into agreement, collusive agreement. Based on collusive agreement, they filed a falsehood.
Then properties belongs to whom?
My father, man, my registered property. Yes, madam.
How it comes to your father?
The registered property.
It
Yes,
is
property.
ancestral
Yes,
property.
property.
Your property, they have executed an agreement.
Even in, yeah, even in.
Why
that
your
question,
application is rejected?
my trial court stated that, my lord, in the execution, the court cannot conduct a mini trial. So it has dismissed my application and pursue in the decree, in the OS what I have filed against challenging the decree, my lord.
What is the degree of suit you have filed?
I'm challenging the entire decree.
There you have not sought for
No,
stay.
I have
of-
not for stay, my lord.
Why?
Because ನಾನು ಮಾಡಿದಾಗ they have not filed execution. ಆಮೇಲೆ they have filed execution and they're trying to take a decree from the court.
Otherwise, even both can be proceeded. If the execution petition is allowed, then you will lose it in the degree. Why you can't seek for a stay of execution in the degree?
With that observation,
You file an application. Application there, stay of that,
because this is,
or issue notice. Yes, you take notice.
Like in
For
the time-
impleading, you have any right. For stay, you proceed.
no,
proceeded.
because I filed an document to show that I'm question property. Last time the court has directed.
Now,
me to
what
file
is the
document.
stage in that execution petition?
It's not, they are not at executed sent in, my lord.
You take notice. Yes. Or-
Till that time, same will get.
Nothing will happen.
Because if they
If
execute
that is an execution petition,
it will
you
lead to
can't-
multiple. If they execute a dead, if they execute a sale.
not yet pass any order. What is that next date? Issue emergent notice. In addition, petitioner is also permitted to serve a copy on the council appearing for the respondent before the trial court. Yes.
Cell number 16, Prashant, SH.
For the petitioner's counsel,
Yes.
but the petitioner and Mulot is a company.
Yes.
Government company.
Lord, I may just be permitted to submit this. I was in caveat in this matter, my lord.
No, there is not.
Since a period of time has lapsed, the caveat has not been put up. As against this order, I had filed 2 caveats, one before the
Yes,
vacation.
yes, we will hear you. You are great.
Yes. We had Mulot invited Mulot tenders, but this is the Karnataka Mulot state medical supplies, state medical supplies corporation.
Yes,
We had invited the tenders.
yes,
Petitioner respond before Lordship Mulot had submitted Mulot his bids.
yes.
Amount Mulot is fixed. What happens is, after Mulot the supply, they Mulot give them higher amount. And Mulot, he goes before the MSME council, Mulot, unless Mulot they are registered, MSME Mulot can't. The officials then did not Mulot properly Mulot conduct the case. Decree passed. Appeal hakodilla. Execution hakidariga. Now Mulot, we have, Mulot, there is a commission Mulot which has been appointed by the government. And Mulot, the commission specifically holds that there has been absolute fraud. And Mulot, your lordships are aware, Mulot, if there's a fraud, even in a collateral proceeding, Mulot, it can be Mulot raised.
Yes.
We have already deposited Mulot about 1 crore and odd. Yes.
No, but
40 lakhs.
there is no fraud in that getting any degree.
Lord, no, there is. I'll tell you, Lordships, why. If Mulot, he did not have Mulot the MSME certificate at the time Mulot of his this thing, application for Mulot tender, then Mulot they should have, and
No.
they should have,
Why you have not challenged the degree?
Mulot, that's what it is. All officials have colluded, that's what Mulot our case is, and in the commission report, specifically Mulot, they come to that conclusion.
Now that what that court can do, that executing
Mulot,
court.
can say,
Hmm.
Mulot, even in a collateral proceeding, if there's a fraud, even in a collateral proceeding, Mulot, fraud can be raised. We have produced all this.
No,
Nothing
that
is
where is that degree? Where is that degree? Where is?
Come to my lord, running page. Degree. 225, my lord.
225.
26 ಬರುತ್ತೆ ನೋಡಿ. 226.
No, 226, what is this degree?
That's my lord the award, the MSME award.
Hmm.
My lord, there is that micro, my lord, ಅದರದೊಂದು ಕಮಿಷನ್ ಇದೆ. ಅದರಲ್ಲಿ
Oh, degree is obtained there.
ಹೌದು.
That can be
Arbitral award, an arbitral award.
It is treated as an arbitral award. They should file a section 34. ಅದನ್ನು ಹಾಕಿಲ್ಲ. And my lord, unless my lord, they
Now,
have
who is that presiding officer there?
my lord, one official my lord of the government. He will not my lord commit any fraud. It is
No,
not
no, no.
our officials.
No, whether is there any pleading or admission by the your parties to favoring that
No representation.
Representation ಇಲ್ಲ.
representation illa.
ಏನು ಹೇಳೋದು ಗೊತ್ತಾಗೋದಿಲ್ಲ ಇದಕ್ಕೆ.
No, why can't you seek for that there is no appeal remedy?
34 my lord has to be
34.
filed. 34 ಹಾಕಿಲ್ಲ ಇವರು. ಅದು 34 my lord section 34 of the Arbitration Act my lord within 120 days ನೀವು ಹಾಕ್ತಾ ಇದ್ರೆ ಬರೋದೇ ಇಲ್ಲ. That's my lord the fraud my lord from the beginning till the end. Anyway my lord, we have deposited my lord before the execution court 1 crore
40 lakhs.
40 lakhs.
No, he is recovering of money.
Recovery of money.
1 crore 40 lakhs we have already deposited. Their claim is my lord about 1 crore 98 lakhs.
Yes, we'll hear that. Let us, it is in a public money, we'll see.
No, it's not public money, it's supplies of medical equipment during the COVID period.
No, see, the question is that.
Well, can
the
it be?
award you obtained,
Well, just, the award has been obtained by fraud. Is there a pleading saying that the award has been obtained by fraud? Award is not there. Is something called the small and medium.
what is the remedy,
facility
Mr. Senior
council.
Counsel, if it is
That report of the commission appointed
no,
by the
that
government.
is different. See, after that limitation, you can't challenge that award.
They can't.
There is no any other remedy.
No, I can, my lord, set up in a collateral proceeding. My lords, my lord, if it's needed, my lord, I'll give you a lord's
No,
judgment.
collateral proceedings, if that award or degree is in a fraud,
Correct.
you can.
Absolutely.
that is
Therefore, my
there.
lord, what I am submitting before your lordships is two things.
Now, is it non-appearance of your party is in a
One is
fraud?
non-appearance. Second is, my lord, that my lord, he did not have the registration because, my lord, to come within the purview of MSME, he must have a registration certificate. He must register himself as a micro, my lord, or a medium enterprise, which he had not, is according to us. All that, my lord, is a matter, my lord, which has
here,
gone.
My lords, what? Malaj, I'm sorry, Malaj. If without even having an MSME certificate, how do I participate in the tender?
That will
The-
see.
Malaj, your
MSME
lordships, that has gone through the MSME council, these contentions were not taken up. They have come before this court at the first
ಅದೇ
instance.
ಪ್ರಾರ್ಥನೆ
This honorable court said, let the executing court hear the matter. There is a lot of
ಮಾಡ್ಬೇಕಲ್ಲ. ಅದನ್ನ
Executing
consider
court is-
So
ಮಾಡ್ಬೇಕು.
what is that order executing court is?
Now,
There is no order under challenge. Malaj, I have not been served with a copy of the petition in the first
That is
instance.
even without knowing anything,
Yes.
my lord, he is saying that is.
Yes, what is that you are
Now,
challenging?
my lord, they have directed, my lord, attachment of mobiles.
Malaj, as
1
on
crore
date,
40
as on
lakhs.
date, no attachment
No,
is filed.
see,
As on
let
date,
them
no
proceed on that
attachment is
merit
filed.
and consider, see, executing court has decided, can decide all these aspects. Let
So
it-
let's kindly look at the order of the court. This court, this honorable court passed an order, the first writ petition,
Let
I've
them-
given it. This court said, go back, let the executing court hear
They
it.
must consider them.
Executing court has heard it and considered the matter at
Please
detail.
come to my lord, page 260.
Kindly look at the order of this court.
Doesn't even have the copy and then he's arguing.
What is that executing court?
Please come to my lord, running page, my lord, 260.
Yes.
This is, my lord, the first order. We came before your lordships.
Yes.
Para 5,
Para 5, my lord, ತಾವು ಬಂದ್ರೆ
260.
216.
260, my lord, 260.
260.
Since the point was heard before the Honorable High Court of Karnataka was only that his objections were not considered by this court before issuing attachment warrant movable. Very limited question now before this court is whether this court has the right to issue attachment movables. Therefore, my lord, I issue attachment.
See, it is in a state undertaking authority.
absolutely.
What is the necessity for attachment before the degree? You argue on merit and get an
Malaj,
execution.
yeah, execution alien, what merits an execution, Malaj? I have an arbitral award. Executing court can't go behind the award. Award has become a decree today. It has attained finality.
Let
Once the award attains finality, executing court is to blindly execute it.
Therefore, my lord,
No,
all
then
the statements-
instead of that, why they have attached that? Let them
How do
pass
you
any final-
execute? How do you execute? Execution can only be by two methods: attachment of movables, attachment of immovables. Otherwise, the last remedy available is for arrest.
They have raised an objection
Objections has been heard. The court has passed an order in April,
there is-
in April of 2024,
Yes, where is that?
26th of April.
Please come to Malad.
Yes.
My learned friend doesn't have the papers.
Yeah, I
He's
don't
not
have the
got
papers.
copy.
I've not been served with the copy. I bowed out. I bowed
Now
out.
that order is under challenge.
Doesn't even have copies. He doesn't even know to have the order sheet.
Yes,
Doesn't
where is
check.
that? Where is that?
Please come to Malad. The impugned order is Malad page 259 and 260.
Yes.
All these Malad reports, none of it Malad is considered. All that he says is, High Court has said, nimma alle haki ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therefore, I issue attachment warrant.
It was observed that it is settled position would not executing court can't go beyond that degree, not it can enter into the.
High Court order said-
degree Not to be executed was obtained by fraud or collision. Can that executing court go in respect of that fraud?
My lord's order may be page 239. 239.
Yes.
This honorable court will not. We came before your lordship and will not please come to that order of your lordship. Matter is remitted back, last paragraph, sorry.
230?
9, Malad. It starts at 236.
Yes.
Last paragraph,
Hmm.
3. Matter is remitted back to the executive for reconsideration, refresh, or take into consideration the statement of objection filed by the petitioner. Here both parties pass appropriate orders. And what is the order? He says nothing.
Next para, next.
No.
Next statement, next paragraph also, Malad.
Yes.
All rival contention on all aspects of the matter kept open, no opinion is expressed. At the instance of so and so, Malad, 65 lakhs already.
Now
deposited.
that issue is
Ah.
whether executing court can go in the aspect of fraud or collision.
Yes, Malad, absolutely.
That is, you show me that because
Yes.
he has said this cannot be.
Malad,
If that would be the case, this order is wrong. That is the only issue now.
Lord, what I am submitting before your lordship, this honorable court said, consider all objections.
In accordance with law.
Correct. Now, my lord, what does?
Accordance with law, if law says it cannot be considered by that executing court, they can't go that.
My lord,
No, now only the issue is
Ah.
whether executing court can go
my lord,
all
in
this.
any collateral proceeding, if there is a fraud, my lord, if we bring it to the notice of the
Yes,
court, my lord,
yes.
your lords may just have a look at.
No,
my lord.
you just see the 262 page. Court said degree sought by execution was obtained by fraud and collision.
Correct.
Thus, this court cannot enter into that questions.
That is, my lord,
They
this
said.
court means, my lord, high court now can't, but the executing court will. And therefore,
No. Executing court finding is it not?
my lord, this.
Court can't go beyond the degree judgment. It was observed, it is settled
Correct,
position
correct,
of law that executing court can't go beyond the degree.
My lord,
can't-
just pass it over, my lord, I'll get the.
That is what
Just
that-
now, just now, give me
If
5
that would
minutes.
be the case on prima facie, that is
I'll-
wrong.
I'll just
My
pass
lords,
it over.
may I submit this? Learned senior is asking for a passover. Let a copy be served on me, my lords. Let the matter be taken up after 2 days, my lords. Anyway, there, as on date, there is no attachment warrant.
Is there an attachment?
Illa, sir.
ಅದನ್ನ fulfill
Any
ಮಾಡಿದ್ದೀವಿ.
threat is
It is
there?
coming upon 15.
Illa, sir.
Huh?
15/2.
We
Matters
fulfilled
posted
that.
on 15/2.
ಆ warrant ನ fulfill ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಮಾಡಿದ್ದೀರಲ್ಲ?
Yes, any date if you want.
Any date,
That
lords.
is the
whatever-
only issue here.
Si-
If that would be the case on prima facie, it has to go. Yes.
My lords, the leader of the bar, my lord, we bow down to the leader of the bar. Any date convenient to sir.
Yes.
ಎಮರ್ಜೆನ್ಸಿ ಏನಾದ್ರು ಕೇಳಿದ್ರೆ ಇಲ್ಲ ಅಂತ. ನಾವು ಅದನ್ನ.
That is the case, you can move at any time.
Very
There is
well.
No problem.
ತಾವು ಯಾವತ್ತಾರು ಡೇಟ್ ಕೊಡಿ ಅವತ್ತು ಹೇಳಿ.
My lords, notice,
Convenient
copy,
for both of
copy.
them.
Yes. No problem.
Yes.
Date.
Which date you want?
ನಾವು ಹೇಳಿದ್ರೆ
7th?
12th ಆಗ್ಬೋದಾ?
12th, yes, 12th. Wednesday. Yes, 12th.
Grateful, your lordships.
Till number 17, Atip Hussain, party in person.
Yes.
So in this case, the notice of the court, but the respondent is before the court. The CIS website shows that someone has filed wakalat on behalf of the respondent. However, the respondent has never filed any wakalat, not she had given any paper, not she had executed any.
Who is the respondent?
My lord,
Before the court.
You.
respondent, my lord, is only the learned civil judge, my lord. No other respondent is there and I am representing the learned
My lord,
civil
this
judge.
is the first hearing.
CIS court, it's showing us Narayan Bhatt is appearing for Rahila. Even is the
Wait,
cause-
mister.
Even is the cause.
No. Rahila Taj.
Rahila, that is.
See, you are appearing for whom, Mr.?
My lord, I am appearing for the senior civil judge, my lord, JMFC Chintamani.
That they have not made as a party here.
My lord, this lady is not implicated as a party.
No, she, in this petition,
Huh.
you are not a party, only that she is made as in a party.
My lord,
Yes, you are appearing.
my lord, I am appearing, my lord, for the senior civil judge. He's made a first respondent, my lord. He's made a-
Maybe after that he might have, that cannot be. Now that ruling is that the lower court cannot be made as a party in this. I think it might have been removed later.
My
Yes,
lord,
yes.
there was office objection.
Then
because of-
removed. But how that notice you got it?
My lord, I got notice from this honorable court. My lord, this honorable court appointed me, my lord. And thereafter,
There may be an, let us see.
My lord,
Maybe-
hearing,
Wait.
my lord, may I just pass on the order, my lord, passed by the registrar general, my lord.
Request with reference to the director to request you to appear and defend the senior civil judge. No, I think there may be some other cases. Yeah, the number is 6635. Now, why that register has written letter? You are not a party here also.
My lord,
Yes, you are
I-
right. But in that, there is no.
my lord, it was for a writ of prohibition.
Hmm.
That's why, my lord, the court, the learned judge must have been implemented by the petitioner.
my lord, this is the
And
first
I
hearing.
filed a reply stating that, my lord, as far as Chintamani is concerned, it is not covered by section 7. That notification also I have produced.
No, but if that would be the case, it has to go before that other bench. But yes, there is no party. He is, what is you are challenging here? Office objection and learned.
My lord,
I think later he has removed that. What is the prayer in this?
Writ of prohibition,
my lord, I am praying for dismissal of suit.
Direct that honorable court, senior civil judge James Chintamani, pending before the same court as next area, it is violating the family court's order interest. Honorable Court of Senior Civil Judge JMFC to dismiss the suit pending before the same court as next A is violation of the Family Court Act in this. Now, his prayer is to direct that senior civil judge to reject his suit.
please, my lord.
Yes, my lord.
My lord, your lordship may kindly see annexure R2, which I have produced with the objections, which says, my lord, Chintamani court has jurisdiction.
My lord, it doesn't say Chintamani has jurisdiction. It says, it sets the boundaries of Chikbalapur family court. Nowhere it is mentioned. You can read through the order, my lord. My lord, please see Supreme Court judgment.
Now, first we'll see, you don't know that what is that official communication on the administrative side. Where is that, Mr. Bhatt?
My lord, that is the letter, my lord.
No, that, this is pending in that Chintamani.
Yes, my lord.
Yes, my
I have
The
produced
case is that
annexure R2, my lord.
Chintamani has no power in respect of family court matters.
Family court. It's a civil.
Your lordship may kindly see annexure R2, which says, my lord, the Chikbalapur court's jurisdiction is confined to Chikbalapur town, not to any other parts of Chikbalapur
Family
district.
court matter in respect of Chintamani, it goes to where?
Goes to the senior civil judge, my lord,
My lord.
Chintamani.
Notification is there.
Notification only Chikbalapur town ಗೆ ಮಾತ್ರ 7 has been made applicable. I have produced that notification.
My lord, there is no mention of Chintamani, my lord. It's just to misguide the court. Please.
My lord, why
Supreme
should
Court-
I?
You don't know that any procedure, mister. All this will be done by the register. Even we can't know that. Only register has know that. What is that notification and all? It from the register, that's all. If it is there, then that is the only your case. Then you go and prosecute that matter there. In exercise in the power confirmed under that so Family Court Act, the government of Karnataka in consultation with the High Court of Karnataka hereby established with effect the date of presenting. As of June, this is the same notification of the jurisdiction of the court. Now that one family court has been established in the Chikbalapur.
Chikbalapur, its jurisdiction is confined to Chikbalapur
Only-
town,
Chikbalapur ಮಾತ್ರ ಅದು. It is not that
not to Chintamani.
Chintamani. ಇವ್ರದ್ದು ಕೇಸ್ ಅಲ್ಲಿ ಚಿಂತಾಮಣಿ.
Chintamani,
ಚಿಂತಾಮಣಿ which senior civil judge is the
competent court. my lord.
But there are family courts in Bangalore. Bangalore also has jurisdiction to handle.
No, it is not handle the case which is belongs to the Chintamani.
My lord, according to section 20A of.
See, if you are in that Bangalore,
Yeah.
you can file an application for transferring the case to that Bangalore family court. High court can has a power to transfer it if that inconvenience of the parties and all, that is section 24 of that CPC has provided.
My lord, apart from that, I have not been served the summons and the case has progressed.
That is different. Your prayer is that senior civil judge Chintamani has no power. senior Chintamani has an
My
power
lord,
under the
My
family.
lord,
Court
that
Act.
order sheet also has been produced. He was served
See,
and my lord, he was held ex parte. Then he files an application for recall. That is recalled. My lord, he should
oh, my
not
lord,
make
I have
a
submitted
actual
written
incorrect
statement. It
submission.
was not taken. Have the,
no, not, see, Mr. Your relief is only direct the court of senior civil judge JMFC Chintamani to dismiss your suit
As-
because
it is
they have-
violation of family courts.
now that there is a material from the registry, it shows that it has a jurisdiction.
My lord,
Then you go
apart from
and-
that, there is other violation also.
What
My
is
I
that?
have
lord,
not been served the summons and my written statement is not accepted.
No, all that, if the court pass an order without giving your written statement, you can file an application. If it is dismissed, then you can come here.
My lord, that is recalled. Ex parte order is recalled. I have
Recall-
produced the order
Oh,
sheet.
it is recalled.
My
You
lord,
want-
if your
But the-
lordship
But in
passes
order
on, my
sheet,
lord,
it's
that,
written statement is not accepted. Written.
my lord, I have produced that order. My lord, your lordship may kindly pass it on, my lord.
My lord, today is the final hearing and today order will be passed, my lord. Kindly in senior civil.
You
in
go
the-
there
in the
and
trail
file an
court.
application for your written statement, permission to file a written statement.
My lord, the office has accepted. I have filed, I have a copy of,
You have a written statement has been accepted.
yeah, accepted by
Then
office.
what is your grievance?
My lord, page 13, my
but-
lord, your lordship may kindly see. Ex parte order has been recalled on passing an order on IA number 8.
Yes. 14% defendant under so and so seeking to reject the plaint. For objection on IA number 4, so and so. You have filed an application for rejection of plaint, they will consider.
No, they have dismissed it, my lord.
Hmm.
They have dismissed it, saying that Chikbalapur doesn't have jurisdiction. But there's no notification regarding Chintamani, my lord.
Chintamani, it's in a general notification. All city civil, senior civil judge has a jurisdiction, so decide that family matters.
My
If
lord,
there
apart-
is, Mr. Party, Mr. Where there is a number of cases or more, there will constitute separate family court for that. Otherwise, senior civil judge is then a jurisdiction court to decide the family matter. That is the notification we have issued under the administrative side.
My lord, but it's not.
Now you have filed an application for rejection of that plaint. That application is, order is passed. You file a separate petition challenging that. There
My
you
lord,
can
I
see.
have already filed similar subject matter in this court. That's why I have not appealed it further.
That
and-
you prosecute that. This will not maintain
And
a.
I have not been given sufficient time to file the appeals also. Within 7-8 days, next hearing is coming and previous hearing was yesterday. Today is the next hearing. And
Oh.
still I have sufficient time for appealing.
Yes, you go and seek there and immediately you have to file concerned court and seek for a stay of.
Lord,
that
my
proceedings.
fundamental rights of equal justice
I'm
is
not
being violated,
considering-
my lord.
Only in this matter is concerned, your prior is that I will consider this submission and disposal. Third. In this petition is filed by the defendant, respondent. But this petition is filed by the respondent, the petitioner is the respondent in OS number 153 of 2023. He has sought following relief. Three, but Learned Council submitted that. ಎಲ್ರಿ ಅವ್ರನ್ನ?
ಅಲ್ಲಿ ಉಂಟು ನಾರಾಯಣ್ ಭಟ್
Page
page, my lord, annexure R1, R2.
has produced that notification to show that notification dated 30th/4/2020 is only in respect of establishment of family court in Chikbalapur,
Urban area.
within the limits of Chikbalapur city. In respect of Chintamani is concerned, senior civil judge JMFC is the competent court to decide that family matter. Therefore, Senior Civil Judge JMFC has rightly entertained that. Suit filed in respect of family matters. In view of the above, the prior sought by the petitioner will not survive for consideration. Accordingly, the petition is dismissed.
Serial number 18, Mithun GA for petitioner, Praveen HP.
Waiting for the,
The respondent.
Yes.
this is a matter where the, ex parte.
Adon copy kodi, but please, one copy kodi, please. Yes. Yes, Mr.
This is a matter when ex parte interim order was granted. Issue in hand was with the petitioner who was the member of the said respondent club. He was issued a show cause notice for removal of him membership from the said club, your lords.
Yes.
During the pendency of the said notice, he approached the trial court and sought an ex parte interim order, which is produced.
Yes.
Wherein the interim order was granted stating that the said petitioner cannot be removed without due process of law. Then during the pendency of the said suit, your lords, they have removed him from the membership. And the IA was still yet to be considered on main. When IA was considered on the main, the submissions made by the said plaintiff is that when the specific order is that due process of law has to be followed, the interim order was specific on that part. They have not followed the due process of law. Therefore, the removal of the said the petitioner plaintiff was not proper. But the Honorable Court has not looked into that aspects and has dismissed the said
Your suit for?
Suit for not to remove him from the membership of the said club, respondent number 1 club. Your Lordship. So the specific order, your lordships will find at page 109.
109.
Please, your lords.
Now, why you are saying that you cannot be removed? You said you can be removed only due process of law.
Due process of law. The
Now
due
they
process
have
of
done
law
it.
they have not followed.
If that would be the case, if court is now decided that he has already removed from due process of law, his suit become infructuous.
The
They decide now. His case itself is don't remove unless due process of law. Now injunction has been vacated on the ground that there is a due process of law. Then what is else remains in that suit now?
that's the whole point. Your Lords.
Let the suit may disposed of that injunction order will be continued.
That's all I'm stating.
We'll direct them to what is the stage in the suit?
Evidence, your Lords. Cross-examination.
Where is that now order passed by the trial court?
Lords,
Malas, if I may.
page A1, your Lords,
Wait.
page 44.
Page 44.
Please, your Lords.
What is that order?
Operating portion is page 51 and 52, your Lords.
No, your filed vendor, your application for
My main IA itself is disposed of stating that I've been removed from the, my whole purpose of filing the suit, it becomes infructuous.
Now that when that order has been passed ex parte,
Lords, 109 is at page,
Malas, 15 to 2018.
2018,
15th of February 2018.
15 to 2018.
15 to 2018. Please. From 2018 to 24, that order is in operation. Let us see there, another 6 months will direct it to dispose of the suit.
Malas, if I may, Malas. Malas may kindly permit me to, Malas. I have filed the statement of objections. The committee report, Malas, may kindly be seen. Before that, Malas, I want to draw my law's attention to brief facts of the case, Malas. Malas, the defendant before the trial court, Malas, is a small club which has around 200 members. The plaintiff, Malas, admittedly is a member of the club, Malas. He has violated the rules of the club. Now, Malas, the plaintiff has submitted the bylaws, Malas, of the club at Annexure B, Malas. Clause 16 of the bylaw says, Malas, if at all any member is found to have misconducted himself, Malas, the club has the authority to, after giving an opportunity of being heard. Now, Malas, after that, Malas, they have given 4 show cause notices. For none of the show cause notices, the plaintiff has appeared, Malas.
Here.
One.
Now, you have removed him by following that rules,
Due process, Malas.
due process of law, and you have communicated that order.
Please.
Before that, without removing, you have been restricted him to entering into that premises. Therefore, he is before the court.
No.
Now, they have removed, then it is a different class of action.
That is
You have
not,
to file in a separate suit. I think you have not challenged that.
The point is an amendment is filed a lot in the said proceedings and the cross-examination going on. The point is this, the ex parte interim order, what has been granted, that status quo ante should be maintained a lot until the pendency of the.
Till the
That's all I'm
disposal of the
stating.
suit, it was there for 4 years. Let it be there for
That is
another
all I'm stating a lot. Let the matter get
Malas, as-
disposed of whether the compliance is done or not, it's up to the,
Malas,
because
as of now-
amendment is filed.
Yes.
As of now, after 2018, he is under suspension, till date. For 7 years, he has been suspended. The reason being,
Now that.
After
what is that,
suspension.
Injunction order granted.
So that's the injunction order was granted in 2018. That order was challenged, lots. That's what is produced. That is what.
No, see, what is that injunction order granted in 2018?
Not to restraining them, not to terminate him or not to remove him from the said membership without due
No,
process of law.
Malas,
So I
there are
was,
two-
as on the date of the interim order, I was a member. It's
Malas.
only subsequent to this, they have removed me as a member.
there are two.
And now an amendment has been
No,
filed.
no,
and
no,
that
no,
is-
no. He has, what he is saying that court said he cannot be removed without following due process of law. Stay has been granted not to remove without due
following.
process of law. He's saying that during that period, you are under the suspension. That means to say you are not using that club all 3-4 years.
It's only after the said order has been.
Before that, you are using
Before
the
that I
club.
was
Yes,
using
mister.
it. Before that, I was
Malas, may
using it.
kindly permit
No,
me,
only thing is that
Please.
2018 to 24, whether he was using the club or not.
No,
Malas. No,
Until,
Malas.
until the order of the dismissal has
Malas.
happened, I have not
That
used.
no,
I have not
so-
used.
Show me that document to
But-
show that you are using.
That is what I'm telling us. After the dismissal of the order.
No,
of the-
after, I am asking that 2018 to 24, there is an order, whether you are using that. He said
Malas,
that you are under suspension.
Initially, I was using a lot. Thereafter, they have removed me in spite of.
No,
an interim order.
when it is removed, mister.
2018 in May.
31st May 2018, he has been removed,
May 2000.
After conducting the inquiry, I have filed the inquiry report along with my statement of objections. May kindly see,
No, wait, mister.
please.
After that only you have filed a suit.
No, before that only suit was filed.
When suit is filed,
Suit was filed in
February 2018.
February 2018.
when you have been removed,
I've been removed in May
2018.
2018.
2018. What is
Subsequently,
2018 you have been removed.
please.
From 2018 to 24, you are in that, this thing. You
But
have
till
got an
date,
interim.
I could not use the premises.
Till
because
date,
of
he is
the-
not used.
Wait,
because of
mister.
this.
My apologies.
There was an injunction order in 2018, but till today you are not using.
I was using for the
Now, can I permit you to use now?
what I'm stating is lots because the order states that it should be due process of law. Due process of law is not been
That is
followed.
different, mister. That will be decided in that. Last 4 years, you are not in that.
Because of the pendency of the hearings, lots.
Let it be another 6 months, they let them
Malas.
complete that.
I'm only stating it could be.
The end.
principles
You
of
cannot
status-
be permitted to use after 4 years when there is an interim order granted by this court, by the trial court, 2018, but you have not been allowed to use that.
I've used that in that period a lot. Only thereafter I've not been able to use.
That is what that, from 4 years you are not there. Now how can we permit?
From 7 years, from
The only
2018
point is
till
lots-
today,
Yes, you take
2025.
notice, you take notice. Yes,
He's already filed objections a lot.
yes.
The only
yes.
point here is
We'll hear after the disposal of the suit. Nothing is there. Yes, you are not using last 4 years. Now I can't permit. Yes.
at least what I'm stating is lots, the amendment application is filed stating that challenging the fact that my removal is not proper. It's in contrary to the violations of the ex parte interim order. The issue is here, it's more of a vengeance than against the following the principles. The suspension is animated because they don't state what is the time period of suspension. Lots. Suspension is always only a
No, now
tentative
that is
period.
not that. All that is pending before the trial court. Now you are seeking an interim.
I'm only
injunction
seeking for a status quo ante stating that what was my position before the ex parte.
before
interim
4
order.
years back.
7 years back.
Because it had to go before
Yes,
the
yes,
interim order and then it had to come back to
Seven
miscellaneous appeal,
years.
and the miscellaneous appeal was decided only in 23 and I've immediately filed this petition.
Yes, you could have sought for disposal of that immediately. 4 years you are not using, now I cannot permit. Yes. Yes, we'll have, post this matter in B group. Yes.
Sir,
Perfect.
admission matter, serial number 19, Satish R. Kirji.
Tengri, ಇದಕ್ಕೆ ಬಂತದು. B group ಗೆ ಬರ್ತದೆ.
Shown as absent, my lord.
I thought that it is fresh matter. Yes, mister.
Review petition.
You have filed in a review now.
Yes, sir.
Yes. Issue notice. Let the notice.
I have permitted, sir, my lord, counsel on record.
They may not take, let the go to that party. Again, they may say, let the go to the,
I have informed, my lord.
she will take notice. Yes, issue
I
notice.
will, both I will take.
Yes, issue notice. In addition, petitioner is permitted to serve a copy on Mishi. What is her name?
Hemlata Mish.
Yes. Srimati Hemlata Maishi, counsel appearing for respondent.
Please.
With objection, first time matter, serial number 20, Mahesh M.
My lord, I appear for the petitioner in this case.
Alaka.
There is an urgency because the lower court is posted the matter on 4th. So my lord, keeping pending the objections are only that paginations has to be done and another certificate, which I've already filed.
Pass or you do it, then we'll hear. Yes, pass or.
Number 21, Subramania PD.
For the petition, my lord, observe if I have a complaint, only copy was, my lord,
Paid, pass.
paid.
What we paid?
Paid itself, I paid.
What is that? Ella complete.
What is in? Online payment ಇದೆ, that is why.
ನೆನ್ನೆ ಕಟ್ಟಿದ್ದೀನಿ ಅಂತ.
Online payment ಇದೆ, ಹಾಗಾಗಿ I have paid in the evening, yesterday evening. Receipt ಇಲ್ಲಿ ಇದೆ.
Yes. Yes, then argue, yes. What is this?
Please, my lord. But the petitioner, my lord, is the defendant, my lord. The respondent filed the suit for the declaration, injunction and mandatory direction, my lord. My lord, the contention of the plaintiff is that, my lord, the defendant has encroached upon his property. So the specific, the sketch or the averment is not there in the plaint. Suppose, my lord, the plaintiff says, my lord, he is the owner of the 14.8 guntas of agriculture land. My lord, the defendant is my neighboring site owner, my lord. The site was granted by the Gram Panchayat.
No,
The Gram
suit for declaration.
declaration and mandatory direction by the plaintiff.
Now,
The
what's
defendant, my lord, I said that, my lord, I am the neighboring site owner. My lord, I constructed the house. Not the allegation of the plaintiff that I have projected some portions equipment on the plaintiff's property, my lord. The plaintiff examined himself as PW1.
Now, what is that you are challenging?
And I am challenging, my lord, acceptance of the commission local investigation on survey of the property, my lord. The commissioner's report is, Lord, is produced, my lord, at page number, my lord, 50, my lord. Page number 51, my lord, can be seen, my lord. The marked portion ABCD is that, my lord, my house, the what commissioner says.
Yes.
My lord, and the 57/7 is the defendant's property, sorry, plaintiff's property, land. Lord, commissioner has not surveyed the land area. He only surveyed the marked 1 and 2 portions, as he mentioned in the point number 3 of his report. But he has not surveyed the 14.8 guntas of the plaintiff.
ಅವರು ಮನೆ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದು ಸದರಿ ಮನೆ ವಾದಿ. Yes.
He has not surveyed the entire 14.8 guntas from all the corners of the plaintiff 14.8 guntas, nor he surveyed the sites of the defendant. He only marked the point number 1 and 2 as mentioned in the serial number 3 in
What is that order you are challenging now?
the acceptance of the commission's report.
Where is that order?
That is my annexure M, my lord. Annexure M. Annexure M. I have cross-examined the commissioner. My lord, thereafter, my lord, the order has been passed.
Where is that order?
Annexure M, my lord, page number 65, my lord. 65.
Yes.
May I read the order, my lord?
Yes, yes.
Please. On 16/3/2023, plaintiff has filed application.
Read that reasoning.
Reasoning is that, my lord, point number 10, my lord.
Yes.
The court commissioners had issued notice to the plaintiff and defendants. Both the plaintiff and defendants were present on perused the documents produced by the commissioner. As per the Akarband measurement of survey number 57/7 of Devarhalli village, Kasaba Hobbli, Kotigere Taluk, Hissa Mojini, Pakka book, original survey Tippani, Hissa survey Tippani, in respect of survey number 33/1, 57 and 57/8, along with the sketch. After reviewing these documents, as per the memo of instructions filed by both the parties, the court commissioner conducted the inspection of spot and measured the property and encroachment by defendants is also mentioned in the report and prepared a survey sketch in the survey number 57/7, and the commissioner has submitted his report on 24/9/2024 along with the sketch. As per the commissioner report, at the time of conduct, the merger and prepared the sketch, both plaintiff and defendants were
where, my lord,
Where is that, Mister? Other page.
subsequently, it is not there. Subsequently, after submit the report on 5/12/2020.
No, defendant were present.
Present and present,
Right.
present, parallel 11, my lord. Subsequently, after submit the commission report on 5/12/2024, the learned counsel for the defendant has filed application under section 151 of CPC to reopen the case for inquiry on commissioner report and files an application under section 16 or 16 rule 1 and 6 read with section 151 CPC seeking to permit to issue summons to the court commissioner, and the said applications are allowed and issued summons to the court commissioner. On 17/12/2024, the Taluk surveyor is present and she is examined as CW1 and got marked as 3 documents as exhibit C1 to C1 to 3. She cross-examined by the learned counsel for the defendants. The main contention of the defendants is that in spite of report submitted by the court commissioner, which is not correct, on perused the commissioner report filed by the court commissioner and on the basis of materials available on record, it is sufficient to proceed with the case. The court again cannot appoint commissioner to correct some more materials, to collect some more materials. It's amount to fishing out of the evidence, which is not permissible under law, and reissuing the court commissioner warrant is contrary to law. In the facts of the circumstances of the case, the oral and documentary evidence available on record and the commissioner report are sufficient to proceed with the case. Hence, again, reissue commissioner warrant to file for further report cannot be sustainable. Hence, there is no prima facie error or mistake in the commissioner report. Therefore, there is no impediment to accept the commissioner report dated 24/9/2024. Accordingly, I answer the point number 1 in the affirmative.
What is wrong in the commissioner?
That is what. There is no reasoning, my lord, about the my objections raised in the report, my lord.
What is that?
In page number, my lord, 51, I said submitted, my lord. At page number 51, my lord, commissioner says at pair number 3 in the last para, he has identified point number 1 and 2. That is, my lord, the boundary of 57/7, 57/6 and 57/7. He has not measured entire 14.8 guntas possessed by the plaintiff.
No, see, which is the suit schedule property?
That is 57/7, my lord. He has not measured these 14.7 guntas.
You are outside that.
I'm outside that. It is not disputed in that. What is the allegation by the plaintiff is ABCD is my building. I'm encroaching on this 57/7.
No, that shows that you are not encroaching. Then it is your benefit.
No, but he says, point number 1, he says in his report, the one projection of the on the northern side, that is a road on the northern side, 6.5 feet projection, my lord, terrace area is encroaching on the plaintiff's property. That is what the commission report. That report, my lord, says that there is encroachment on the northeast side, as per point number 1, my lord. That itself is, my lord, cannot be come to conclusion without measuring the entire extent of land of the plaintiff.
No, your property is adjacent to that.
Adjacent to that.
You have constructed.
In my side.
You are constructing inside. In the second floor, that is extending.
First floor projection matra, terrace matra, road actually, road hogtade. North side is road. But road is dotted line is that is road, my lord. The dotted line. Front portion facing to the north. In fact, the plaintiff has not furnished the correct dimension, boundaries.
No,
of course, my lord.
You are saying that B and D.
A and B is the northern portion, my lord.
A and B is the northern portion.
Northern, so and that is dotted line is the road. In that side, that is a B portion is northeast corner, my lord. Northeast corner. In that side, there is encroachment as per the report of the commissioner. To come to this such conclusion, my lord, he has not surveyed the 14.8 guntas of land or the defendant's site. He has not measured my site or his land. He only measured the point number 1 and 2 marked by him. One straight line, he has put a straight line.
Now, petitioners 57/6 plaintiff.
57/7 plaintiff.
ಅವ್ರದ್ದು ಮೆಜರ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಮೆಜರ್ ಮಾಡಿದಾಗ
ಅಲ್ಲದೆ ಅದರಲ್ಲಿ ಅವ್ರದ್ದು 14.8 ಗುಂಟೆ ಇದೆ. ಅದನ್ನು ಮೆಜರ್ ಮಾಡಿಲ್ಲ ಅವರು. ಅದನ್ನ ಮೆಜರ್ ಮಾಡ್ಲಿಲ್ಲ. ಜಸ್ಟ್ 2 ಲೈನ್ ಇಟ್ಕೊಂಡು ಇಲ್ಲಿ ನಮ್ ಸೈಟ್ ಇಲ್ಲಿ ಇದೆ, ಅವ್ರ ಲ್ಯಾಂಡ್ ಇಲ್ಲಿ ಇದೆ, ಈ ಲೈನ್ ಅಷ್ಟೇ ನೋಡಿದ್ರು ಅವರು. He has not measured the entire extent of plaintiff's land. 57/7 ಅಲ್ಲಿ 14 ಗುಂಟೆ ಇದೆ.
Has he stated in that evidence that I have not measured entire?
ಅಲ್ಲ ಇದೆ, ಪಾಯಿಂಟ್ ನಂಬರ್ 3 ದಲ್ಲಿ ಇದೆ ಸರ್. ಇದೇ
Evidence ಅಲ್ಲಿ ಹೇಳ್ಸಿದ್ದೀರಲ್ರಿ?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕೇಳಿದೆ ಸರ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ I have produced at page annexure L, my lord. Annexure L I have produced, annexure L, my lord. That is just 2 pages, my lord, I will read. ಪಾಟಿ ಸವಾಲು, my lord. ಸರ್ವೆ ನಂಬರ್ 57/7 ಸರ್ವೆ ನಂಬರ್ 57/8 ಪೂರ್ವಕ್ಕೆ ಬರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 57/8 ಗ್ರಾಮ ಠಾಣೆಗೆ ಭೂ ಸ್ವಾಧೀನವಾಗಿ ನಿವೇಶನಗಳಾಗಿ ಆ ಬಗ್ಗೆ ನಕ್ಷೆ ಸಹ ಆಗಿರುತ್ತದೆ. ಎಂದರೆ ಸಾಕ್ಷಿಯು ಹುಲಿಕುಂಟೆ ಪಿಡಿಒ ನನಗೆ ಯಾವುದೇ ನಕ್ಷೆ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದು ನುಡಿದಿದ್ದಾರೆ. ಸರ್ವೆ ನಂಬರ್ 57/8 ನಿವೇಶನ ಸಂಖ್ಯೆ 13 ಬರುತ್ತಿದ್ದು ಆ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದಾರ ಎಂದರೆ ಸರ್ವೆ ನಂಬರ್ 57/57 ಉತ್ತರ ಮತ್ತು ಪೂರ್ವ ದಿಕ್ಕು ಈಶಾನ್ಯ ಮೂಲೆಯಲ್ಲಿ ಕಟ್ಟಡದ ಗೋಡೆಯ ಹೊರಗಡೆ ರಸ್ತೆಯಿಂದ
57/2, 57/7 ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದನ್ರಿ?
ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಮಳೆ ವಾದಿಗಳ ಮಾತು ಕೇಳಿ ನಕ್ಷೆಯನ್ನು ತರಿಸ್ತೇನೆ. 57/6, 57/7, 57/10 ಎಲ್ಲಾ ಮೂಲ ಬಾಂಧುಕೊಲ್ಲುಗಳಿಂದ ಅಳೆದು ನಾವು ನಿಸಿಟು ಅಂತ ತಯಾರಿಸಿದ್ದೇವೆ. ಅದರಲ್ಲಿ there is no in the memo of instructions I have produced and in the sketch also he has not, there is no marking in the point number 3.
ಮೂಲ ಬಂದು ಕಲ್ಲುಗಳಿಂದ ಅಳೆದು ನಾವು ಎಲ್ಲವನ್ನೂ ಅಳತೆ ಮಾಡಿದ್ದಾರೆ ಮೂರನ್ನು.
ಅದು ಹೇಳ್ತಾನೆ ಮಾತ್ರ, ಇಲ್ಲಿ ಆಕ್ಚುಲಿ ಇಲ್ಲ. In this page number 50
evidence ಅಲ್ಲಿ cross examination ಅಲ್ಲಿ you yourself has put in a question.
ಅಲ್ಲ, I put a question, but my lord
said it is measured. Saying that no, on what basis you are saying that it is not measured?
That is sketch itself, my lord. The sketch itself, that is page number 51. In the 51 says there, my lord, point number 3 at bottom. ಸದರಿ ಸ್ವತ್ತನ್ನು ಲಾಗು ಹಿಸ್ಸ ಗಡಿ ಗುರುತುಗಳು 1, 2 ಈಗಾಗಲೇ ಹದ್ದುಬಸ್ತು ಆಗಿ ಗುರುತುಗಳಿದ್ದು ಸದರಿ ಗುರುತುಗಳಿಂದ ಅಳತೆ ಮಾಡಿ ನಿಗದಿಪಡಿಸಿಕೊಂಡು ದಾವಾ ಸ್ವತ್ತನ್ನು ಗುರುತಿಸಲಾಗಿದೆ.
See, from that point he has measured.
ಅಲ್ಲಿ ಈ 2 ಪಾಯಿಂಟ್ ಇದೆಯಲ್ಲ, ಈ 2 ಪಾಯಿಂಟ್ ಅನ್ನ plaintiff in his evidence that there is no such stones.
See, you said 57/7, 57/10 he has not measured. In his evidence he has said that it is measured.
There is no measurement, my lord, marked by the court commissioner as well as in the poem of instructions I have produced, my lord.
Yes, that's all.
Page number 55 and 56, my lord, typed copy I have produced, my lord.
Yes.
57 and 56.
For assisting the court to.
ಅಲ್ಲ, ಈಗ ಏನಾಗ್ತದೆ ultimately, my lord, it is through decide the case, my lord, and resolve the dispute, my lord.
Yes.
Since, my lord,
After that measurement only he has come to that conclusion.
ಅಲ್ಲ, even
it is coming in this evidence.
ಅಲ್ಲ, in the report, my lord, he says that
What's an order? That's all, Mr.
Just for a minute, my lord.
Yes,
He
yes,
says,
I
but
understood, but this is all simply dragging that matter.
ಅಲ್ಲ,
He has
ನಮ್
conducted, it clearly shows that that is a projection because they have measured their property.
That
in measuring part of that your projection has been passed into their property. That is what he has given.
in the source examination PW1 plaintiff, my lord, he himself admits that there is no boundary stones, my lord.
If you want
page number,
give a notice.
ಅಲ್ಲ, page number 29,
Which one you want?
ಅಲ್ಲ, just for a minute, my lord. Page number 29.
Yes, yes.
There is no court commission.
No, Mr. Yes, notice. Yes, office objection, submission is accepted, office objection. No, learned counsel for the petitioner submit that office objection is complied. Yes, office to verify and proceed further.
Serial
Yes.
number 22, T. Sheshagiri Rao petition.
Handsome, my lord, as well as, my lord.
In addition, petitioner is also permitted to take out hand summons.
Please.
What is that?
The
Elevator officer.
Copy has to be served to
the
the
caveator has been served through email.
Yes.
Caveator has been served through.
Served. Yes.
Minutes,
We have not received any caveat.
email consider.
Not received, my lord. Before that.
Not issued. What is your name?
P. Chandrappa.
Chandrappa.
Check your mails.
Yes,
If you,
copy
if you still have one
Only
physical copy,
have it
not
on
a- you can please
Monday
have-
or Tuesday.
Yes,
Minutes,
Monday.
the only problem, minutes, is police protection has been granted in minutes to enforce an order of injunction. Minutes, pure agricultural land. Minutes, police come to the spot and say, ನಿನಗೆ ಮುಕ್ಕಾಲ್ ಎಕರೆ ನಿನ್ ಮುಕ್ಕಾಲ್ ಗುಂಟೆ ಖರಾಬ್ ಯಾಕೆ ಜಾಸ್ತಿ ಬಂದಿದೆ ಸರ್ವೇಲಿ? This is
What is that injunction has been?
my brother has applied a suit seeking the relief of prohibitory injunction.
Yes.
All right. Then the court grants an order of injunction because it is partition properties. Now, what has happened, is only this. I'll just point out. In the property, by the end of his property, there is a commonwealth. There's a commonwealth for all of
That
us.
is not the issue here.
Yes, my lord.
Injunction has been granted.
I have no issues with it.
Implementing that injunction, see, if
Yes,
you are
ma'am.
no grievance against the
Yes,
injunction,
my lord.
to implementing the court order, if that police protection is given, how
But,
it become wrong?
Kindly see what is the effect of implementation of this order, my lords.
Now,
Now-
then why interim order has been granted? It should not be
My lords,
implemented.
initially we thought, our 18 ಗುಂಟೆಗೆ ಅವ್ರು ತಗೊಳ್ಳೋದಾದ್ರೆ, we should not have any objection. But the effects of this injunction order, my lords, injunction order ಆಯ್ತು.
Challenging that injunction order.
My lords, yes, we have proposed to challenge that order because, yes,
It
no,
then you-
I'll just request, my lords, what has happened is only this much. I know what your lordships are getting me.
Yes, yes.
Your lordships are asking, injunction order challenge ಮಾಡಿಲ್ಲ, you are coming before
Already
the
ನಮ್ಮ
court
order
seeking-
ನ ನಾವು protect
ಇಲ್ಲ,
ಮಾಡಿ
ಇಲ್ಲ, ಇಲ್ಲ.
ಕಳ್ಸ್ಬೇಡಿ
No, I'm
ಅಂತ
not
ಅಂದ್ರೆ
for a
what-
moment saying that. I'm not, the test is only this much, my lords.
Yes.
Police protection can be granted for, my lords, implementing the court orders. My lords, the averments in the affidavit will have to demonstrate a higher degree of probability saying that there is an extraordinary breach. And my lords, the breach is in akin to a contempt. That is, my lords, order 39 rule 3. Then, my lords, the courts will indulge itself and say, yes, there is a possible of the likely possibility of a contempt or contempt is being carried out. Hence, I am granting an order of injunction. I will take my lordships to the order, the affidavit which I have filed before the court below.
Yes.
F1, my lord, for a moment. I will not go beyond that at all.
Already they have cut off the trees and.
I'll just point out, but I'll just point out
When do
the,
you want?
my lords, 117 for a moment.
Monday or Tuesday.
What will happen till Tuesday?
My lords, ಈಗ ಏನಾಗಿದೆ, ನಂಗೆ ಎರಡೇ ಸಮಸ್ಯೆ ಆಗಿರೋದು. ಅಲ್ಲಿ ಮೂಲೆಯಲ್ಲಿ ಒಂದು ಬಾವಿ ಇದೆ. All I am requesting, my lords, is ನಾವು ರೈತರು ಬೀನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಬೀನ್ಸ್ಗೆ ಅರ್ಧ ದಿವಸ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಇರಿಗೇಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ, my lords, the crop will grow. The crop will wilt away by the end of this March. My lords, all I am requesting is, ಅಲ್ಲಿ ನೀರ್ ತಗೊಂಡು ಹಾಕೋತಾ ಇರ್ತೀವಿ. I don't think it's a common.
Is there any injunction for that?
No, there is
Not
no
to use
intention, and this is what the police have protected. But the police have come, road gate ಎಲ್ಲ ಬ್ಲಾಕ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲಿ ಹೋಗಕ್ಕಾಗಲ್ಲ ನಮ್ಗೆ.
What is that material to show that?
I just point out, my lords, kindly see, this is the road. If my lordships could see for one moment, my lords, my lords,
Beyond that injunction order.
please, my lords, kindly see. 120, my lords, 125, your lordships will
No,
see.
you can't brought to the notice of the same court showing that police protection which is given, they are doing beyond the.
ಮೊನ್ನೆ ಇದಾಗಿದೆ, ಇಲ್ಲದೆ ಇದ್ರೆ ರಿಟ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. ರಜದ ದಿವಸ ಬಂದು ಪೊಲೀಸ್ನವರು.
Can't go before the same court.
We will, my lords, we will, that exercise we will carry it out, my lords, but I am only pointing it out. My lords, civil disputes, agricultural lands, ಏನೋ ಅಲ್ಲಿ ಏನೋ ಬೆಳೆ ನಾಶ ಮಾಡ್ತಾ ಇದೀವಿ, ಫೈನ್. ಅಲ್ಲಿ ಏನೋ ನಿಂತಿರೋ ಮರ ಕಡಿತಾ ಇದೀವಿ, that is fine. My lords, if there is an allegation to that in the affidavit, my lords, I bow down. My parties, my lords, are under the risk of incurring contempt. Kindly see 123. This is the well. ಒಂದೇ ಒಂದು ನಿಮಿಷ, 123. My lords, 124 is the pump set, my lords. And my lords, my wilting away is at 125. And my lordships will see
No,
127 for a moment, how the roads are blocked.
till Tuesday, what is that urgency to plead?
ನೀರಿಲ್ಲ, ನೀರು ಬೀನ್ಸ್ ಹಾಕಿರೋದು.
Yes.
ಬೀನ್ಸ್ ಹಾಕಿರೋದ್ರಿಂದ,
Where is that injunction order?
my lords, the injunction order, your lordships will see at 101, my lords, 101 and 111, my lords, is the order of injunction.
Yes, what is that?
And it says, my lords, you shall not enter upon his property.
Defendants, agents, anybody claiming through that under them is
His peaceful protect.
position of the principal. What is that suit schedule property?
My lord, suit schedule property is 18 3/4 guntas of agricultural land. My lordship will see the schedule at 95 for a moment. 95. This is the schedule. Each one of us, my lords, have the same schedule here. My lords, ನಂಗೂ 18 ಮುಕ್ಕಾಲ್ ಗುಂಟೆ ಇದೆ, ಅವನಿಗೂ 18 ಮುಕ್ಕಾಲ್ ಗುಂಟೆ ಇದೆ. ಒಂದೇ ಒಂದು ನಿಮಿಷ, ಪೇಜ್ 71.
Vegetables you have grown.
Please, my lords, I'll just point. ಒಂದೇ ಒಂದು ನಿಮಿಷ, 71 ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ತಮ್ಮಲ್ಲಿ.
Yes.
Page 71. There, my lordship will see the southernmost tip, my lords, is what is allotted to my brother, the plaintiff.
Yes.
2 ಅಂತಿರೋದು plaintiff. My lords, the next one is 5 ಅಂತಿರೋದು plaintiff number 1, defendant number 1. ಮೇಲ್ಗಡೆ 7 ಅಂತಿರೋದು defendant number 2. My lords, your lordship will see there is a road of access. It is a survey. This road of access, my lords, passes through my land, his land, everybody's land, my lords.
Yes.
It ends in 2 and then, my lords, it passes through 4.
Yes.
And the wells are here in this portion.
Yes.
No, my lords, I have to use the road, number 1.
No, well in that which portion?
Well is in, my lords, in 2, block 2. My father, my lords, while the partition executed.
No.
Yes,
This 2, the plaintiff properties is 5.
plaintiff property is 2.
Plaintiff properties 2.
2.
There is an injunction.
There is an injunction.
And then how will you use
No,
that?
no. The injunction, my lords, is with respect to 18 ಮುಕ್ಕಾಲ್ ಗುಂಟೆ ಜಾಗ. No problem, lords. On 18 ಮುಕ್ಕಾಲ್ ಗುಂಟೆ, we don't want to interfere at all. No, my lords, there's a common well, just common well in that.
The total extent of that land.
My lords, this land, my lords, is all put together. My lords, 18 ಮುಕ್ಕಾಲು 4 ಭಾಗ ಆಗಿದೆ.
No, only in number 2.
ಒಂದೇ ನಿಮಿಷ ಸ್ವಾಮಿ. I'll just give the exact number. I'm so sorry. I should have had it on
Number
my.
2 is the suit scheduled property.
Please, my lords, 18 ಮುಕ್ಕಾಲು ಗುಂಟೆ is the suit schedule property. What your lordship saw? Number 2.
That
No?
is number 2.
Yes. And
Total extent of number 2.
my lords, 18 ಮುಕ್ಕಾಲು ಗುಂಟೆ. All of us have been given 1834.
No, see, in item number 2 ಇದೆಯಲ್ಲ,
Yes.
ಅದರಲ್ಲೇ ಎಲ್ಲರಿಗೂ ಡಿವೈಡ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಬೇರೆ ನಿಮ್ದೆಲ್ಲ ಮೇಲ್ಗಡೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು plaintiff number 2, 7.
ಹ್ಮ್.
ಇನ್ನೊಬ್ಬ ಬ್ರದರ್ ಹೂ ಇಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ, ದಿಸ್ ಇಸ್ 6. ಅವನು 18 ಮುಕ್ಕಾಲು. ಇದು ಇನ್ನೊಬ್ಬ ಬ್ರದರ್ ಹೂ ಇಸ್ ಅಗೇನ್ ನಾಟ್ plaintiff, defendant number
I'm not
1.
Which is that plaintiff suit scheduled property?
2.
Entire extent is gone to that plaintiff.
Yes, my lords.
A injunction is entire extent.
Injunction, my lords, is 1834.
Huh?
1834 guntas is the injunction.
No,
Yes, my lords.
2 is entire extent 18.
Please, my lords, yes.
Well is in that.
In the southernmost tip of that. That is why I wanted your lordships only to look at this declaration.
One person is also part of that suit scheduled property and item number 2.
My lords, may I just point to? No, there, no. There's, I'll just clarify.
Yes.
I know what
Yes,
your lordships
have
are
it on
asking.
Tuesday. Yes.
My lords, may I only request this? There's
Now
a,
that
ಅಲ್ಲಿ
you
ತಾವು
said-
ಹೇಳಿದ್ ನಂಗೆ ಅರ್ಥ ಆಯ್ತು.
Yes.
ಆ ಡಿಕ್ಲರೇಷನ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ at the time of partition. Yes.
Now injunction has been granted in
Yes,
respect of the item number 2.
Yes, my lords. Yes, my lords.
If well is there and that,
Yes, my lords.
if there is an injunction not to interfere,
Please, my
even
lords.
for the water also you can't go unless you challenge that.
My lords, all right, my lords. Your lordships are quite right in saying so. For only one aspect, I'll only request, my lords. My lords, I have an access to another borewell in 4.
Yes.
My lords, this 4 there is no injunction. Wait. 4
From
there
where
is
you
no,
are going to 4?
the right to go to 4 minutes is also being blocked by virtue of this order.
No, that injunction has been
Yes.
given entire extent now.
Minutes, no, the road, my lords, it's a government road that is being blocked, which is what I wanted to point out.
Therefore, court has granted an injunction in respect of that road. You have to challenge that. Challenging and you have to argue before me saying that this is wrong.
I will do the needful. Minutes, but police should not come.
Huh?
Police should not come, minutes.
No, if there is an injunction.
I agree, minutes, but in the light of these circumstances, minutes,
You challenge that.
I will do the needful,
And
minutes. I will do the
genuinely
needful.
needful.
I will do the needful. But civil disputes, minutes, police should not come. Generally, minutes, if he makes one allegation that I have cut a
No,
tree,
it clearly shows that
Yes, Lord.
police is required because you are violating. By arguments itself shows that you are entering in the road to the suit scheduled property.
It's
which
a
has been-
government road.
Injunction has been granted.
it's a
Police is-
government road.
No. If court has granted an injunction to that Vidhan Sauda, you have to challenge, mister.
I
Till
totally
challenging that.
I
the
totally
order is in
agree.
force.
I will only point out one stray sentence in
Yes.
the affidavit,
Now
117.
that Police are doing that, implementing that injunction order.
Please, Minot.
Nothing wrong in that case. Otherwise, I could have called that police to give an affidavit why you are blocking, but injunction is there, what they are do. If they are not complying, then that allegation against the
Please,
police.
minutes, I get it.
The remedy is to, you have to challenge. You
Minutes, it will be
challenge it,
challenged,
then
minutes.
it
Your
is-
lordships are right in holding out on Tuesday, minutes. By Monday, the appeal will be filed, so that there is a challenge to that.
Yes, Tuesday.
Please.
Tuesday you will.
ನನಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನಾಗ ನನ್ನ ಬೆಳೆ ಎಲ್ಲ ಹೊಟ್ಟೋಗ್ತಾ ಇದೆ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್.
Then
Yes,
that Tuesday, yes.
please.
Yes.
Cell number 23, Chandranath Arigake.
Small
Yes.
office objection, I shall comply. That is, one is,
Provision of laws to be
pro-
stated.
that is two
Details
twenty-six.
to be stated.
Yes,
Number difference.
my lord, once,
Yes,
yes,
pass over, you do it. We'll have it.
yes, one submission, my lord.
Hmm.
IA number, actually, IA number is 54, my lord. The court refers it as 55.
No, all that minor corrections will overrule it.
Yes,
Whatever that can be done it, you have to done it, we'll pass over. Yes.
230, my lord.
Yes,
Because
all that objection I am passing over, you comply it, I will take that matter.
urgency
If
is
that-
that matter is posted for judgment today.
No, see,
I shall.
legible copy, some this clerical, all this I am overruling in the urgence.
Yes.
Some of that office objection, affidavit is not shown, court fee is not paid, all that I will not entertain without that. Therefore, whatever
Yes.
you complied,
Yes,
if you satisfied me that other objection is not so much important, I will hear.
no, others also, I shall comply.
Yes,
Cell
whatever you can be complied, it is complied.
Cell number 24 to 28 adjourn. Office objection third time, serial number 29, G Narayan Rao.
Yes, third time. ಏನ್ರಿ ಅದು? Yes, pass over suit and I don't check.
Serial, fourth time office objection, serial number 30, Chandra
for
Kumar
repeat.
R.
I am for the petitioner in this case, Your Honor. My lord. Office objection is concerned. Why the defendant number 4 and 5, as per the plaint made to the petition. Your Honor, the petitioner has filed suit for bare injunction. Trial court has granted export a temporary injunction. During the pendency of the suit, subsequent to service of the summons, during the pendency of the suit, defendant number 4 and 5 came to be died. In a suit for bare injunction, the plaintiff was unable to bring the LRs of the defendant number 4 and 5. Defendant 4 and 5. Suit for bare injunction legally as tarak. So, the same cause title was continued. But thereafter, the petitioner has filed present application to extend the interim order. It was rejected. Then the petitioner has challenged the said order. This office objection is concerned defendant number 4 and 5 act party model. In a suit for bare injunction, legal years need not to be bring.
No, see, suit for,
Bare injunction.
you are the plaintiff or a defendant?
Plaintiff.
You are the plaintiff.
Plaintiff. Defendant number 4 and 5 came to be died during pendency of this suit.
Defendant number?
4 and 5. Page number 24.
Defendant number 4 and 5.
4 and 5.
Now you are not prosecuting against 4 and 5. Only 1 to 3.
1 to 3.
Yes. Submission of learned counsel for the petitioner is accepted. Office objection is overruled.
Matter may be listed tomorrow. Another
Next week.
another connected matter list ಆಗ್ತಾ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ 9930.
4 times office objection has not complied.
ಇದೇ submission.
Then you have not moved that matter.
Last time
Only for that office objection.
one submission.
ಆಯ್ತ್ರಿ 4 time ನೀವು ಬಂದು ಇದನ್ನ ಹೇಳ್ಬೋದಿತ್ತಲ್ಲ.
We moved to
there is other urgencies matter is there.
ಎರಡು ಮೆಮೋನು ಹಾಕಿದ್ವಿ ಈ ಮ್ಯಾಟರ್ಗೂ ನಾಳೆ ಬರೋದ್ ಮ್ಯಾಟರ್ಗೂ ಎರಡೂನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆಗಿತ್ತು.
ಬರ್ಲಿ ನಾಳೆ ನೋಡ್ಕೊಂಡಣ. ಆಮೇಲೆ
ಅರ್ಜೆನ್ಸಿ ಇನ್ ದ ಮ್ಯಾಟರ್ ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿಲ್ಲ.
Thursday.
ನಾಳೆ ಬರ್ತಾ ಇದೆ ಸರ್ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಾಳೆ
ಬರ್ಲಿ ಅದನ್ನ ನೀಡೋಣ. Yes, then we will connect this matter.
For
Yes.
orders, serial number 31, decline Gomes for petitioner Archana.
For the respondent, my lords.
My lord, for the petitioner, my lord.
Copy may be served to me, my lords.
My lord, I will. Notice has not been issued, so post today I will. My lord, there's an office note that on the maintainability of the writ.
Yes, why?
My lord, the writ petition is arising out of the non-granting of an interim ex parte order. Therefore, my lord, the challenge to that can be maintained under Article 227.
No, that passed by which court?
My lord, City Civil Court, Court Hall number 14.
In a AA suit, my lords.
In an arbitration suit, my lord.
Arbitration application.
My lord, it's not arising out of the section 9 application. My lord, it is arising out of the 39 1 and 2. Therefore, my lord, my writ under 227 is maintainable.
As section 9 of the arbitration, code is section arbitration and conciliation. Nine. Any party may before or during the arbitration process, at any time after the making and after the award, or it enforcing. Oh, you have petition under 9.
Yes, my lord.
Yes, you serve the copy, we'll see that, yes.
They have to serve me the copies. I have not.
Serve a copy, we'll see.
My lord, may I make a submission, my lord? Actually, my lord, there's a little urgency. The respondents have issued an email seeking to cancel the plots. My lord, in fact, this is an this was supposed to be an amalgamated.
Monday.
Please.
Yes, Monday.
Obliged.
Yes.
Obliged.
Kind permission.
Yes.
Kind permission.
Yes.
Madam.
ಸಿವಿಲ್ ಮ್ಯಾಟರ್ CPC,
Hmm.
but it's a compromise. ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾಯ್ತು, ಪಾರ್ಟೀಸ್ ಬಂದಿರಲಿಲ್ಲ, ಎಲ್ಲಾ ಪಾರ್ಟೀಸ್ ಬಂದಿದ್ದಾರೆ. But it may be taken end of the list.
Yes, all that, who is other side?
I am appearing for one side, other side is also ready.
Ready?
ಎಲ್ಲರೂ ರೆಡಿ ಇದ್ದಾರೆ.
Yes.
Then serial number 43, my lords,
End of it.
End of.
serial number 43, I had moved the matter.
Yes.
But I have a matter in Gulbarga which is on compulsory VC, my lords. May I request this to be had tomorrow, my lord? Serial number 43.
43.
Yes,
Yes. Is
some
this matter
urgency.
tomorrow?
Great.
Yes.
That's serial number 40 minutes.
40.
I'm for the petitioner.
Yes.
That's the matter's infectious. I'd like to withdraw the matter.
Yes, learned counsel for the petitioner filed a memo seeking leave of this court to withdraw this petition. Dismissed as withdrawn.
40. ನಿಮ್ ಕೈ ಕೊಟ್ಟು ಯಾರಾದ್ರೂ junior ಕೈ ಕೊಟ್ಟು. ಬೇಗ ಬರ್ಬೇಕು.
ಸರ್ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ ಮಧ್ಯಾಹ್ನ? ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಮಧ್ಯಾಹ್ನ? 39 ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗೋದಲ್ಲ ಸರ್?
ಕೇಳು ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಏನೋ ಹೇಳಿದಾರೆ ಸರ್.
Serial number 54.
ಸರ್ ಹೋಗಿ ಹುಡುಗರು ಕಳ್ಸಿ. ಹೋದ್ ವಾರನೂ ಅದರಿಂದನೇ ಯಾವ್ದು ಬಂತು.
ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು ಯಾವತ್ತಪ್ಪ? 1724 ಆರ್ಪಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದು ಆರ್ಪಿ ಅಲೋ ಮಾಡಿದ್ರು ಸರಿನಾ? ಆರ್ಪಿ ಅಲೋ ಮೇಲೆ ಈ IS ಹಾಕಿದ್ರು. IS ಹಾಕಿದ್ಮೇಲೆ ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ಬೇಕಲ್ಲ?
ಯಾಕೆ ಸಾಹೇಬ್ರು ಕೇಳೋದು ಯಾಕೆ? ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಲ್ಲ, ಅದನ್ನ ಅವರೇ ಪ್ರೆಸ್ ಮಾಡ್ತಿಲ್ಲ. ನಮ್ಮ ಆಫೀಸ್ ಏನು ನನ್ನನ್ನು ಕೇಳಿದ್ರ
ಅಂದ್ರೆ ಒಂದೊಂದು ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕು.
ಹೌದು, ಪೆಂಡಿಂಗ್ ಇರೋ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ IS ಪೋಸ್ಟ್ ಮಾಡಕ್ ಯಾರು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದವ್ರು? ಲಾಸ್ಟ್ ಟೈಮು ಹಿಂಗೆ ಪೋಸ್ಟ್ ಮಾಡಿ
ಅಲ್ಲ, ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ IS ಹಾಕ್ತಾರೆ. ನಾವು
ಹಾಕಿದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿ ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ತಂದು
ಪ್ರತಿಯೊಂದನ್ನು ಅವ್ರು ಗಮನಕ್ಕೆ ತರ್ಬೇಕಾ? ಬಟ್ ನಮ್ಮ ಬೋರ್ಡ್ ಅವ್ರು ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, ಹಂಗೆ ಮಾಡಿದ್ರಂತೆ. ಸುಬಿಲೋನೇ ಇತ್ತಂತೆ ಅದು, ಅದನ್ನು ಹೇಳ್ತಾ ಇದಾರೆ ನಿಮ್ಮವರು. ಬಟ್ ಅವ್ರು ಯಾಕೆ ಅದನ್ನ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರು ಗೊತ್ತಿಲ್ಲ.
ಇವಾಗ ನಾನು ಎಲ್ಲಿ ಹೋಗಿ
ಸಾಹೇಬ್ರಿಗೆ
ಹೇಳ್ಬೇಕಾ?
ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ, ಇದ್ರ ಮೇಲೆಲ್ಲ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಸರ್.
ಆರ್ಡರ್ ಆಗೋದ್ ಬೇಡ, ಆರ್ಡರ್ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಿ ಸಾಹೇಬ್.
ಸೇಮ್ ಏನೋ ಒಂದ್ ಆಗ್ಬೇಕಲ್ಲ. ಸಾಹೇಬ್ರ ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ, ನಾನು ಏನು ಮಾಡಲ್ಲ, RP ಒಂದೇ ನಾನು ಮಾಡೋದು, ನೀನ್ ಯಾಕೆ ಇದನ್ನೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಂಗೆ ಅವೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅಂತ.
ಲಿಸ್ಟ್ ಮಾಡೋದಂದ್ರೆ ಸರ್, ಇವಾಗ ನಾನು ಹೇಳೋದು these applications are filed subsequent to disposal of RP. ಇವಾಗ ಯಾವ್ದೇ ಒಂದು ಕೇಸಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ನಾವ್ ಇಟ್ಕೊಳಂಗಿಲ್ವಲ್ಲ, ರೂಲ್ಸ್
ಕೊಡಂಗಿಲ್ಲ. ನೀವು ಇದೇ ಜಾಗದಲ್ಲಿ ಇದ್ದವರು ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ತಂದು ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು, ಇಷ್ಟೇ ಸಿಂಪಲ್. ಅವ್ರು ಕೇಳ್ತಿರೋದು ಇಷ್ಟೇ, ನಾನ್ ಗಮನಕ್ಕೆ ತಂದು ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಈಗ ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ. ಪ್ರತಿಯೊಂದು ಅಂತ ಅಲ್ಲ ರೀ ಮೇಡಮ್, ಯಾಕೆ ಹಿಂಗ್ ಮಾತಾಡ್ತೀರಾ? ಪ್ರತಿಯೊಂದು ಕರ್ಕೊಂಡ್ ಕೇಳೋಣ. RP ಅಲ್ಲ, ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಾಗ ನಾನ್ ಏನ್ ಮಾಡ್ಲೆ? ನಾನೇನ್ ಮಾಡಕ್ ಸಾಧ್ಯ? ಬೋರ್ಡ್ ಅಲ್ಲ, ನೀವು ಪೆಂಡಿಂಗ್ ನೋವು ಕೇಳಿ ಅದ್ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅಲ್ಲ. ಯಾವ್ದಾವ್ದು
ಹಾಕ್ಬಾರ್ದಿತ್ತು ಅಂತ ನನ್ನ ಜೊತೆನಲ್ಲಿ
ಒಂದೇ RP ಅಂತ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾರೆ.
ಬಟ್ ಕನೆಕ್ಟ್ ಮಾಡಿದಾರೆ.
ಸರಿ, ಅವ್ರು ಯಾರು ಕರೆಸಿ ನಾನು ಮಾತಾಡ್ತೀನಿ ಪಕ್ಕ. ಯಾಕೋ ನೀವು ಇಷ್ಟು ಬರೋ ಅಷ್ಟಿಲ್ಲ ಮ್ಯಾಥ್
ಫೈಲ್
ಅರ್ಥ ಆಗುತ್ತೆ. ಅವ್ರು ಬೇಡ ಅಲ್ಲ, ಪೆಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ತೋರಿಸಿದಾರಲ್ಲ, ಏನೇನೋ ಮಾಡಿದಾರೆ ಅದ್ರಲ್ಲಿ. ಅಲ್ಲ, ಅಷ್ಟೊಂದು ಎಲ್ಲಿ ಎತ್ಕೊಂಡು ಹೋಗ್ತೀರಾ ನೋಡಿ, ಬೇಗ ಹೋಗಿ. ನೀವು ನೋಡಿ, ಅವ್ರ ಗಮನಕ್ಕೆ ಹೋಗಿ
ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಗಮನಕ್ಕೆ ಹೋಗುತ್ತೆ.
ನಮ್ದಲ್ಲ ಸರ್,
ಮೇಡಮ್ ನಂದಲ್ಲ ಅಂದ್ರೆ ಈಗ ನಾನು ಸಾಹೇಬ್ರ ನಮ್ದಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗತ್ತ? ಹೇಳ್ಬೇಕು. ಸರ್ ಹೇಳಿ.
ನಂದು 26/8/11 22ನೇ ತಾರೀಕು ಮೂವ್ ಮಾಡಿದೆ, ಸಾಹೇಬ್ರಿಗೆ ಹೇಳೇ ಮೂವ್ ಮಾಡಿದೆ. 2011 ಮ್ಯಾಟ್ರು, ಸ್ಕೂಲ್ ಮ್ಯಾಟ್ರು ಅರ್ಜೆಂಟ್ ಇದೆ ಅಂತ ತಗೊಂಡು ಡೇಟ್ ಕೊಡಿ ಅಂದ್ರು. ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು 31ಕ್ಕೆ.
ಮೆಮೊ ನೋಡಿದ್ರಾ? ಮೆಮೊ ಇದೆಯಾ?
ಮೆಮೊ ಇದೆ.
ಹಾ.
ಪೆಂಡಿಂಗ್
ಇವತ್ತು ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ, ಇವತ್ತು RFA ದಿನ ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ ಅಷ್ಟೇ.
ನಾಳೆಗೆ
ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ನಾಳೆ ಇಲ್ಲ, ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರು ಎಲ್ಲಿಗೆ ಬಂದ್ರಿ ಬೋರ್ಡ್ ಇಂದ ವಾಪಸ್ ಕಳ್ಸವ್ರೆ. ನಾವು 4, 5 ಮಾತ್ರ ಇದು ಮಾಡೋದು ಅಂತ, ಪೋಸ್ಟ್ ಮಾಡೋದು ಅಂತ. 2004, 5 ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಮಾತ್ರ ಪೋಸ್ಟ್ ಮಾಡೋದು ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಬೋರ್ಡ್ಗೆ ಇದು ಪೆಂಡಿಂಗ್ ಕಳ್ಸಿದ್ದಾರೆ.
4, 5 ಮಾತ್ರ ಪೋಸ್ಟ್ ಮಾಡೋದು
ಅಂದ್ರೆ ಅವರು ಹೇಳಿದ್ದು
2004, 5.
ಹಾ,
ನಿಮ್ದೇನು
2011
ಹಿಯರಿಂಗ್?
ಹಾ,
ಹಿಯರಿಂಗ್ ನಾಳೆ ಯಾವ್ದು ಬರದೇ ಇಲ್ಲ. ನಾಳೆ ಅಂತೂ ಯಾವ್ದು ಬರಲ್ಲ.
ಗೊತ್ತು.
ನೀವ್ ಯಾವ್ದು ಕೇಳಕ್ ಹೋಗ್ಬೇಡಿ. ಕರೆಕ್ಟ್ ಸರ್, ನಾಳೆ ಬರಲ್ಲ. ಸಾಹೇಬ್ರೆ ರಿವರ್ಸ್ ಅವ್ರಿಗೆ ಹೇಳಿರೋದು, ಅದು ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ ಯಾವ್ದು ಹಾಕ್ಬಿಡಿ ಹಿಯರಿಂಗ್ ಅಂತ. ಕರೆಕ್ಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಅದಕ್ಕೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಟ್ರೈ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾಳೆ ಹೇಳ್ತೀನಿ, ಕೇಳಿಸ್ತೀನಿ. ಬೇರೆ ಅರ್ಧ ದಿವಸ ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಪಾಠ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ನೀವು ಬಂದ್ರು ಅಡ್ಜರ್ನ್ ಆಗುತ್ತೆ.
ಅಟ್ಲೀಸ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ
ಬೇಡ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ರು. ಈಗ್ಲೂ ಪೋರ್ಟಲ್ ಅಲ್ಲಿ ಹೋಗೋಕೆ ಅದನ್ನೇ ಹೇಳಿದ್ರು. ನಾಳೆ ಯಾವ ಏರಿಗೂ ಹಾಕ್ಸ್ಬೇಕು. ಹಂಗಿದ್ದಾಗ ಪಾಪ ಅವ್ರ ಹೆಂಗ್ ಆಗ್ತಾರೆ? ನಾನೇ ಹೇಳಿದ್ರು.
ನಾವೇನ್ ನಿಮ್ಗೆ ಕಾಣ್ತಾ ಇಲ್ಲ ಅನ್ಸರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ರೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತಾರೆ.
ಸಾಹೇಬ್ರು ಎಷ್ಟಕ್ಕೆ ಬಂದ್ರಿ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತದೆ. ನೀವು ಅದನ್ನ ಪರ್ಸ್ಯೂ ಮಾಡಿ.
ಅಲ್ಲ,
ಇವತ್ತು ನಾಳೆ ಮಾತ್ರ ಯಾವ್ದು ಬರಲ್ಲ ಹೇಳಿ.
ಎಷ್ಟಕ್ಕೆ ಬಂದ್ರಿ? ಅವ್ರು ಹಾಕಿದ್ದೀನಿ. ಎಷ್ಟಕ್ಕೆ ಬಂದ್ರಿ? 4 and 5 ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಹಾಕೊಡ್ತೀನಿ ಸರ್.
ಹಾಕಲ್ಲ ಸರ್, ನಿಮ್ದು ಒಂದೇ ಅಲ್ಲ, ಯಾವ್ದು
ಹಾಕೊಡ್ತಾರಂತೆ. ಬಟ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಾಳೆ ಹಾಕ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹಾ, ಇದನ್ನೇ ಅವ್ರಿಗೂ ಗೊತ್ತಾಯ್ತು. ಅವ್ರು ಇನ್ನೂ ಪ್ರೆಷರ್ ಮಾಡ್ತಾ ಇರೋದು ಏನಂದ್ರೆ 4 and 5 ಹೋಗ್ತಾ ಇದೆ, ನಮ್ದು ಯಾಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ನ.
ಕೆಲಸ ಮಾಡಿ, ಫೈನಲ್ ಇಯರಿಂಗ್ ಹಾಕೋದಾರೆ ನಮ್ದು ಹಾಕ್ಲಿ. ನಮ್ಗೇನ್ ರೀಚ್ ಆಗ್ತಿದ್ರು
ಹಂಗ ಹಾಕಕ್ಕಾಗಲ್ಲ ಸರ್. ನಾಳೆ ಯಾವ ಇಯರಿಂಗು ಬರಲ್ಲ. ಡೇಟ್ ಬಿಟ್ರೆ ಬೇರೆ ಯಾವ್ದು ಹಾಕ್ಬೇಡಿ ಅಂತ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ. ಮತ್ತೆ ಅವ್ರು ಹೆಂಗ ಆಗ್ತಾರೆ? ನಾನ್ ಹೆಂಗ್ ಹೋಗಿ ಹೇಳಿ?
ಯಾವ್ದೋ ಡೇಟ್
ಆಮೇಲೆ ನಿಮ್ದೇನು ಏನೋ ಆಮೇಲೆ ನಿಮ್ದೇನ್ ಸರ್?
ಅಲ್ಲಿ ಎಲ್ಲಿ ನಿಂತ್ಕೊಂಡಿದ್ದೀರಾ?
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಎಲ್ಲ ಈಗ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿ ಬೋರ್ಡ್ ನೋಡಿ ಸರ್, ನನ್ನೇ
ಬರ್ತಾ ಇಲ್ಲ
ಅಂದ್ರೆ 1ರಿಂದ 11ವರೆಗೂ ಕೆಟ್ಟೋಗಿದೆ. ಆಯ್ತು, 31 ಅರ್ಜೆಂಟ್ ಇದೆ. ಸಾಹೇಬ್ರು ಕರೀತಾ ಇರ್ತಾರೆ ನೋಡಿ, ಅಲ್ಲಿ ಅವ್ರು ಕುಂತಿದ್ದಾರೆ. ಹಾ, ಇದೆ ಸರ್. ಅದ ಆಮೇಲೆ ಬಮ್ಮ, ಇಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಸಾಹೇಬ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ನಾನು ಅದು ಕೊಡದೆ ಇವಾಗ ಅದನ್ನ ಸರ್ ಈ ವಾರ ಬರೋದಿಲ್ಲ. ಆಮೇಲೆ ಪಾಪ ನೀವು ಹೊಟ್ಟೋಗ್ಬಿಟ್ನ ಅಷ್ಟು ಬೇಗ? 5 ನಿಮಿಷ ತಾಳ್ಮೆ ಇಲ್ಲ. ಸಾಯಂಕಾಲನೂ ಹಂಗೆ ಮಾಡ್ತೀನಿ, ಬೆಳಿಗ್ಗೆನೂ ಹಂಗೆ ಮಾಡ್ತೀನಿ.
ಯಾವ್ದು ತೆಗೆದು ಸರ್? ಅದ್ರದ್ದು ಮೊದಲು ನೀವು ಉಲ್ಟಾ ಹಾಕೊಂಡ್ರೆ ಅದನ್ನ ಡೇಟ್ ಇದೆ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಅಲ್ಲಿಗೆ ಯಾವ್ದೋ ಒಂದು ಇನ್ನೊಂದು ಡೇಟ್ ಇದೆ ಅಂದ್ರಲ್ಲ?
ಇನ್ನೊಂದು ಡೇಟಾ? ಅದೇ ಕೊಟ್ಟನಲ್ಲ.
ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ, ಇದ್ರಲ್ಲಿ
ಹಾ, ಅದ್ರಲ್ಲಿ 23 ನಾಟೆ. ಇದೊಂದು ಇವಂದು ಹೇಳಿ ಸರ್. ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ ಅವಾಗ.
ಸೀರಿಯಲ್ ನಂಬರ್ 59 ಬರ್ತಿದೆಯಲ್ಲ 59.
ಹಾ. ನೀವ್ಯಾರು ಬರ್ದಿರೋದು? $42 ಹಾ. 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 ನಾಳೆ ಬರುತ್ತೆ ಇವತ್ತು RF ಡೇ, ಇದಕ್ಕೇನು ಹಾಕಿಲ್ಲ, ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ. ಸುಮ್ಮನೆ ಇವಾಗ ಇನ್ನೊಂದು ಕೊಟ್ರೆ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ. ಯಾರು ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡೋದು ಅವ್ರು ಕೇಳಿ ಮಾಡಿದ್ವಿ. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸರ್. ಇವಾಗ ಅದನ್ನ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ. ನೀವು ಮೆಮೋಗೆ ಡೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ, ಮೆಮೋ ಡೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಓಕೆ, ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಕ್ ಅದು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ. ಅದನ್ನ ತಿರ್ಗಾ ತಿದ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರೊಬ್ರೆ, ನಾವ್ಯಾರು ಅದನ್ನ ಇದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾವ್ದು ಬರ್ಲಿಲ್ವಾ? ಮತ್ತೊಂದು ನಿಂತಿದೆ. ಇಲ್ಲ 11ರಿಂದ 20ವರೆಗೂ ಏನೋ ವೈರ್ ಕಟ್ ಆಗುತ್ತೆ. ಸರಿ ಮಾಡಿದ್ವಿ ಅಂತಾರೆ, ಸರಿ ಹೋಗ್ತಾನೆ ಇಲ್ಲ ಅಂತಾರೆ. ಎಲ್ಲಿಂದ? ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು.
Serial number 43. And for the petitioner in that case, I've been told that at 1:30, the respondent has sought an adjournment for tomorrow.
43,
my lords.
yes,
I'm for the petitioner in that case.
yes,
They've asked for the matter to be taken up tomorrow.
yes.
I have some inconvenience tomorrow, my lord, if it may be fixed or any date next week.
I have informed other side.
I've informed the other side that I'll be asking for another date because there's an interim order in this as well, my lord. They've been restrained from withdrawing any amounts from a bank account.
Yes.
My request is interim order may be extended.
Yes, leave this matter next week. Interim order granted earlier is extended.
my lord.
Tomorrow. Next week.
With kind permission. One matter your lordships had directed to be listed on 29 yesterday. It is not listed. Trial court matter is on 3rd Monday.
That urgency.
No, petitioners have filed the application under order 16 rule 6. It has been dismissed. They are before this honorable court. They have to address the arguments, final arguments. They have moved this.
If they are not moved, why do
No,
you?
by stating that the matter is pending before this court,
Is there any stay here?
no stay.
Then
But
there
your
is-
lordships directed both of us to not to precipitate the matter.
No, is there any stay? You
No
said
stay,
no.
no stay.
Then,
But matter is posted before the trial court on 3rd. They may come and say that matter is pending before this honorable.
no, pendency is here, no. See, have you asked that orally, you have to be not to precipitate?
Yes,
this
yes, yes, yes.
Then that is their direction. Yes,
Correct.
you have to stay.
No, yesterday it was listed.
Yes, we'll have it on 4th, yes. Yes. Okay.
230 matter. Serial number 70. Devaya IS for petitioner, connected matter, SV Bhatt.
Yes. Yes, once it is password, it is difficult because list is there. Once I have started. Password, let us see. Yes.
Serial number 32, Venkatareddy CM for petitioner.
Yes.
Serial number 32, Venkatareddy CM.
Week's time is granted to do the needful.
Serial number 33, Shyamegowda HV for petitioner.
Well, I'm for the petitioner.
Yes.
Lords may recall I'd moved a memo for urgent listing of the matter. In spite of there being a specific direction to not change the nature of the property, they have gone ahead and they have put up a compound wall in blatant violation of the order passed by this honorable court.
Paper, number 104, we are not constructing any, not can be any.
Yes, you have filed any application?
I have filed an application. Well, it was filed on 27th January.
Hmm.
I have filed it.
What is that application?
Well, it's application.
Any copy.
A copy I have served it on post as well on that day itself.
You give the copy, let him answer that. If there is any violation, it is in a contempt, we'll see.
Well, Well, its contempt would be to punish him, Malats, for now to preserve the status quo of the property.
Now,
It
what
is-
is that order we have passed?
Malats, may kindly see the last order, Malats, of this honorable court. Dated I'm sorry,
Not to change the nature, properties, position.
please.
What
In,
else you
in
want?
any manner. No, Malats, I have got that order. Malats, may kindly see my application. They have gone ahead and put up a compound wall in my property.
Not to change that nature of the property, and what is that meaning?
Well, it's not to put up compound wall or anything.
No, not to change the nature of the properties doesn't mean that you can't put up that compound wall.
Well,
You
it's-
want one more order again.
No, indeed not. Malats,
Then
now changing that would amount to changing the nature. Malats, it was a vacant site, 2 sites. I, Malats, tried to get the property cleaned. I had filed the photographs as well. Malats, may kindly see those.
no, see, there is an order. Why do you want one more order? If that order is violated, you know what you have to do.
Malats, contempt to punish him, Malats, would be the appropriate recourse.
I can do, mister. Again, I have to pass an order. My order is going on violating.
May I request this, Malats?
Hmm.
Let the trial court is not all considering my application. My IA number 1 may be considered. I may be permitted to make appropriate application before the trial court as well, and it may be disposed of within a week, Malats. Anyway, my learned friend is
Is
also here.
that order you are challenging here?
Malats, with respect to not passing any order is concerned, Malats, may I kindly see page number
Not
22,
passing or your application for?
injunction 39-102 not to interfere.
Now the trial court is only issued notice.
Issued notice.
Now they are appeared.
Malats, what happened? They were on caveat. In spite of they being on caveat, I taking out notice to the caveat as advocate, a fresh wakalat is filed for a few defendants, and Malats intentionally avoided 4-5 times.
No, you are appearing for which? Who are that others, mister?
All family members, they have filed wakalat before the trial court. Notices,
No, all are appeared.
all are appeared before the trial court.
Then I will direct it to dispose of the.
Please, Malats, please, Malats.
Yes.
I number, please. I may be permitted to make appropriate application as well, Malats, regarding mandatory injunction before the trial court.
Yes, that whatever that application is that I will direct it to consider that.
Please, Malats. What has happened, I had sought for not to interfere. They have already interfered. They have put up a compound wall. That Malats relief might have become, but however, that may be decided on merits. I may also be permitted to file a fresh application for mandatory injunction.
Law permits for few filing an application for you file it.
Please, only
Yes,
for
why that-
expedited consideration of the same, Malats, because I have filed the suit 2 months back. It's not at all being considered. Even interim relief is not being considered.
No, I will direct, which is the
Expedited.
next date.
Malats, next date is on 18/2.
Yes.
18/2, it may be directed to be disposed of within a week. I'll advance the matter, Malats, and also file appropriate application after service of copies to the other side.
This petition is filed by plaintiff. Speaking. You are appearing for respondent number? 1 and 4. 1 and 4. So and so is undertaken to appear for 1 and 4.
Was already undertaken. Malats.
Section 2. Dispose of that IA number 1. IA number 1.
1, please.
IA number 1 filed under order 39 rule 1 and 2. In view of the above, service of notice to other respondent is not necessary. Plaintiff has filed a suit for
Injunction, Malats.
bare injunction. Along with that plaintiff, he has filed an application under order 39 rule 1 and 2, seeking ex parte temporary injunction. The trial court, without passing any order on IA, has issued a summons to the respondent, defendant. Learned counsel appearing for the plaintiff petitioner has submitted that all the defendant has served.
Please.
In view of the above,
And even wakalat has been filed, Malats, by them.
it's immaterial. If
Please.
it is served is enough.
Please.
Yes. Under these circumstances, the trial court is directed to dispose of that. What is that 12-12-24 order?
12-12-24 order is, Malats,
Only notice.
only notice to
Yes.
the remaining respondents who are unserved.
Yes. Trial court is directed to dispose of that application filed by the plaintiff under order 39 rule 1 and 2. In accordance with law by next date of hearing,
Malats,
18 or on or before end of February.
Please, my lords, I may be given liberty to advance the matter as well as file
Do
necessary.
whatever required, but they have to dispose within that end of February. Yes.
Grateful, my lords. Much obliged.
Serial number 34, Pradeep Nayak for petitioner.
Saturday, I have fixed that to all other matters and all. Next Thursday, 2:30. No, next Thursday means sixth. Sixth, alva, next Thursday, sixth, 2:30. 12th, 13th, yeah, 13th is the Thursday, yes. All other days, you know that GMCPC, lot of matter. Therefore, Thursday I fix it only for, I asked them to post some less matters on that. I still have that lot of list. But anyhow, that potted matter, I have to take it on. Yes, and then 13th, Mr. Hello, 13th.
Lord, the thing is, if it could be heard on an earlier date, because there's no stay and the compromise has been set aside. We
Yes,
concluded our arguments. Let it be heard on a date was specifically fixed today.
No, on 13th you have to. No, 13th you have to be complete that argument.
We've completed our entire set of arguments.
Yes,
Now
yes.
today it was
If there is
specifically
any-
scheduled for Mr. Raghavan to argue. As a matter of fact, he's in the I understand he's in the premises. He could conclude it today by request.
He was on his leg. I called him. His case was just called. That is the reason why he was made to stand there.
What about that on 6th to 5th?
My lord, whole of next week he would be otherwise busy. That is the reason why start for Saturday itself. We wanted to complete it on Saturday itself, day after tomorrow.
Saturday I have, because your matter on, I thought. it
Only,
is on
we
Thursday.
may not take much time, my lord.
All that has been, you said on 12th or 11th.
13th.
13th.
Yes, my lord.
Yes, 13th, 2:30.
Please, please.
13th, yes, 13th, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿ. Yes.
Serial number 34.
Here for the
Pradeep Nayak.
petitioner, Lords, all respondents have been served through court except R1, 2, 10 and 6. So far as R6 and R10 are concerned, I have served them by hand.
Yes.
R1 and 2, there's nobody, we were not able to locate them at that address.
Yes.
But it is the address in the sale deed that we are impugning. So notice may be issued to R1 and 2. 10 and 6 may be taken as served, my lords. I filed an affidavit of service as well.
10 and 6, hand summons is.
Hand
served.
summons is served.
Yes. Notable.
So far as R24, the noting in 3, R24 is deceased. Her children are R5 and 6.
Come one by one.
Please.
Now that 10 is served.
10 is served, ma'am. R3 has accepted service for all respondents.
R3. That notice was personally delivered to that R3 to 22.
R3 to 22.
1, 2.
R3 has accepted on behalf of all members. They all reside at the same location.
That's good. 1, 2 and 10 ಇದೆ. But they have given answers to the 3 2. ಅಲ್ಲಿಗೆ 1 and 2 has to be served now.
1 and 2 has to be served
Yes.
afresh.
Learned counsel for the petitioner has filed an affidavit and produced the acknowledgement having served hand summons to respondent number 10. Hence, service of notice to R10 is held sufficient. What about 1 and 2
Same for
now?
6, my lords. Same for 6 also, R10 and 6.
6 also, 6 ತೋರ್ಸಿದಾರಾ?
6 is there in number 5, my lords. Correct address to issue second time notice to R6.
Yes. R10 and 6
Please, ma'am.
hand summons is served, service held sufficient. Now it's left only 1 and 2.
1 and 2. 24, the point number 3, her children are R5 and 6. They are already on record. So her R24,
Learned counsel for petitioner has filed in a memo stating that respondent number 24 is dead, leaving behind who is
R5 and R6.
R5 and R6 are the LRs. Memo is taken on record. Respondent number 5 and 6 are treated as LRs of deceased respondent number 24. Learned counsel for the petitioner is permitted to amend the cast title. Now, 1 and 2.
1 and 2 has to be reissued.
Yes. Issue, week's time is granted to pay the process, issue notice to respondent number 1 and 2.
IO may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Serial
Malaj, on
number
the-
35.
Malaj, I want to point out on the last occasion, these orders were passed, the IO was not extended. The very next day, I filed a memo for extension. Therefore, though it was granted on the initial date, on the last occasion, your lordship,
Interim order granted earlier is extended till next date.
deeply obliged.
Serial number 35, Vardhaman V. Gunjal for petitioner.
Yes. Awaiting service of, yes, Mr. Gunjal.
After, I'll be fair, my lord, after the notice was issued,
Hmm.
I was permitted to cross-examine the plaintiff. No doubt it was a suit for partition, I was purchased the property in the year 1960.
Hmm.
Suit was in the year 2004. I unfortunately did not file my return statement, only when the defense evidence was in progress.
That in service,
my
and
submit-
summons is served. And
Sir,
summons is
no,
served.
no, I'm
madam.
making, I'm aware of it, my lord. We have, I served the hand summons served to the advocate, I have filed the memo also.
No, for the party,
Yes, I have paid.
not served.
They refused to take it. We have sent it by registered
No,
post.
have you filed
Yes.
a memo saying that they have
Yes.
refused to take?
Yes, I have paid the process also.
You file in a memo,
Lil- no,
then
no,
I will
right, fine.
take it that it is served. If there's a refused means it can be treated as service.
It's filed one.
Sorry. No, this is not. You have to file an affidavit.
Keeping that aside, my lord, I would like to make this submission. Since the matter is put for judgment today, I may given liberty, if the suit is dismissed, my lord, it's other issues. If the suit goes against me, liberty will be reserved to raise this ground in the appeal.
Yes.
With that decision, it could be disposed of, my lord.
Now, what is that we are challenging here?
Now, the learned judge has, when the defendant's trial was, cross-examination was going, my lord, I noticed that I had not filed the returns for nearly 16 years, 16, 17 years. It's a suit for partition, my lord. That application has been rejected. And consequently, the learned judge thereafter permitted me to cross-examine the plaintiff. That was done. And I also made my submission, this thing, my lord, filed my written arguments also. I was allowed to argue. That's it, my lord. In the meanwhile, after notice is issued, these things have developed. So fairly, I would like to submit, my lord, that instead of going on merits, my lord, if the suit is dismissed, there is no issue. If the suit is by chance decreed, my lord, for the plaintiff, I will permit to raise this ground in the appeal.
No, I want to know what is the ground.
Ground is, my
Because
lord, that
can't
after
raise all the grounds
16
in the
years, I
appeal.
cannot file the return statement.
You are not filed any return statement.
Yes, inadvertently it was left out.
No, can it be taken that as a ground in the appeal? That cannot be. Return statement should be there. See, written statement, non-filing of the written statement is not a ground in that appeal. That cannot be an appeal, filing an appeal.
Please, my lord. If that is so, my lord, then my submission would be this, my lord, I will have to argue on merits.
Yes. You file an affidavit that they have refused to take that copy
Please, my lord.
and summons.
We called on Monday, my lord, so I will file the affidavit in the
Please this matter.
Can I seek a stay of judgment, my lord, till then?
No, you will have it
It's
on
posed
Monday.
for judgment today.
No, therefore you file it today itself, that affidavit. Then I will take that, that is a ground for that. They are refused to take and forcing for an judgment. You file an affidavit.
I'll make, then your lordship kindly take
So, we
it.
file-
Tomorrow you may take it, my lord, I'll file the affidavit. Tomorrow it may be taken.
Yes,
Because affidavit will have to be properly worded. my lord.
yes, yes. Tomorrow.
Bill number 36, Prashant UT.
Here for petitioner in this case.
Yes.
Appearing for R2 in this matter, my lords. Lords, the property belonging to this petitioner has been sold, my lords, without even fixing the base price as well as, my lords, without even giving wide publicity, please. One submission, my lords.
IA2 of dispensation, production of certified copies, 3 of dispensation, production of entire copy of annexary, rectification of the office objection raised in the statement, objection filed by that 1 and 2. Yes, Mr. What is it?
One submission, my lords. A matter may be taken up anytime in the next week, my lords.
Yes, Mr. Next
My
week.
lords, My lords, what has happened means, now sale certificate, my lords, is subject to outcome of this writ petition. My lords, sale certificate is already registered. Now, very next application which they are going to file is, my lords, seeking delivery of possession. Let them not precedent regarding.
Interim
deliver-
order here.
No,
No, my lords.
it's subject to outcome of, my lords, this writ petition. Sale certificate shall be issued is what the direction has been issued by this honorable court on 23/8/2024 while passing an order. Now, my lords, sale certificate is already issued. Anyhow, it is subject to outcome of, my lords, writ petition. No, my lords, they will make an application seeking for delivery of possession.
Yes, Mr. Don't precipitate that.
Till next week, my lords. We don't
And my lord,
file any application, my lord.
kindly appreciate,
Next week.
they have also, my lords, withdrawn the amount as well. Withdrawn the amount deposited by second respondent who is auction purchaser.
I am the action purchaser, my lords. I have deposited the amount, whatever the bid amount, and also court has executed the
What
sale
is that you are
certificate.
challenging here?
My lords, what has happened means, my lords, trial court, without even fixing the base price of the property, has sold the property to 1/3 the market value, please.
No, what is that you are challenging that?
No, my lords, order 21 rule 90 application was filed seeking for setting aside sale.
On the ground of fraud and
Material irregularity causing substantial injustice, my lords, please.
that would be the case, no rights will be transferred to that action purchase.
Not only that, my lords, even wide publicity of, my lords, proclamation has not been given.
That will be wants type, yes. Till then not to precipitate, Mr. Dev.
No, my lord. Yes, ma'am.
Let there be an order to that effect, my lords. Let them,
No, my lords. I'll undertake. I'll not file any application, my lords.
That is there.
let that be recorded, please.
No, he is undertaking, you, why you want that order, Mr. He
My
is
lords,
saying that
tomorrow if he files an application, my lord, then, my lords,
you
I'll-
move that matter.
please, if that is the case, please.
Yes. Then we will grant absolute interim order, then he has no voice. Yes.
Kindly fix some date, my lords, please.
21. 7.
Okay, my lords.
Yes, leave this matter on 7.
Grateful.
That's all.
Yes.
Serial number
27.
7.
Here for us.
Steps
Serial number
against
7.
respondent 4 and 5 within a
That they
week.
are not necessary because I am the plaintiffs. They
Yes.
are the co-defendants. It is dispute between them and me.
I am the
And it is
petitioner.
a order under challenge is a granting of status quo order.
No,
That is
yeah,
granted
they
in
have
my
moved the matter.
Yes.
Yes, they had also filed an application for vacating stamp filing objections today. Matter may be had anytime next week. And
Yes,
the
that's what-
impleading application also, it's been allowed in the trial court. It may be allowed here. I'll file the amended petition also.
What is
Bank
that?
wants to come in as a respondent. In
Who-
a partition suit, bank wants to
And-
be added as a defendant.
Hmm.
They say that they, the necessary parties.
No, that
I
will
will-
hear, that will hear. Now that, what you want that?
Matter may be had next week. I'll
Next
take
week.
steps against respondent 4 and 5 also. Because they are not
Why yesterday,
established.
from yesterday it's come today then?
No, no.
Not yesterday, old man.
Old man.
Date given, yes. Yes.
Well, I have moved the memo, Milord.
You
Before
have
that-
moved that
Yes, I have moved because there is Milord, what has happened is there is an order excluding the alienation for one part-time property is granted in the interim order, by the interim order. So on the strength of that, Milord, they have sold many properties. I have produced the annexure R1, Milord, the EC.
The main
During
ground.
the
of-
pen- let me
Who are
complete, sir.
you?
I am the plaintiff.
You are suit for
Suit for partition, declaration of several gift deeds and release deeds.
release date. Who
Yes.
is he?
And he is the first plaintiff, is the wife of one Krishnamurthy, and he is the brother of first plaintiff.
What is that order challenging here?
Order challenge is granting an order of status quo by the trial court. Miller, what has happened is,
Now that, that order has been stayed here.
yes, except for item number 1, remaining properties, there is an order of status quo continued, which is granted by the trial court.
Item
Trial
number
court
1.
granted.
What is that item number 1?
My lord,
It is
item
a,
number I
develop the
property is
property.
my absolute property. They have not produced one document to show, they claim that it's
The
HUF.
suit for partition.
Not
is
one
pending.
document is produced to show. It is all my personal property,
You have taken a defense that it is your
personal property.
property.
In fact, there is an order by this honorable court that trial court will have to consider IA number 1 on merits. 7 months agide. Trial court has not considered IA
That
number
it is
1 on
because
merits.
of their own mistake. They have not filed a return statement.
And
No,
They
trial
have been
court-
dragging,
What?
pardon?
IA 1 for what?
IA
They
1
had
for
filed
temporary
it
injection, Milord.
temporary.
Injunction in written statement ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ ಅವ್ರು ಟೈಮ್ ಕೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಆಗಿದೆ
No, I
ಅದನ್ನ-
direct them, that is the only challenge.
Yes.
Direct them to dispose of that IA.
ಇಲ್ಲ till
There is
then, Milord,
already a
because-
direction, my lord.
Milord, my
Sir, that
responsibility.
order of 6/7/2024 ಏನದು?
Are granting an order of status quo?
Trial
What has
court
happened is-
has granted an injunction order on an application filed under section 151. That cannot be done is my submission.
Milord, before that, Milord, what
No.
has happened is,
Provision of law, it's different. Now that his application for temporary injunction, on that base, on that application, that status
court
quo has
has
been
said the status quo, maintain the parties to status quo.
status quo,
Yes.
that final order has not been
Not
passed.
been passed, they are not allowing to complete the procedure, argument
Matter
at
may
all.
be had next week.
We'll direct it to dispose of that IA itself.
Milord,
next
that is
week.
true, Milord, my respect submission is, there is an order, interim order that has been made by the Istanbul court, wherein they have been allowed to sell the item number 1 of the suit schedule property.
That,
Matter
where
may-
is that,
Interim order granted in this case, Milord.
no, not interim order, we will see that IA.
Milord,
on
IA
6
first,
6/7/2024 order. Where is that 6/7/2024?
My lord, it's at page number 235,
200 and,
34, my lord, 234, 235.
what is that order? Advocate defendant file an IA CPC seeking permission to condone that delay in filing in a written statement. File in a memo, advocates. Where is that? What is that order on that?
My lord, this honorable court had granted a status quo order,
Hmm.
had made it clear that independent of whatever we have observed, trial court will have to decide independently. Now, trial court extends the interim order granted by this honorable court.
See,
That cannot be done.
we'll direct, if that application is there, we'll direct the trial.
it is
court to
pending
dispose.
consideration.
Matter may be had next
Or
week.
that
my lord.
argument of the plaintiff on IA 8 and so on, so. No, which is, what is the date you are challenging? 6/7/20?
6/7/24.
It
It
is a
starts at 235,
6/7/24.
24, man.
Page number 235, Milord.
235.
6/7/24, ಏನ್ order ಅದು ಅಲ್ಲಿ?
The order granting is status quo, directing the parties to maintain status quo. Milord, what has happened is,
See, MD advocate filed a memo undertaking the defendant and summons defendant served in person called absent. Advocate for the plaintiff along with that. No, High Court. What is that writ petition? Idena?
11230, my lord.
Ah,
That
they
was the
are-
previous order. That's
that
at
was
page
filed by
2,
me.
That grant of. order
page
of temporary
211.
petition, Alienating that. He on the basis of the order passed by the Honorable Court, counsel for the defendant objected on the ground that so and so. Counsel for the plaintiff submitted that so and so.
My lord,
Otherwise,
please
the
see
rest of the
to
interim
page
order
217, my
passed by this
lord.
Parties are directed to maintain status quo. Next date of hearing. IA number 4 and 5, call on so and so. It is only that interim order is not made absolute.
yes, it is pending consideration of IA number 1. Parties are because there is already an order of status quo granted by the Istanbul
So
court.
and so. Counsel defendant plaintiff to. IML ಏನು next urgent ಆಗಿರೋದೇನೋ ತೋರಿಸ್ತಾನೆ ಇಲ್ಲಲ್ಲ.
Illa, urgent.
Order is passed till
Order is
today.
passed, it is been
No
executed.
order is passed till today.
On IA.
Yes,
Yes.
my lord.
Yes, we'll direct it to dispose of.
There is
that.
already a direction. Trial court is not abiding by the direction.
Why?
Milord, it is not so, Milord. They have taken
I will
time.
produce the
because
entire order sheet.
Return
my lord.
statements has been filed, return statement, they took time.
Hmm.
Then they have set up the bank people to come on record. They have filed an application and order 1
Now
full
all
time.
the defendants are served.
Yes, all the defendants are served and participating in the, before the trial court.
Date
It is on 6/3, Milord,
6/3.
please.
We'll directed that by that time they'll dispose of that application.
I'll take instructions. Matter may be had next week.
Yes. Yes, we will consider. On that day, we'll. No, now that there is no final order passed by the trial
Yes.
court, what we have to be decided here?
My lord, in fact, we had only
If I
requested.
decided anything, nothing but the deciding on that application which
only.
is pending.
Yes.
That the writ petition itself is not made because the granting of status quo is an order of restraint.
Yes, we'll direct them to dispose of that. Yes, yes, on that day we'll hear
Yes.
and this thing. Yes,
The date may kindly be fixed.
yes, when do you want?
Uh,
7th,
Please.
7th, yes. Where is this matter on 7th?
my lord, my request for is, 5th, my. Illದ್ರೆ 10th, 10th.
5th, yes. On 5th,
ಅವ್ರಿಗೆ
yes.
5th ಆಗಲ್ಲ. 10th,
You want 10th, yes, 10th.
interim order may be extended.
Yes, interim order granted earlier is extended till next date of it.
Cell number 38, Uday Prakash M for petitioner.
For petitioner, my lord, we need to take steps against the R3 has been deceased.
Yes,
I pray for a week's time.
yes. Steps to be taken in respect of refused R4, notice issued to that R4 written with postal shara, refused, then service of notice to R4 is held sufficient. At the request of counsel for the petitioner, 2 weeks time is granted to take steps in respect of deceased R3.
Obliged.
Serial number 39, Mithun GA for petitioner.
The petitioner minutes.
It's a-
Minutes,
it is- I have filed a wakalat for defendant respondent number 8A, impleading application of 8A, my lordship. And also wakalat for 7 and 11, my lordship.
Furnishing a PF issue notice to that R169.
My lords, I'll take steps, my lords, in that.
You take steps to.
My lordship, respondent number 10 had expired. In respect of her children of LRs, I have filed a wakalat, my lordship, in before this honorable court.
Who is that? R10.
R10, yes, my lordship.
Yes. Is it true, madam?
My lords, we haven't, my lords, I'll take.
Have you served the
instructions.
copy?
My lords.
Yes, my lord, I sent it through post, my lordship. However, I'll serve the copy on the other side.
Serve a copy.
Yes, my
If,
lordship.
respondent number 10 is dead, then instead of you filing an application, they are coming on record. We'll allow that.
My lords, I'll take instructions, my lords.
Yes.
Yes, my lordship.
Week's time is granted to do the needful. Yes.
Serial number 40.
Interim order may
disposed of-
kindly be extended, my
Interim
lords.
order granted earlier is extended till next date of hearing.
40 disposed of, 41 V Anand. 41,
Bench of the office objection, 2 weeks time is granted to comply office objection.
42 Abhishek MR.
Petitioner, my lord, all the objections are complied, minor objections. There's one particular objection regarding the maintainability. Lord, the Supreme Court decision, my lord, there are 3 observations made, my lord. First is the dismissal of the writ petition.
Objection yet to be complete. This writ petition be maintainable in view of that order. OS in number on IS 7 of 96. Yes, what is the order?
My lord, the order, my lord, says firstly that the writ petition which was dismissed based on the non-maintainability was set aside, my lord. The writ petition was remanded back to the High Court to pass an order based on merits. And third observation was, my lord, in case in that particular set of facts, if the writ petition is not maintainable, in that case, the 227 remedy, which is a constitutional remedy, cannot be taken away and appropriate orders can be passed through.
In this case,
In the Supreme Court decision, which is
you tell what is the facts.
My lord,
this case,
in-
Mr.
my
Now
lord,
I
in
heard
this-
that This matter has went Supreme Court.
the objection is raised on that.
You first tell me
My
that.
lord, the order under challenge is order
What is the suit for?
well, suit for declaration.
You filed in a suit for declaration.
No, I am the defendant before the trial court.
Defendant.
Yes, ma'am.
Yes, what is that order you are challenging?
Order 7 Rule 11 came to be dismissed, my lord.
Order 7?
7 Rule 11.
Then it is in a CRP.
My lord, here the
Then a judgment in every day they are filing. If it is, see, any application which is filed by order, if terminating that suit itself, then 227 is not maintainable. It is only that revision.
my lord, suit is not terminated here.
No, your application, suppose if it is application is allowed, rejection of the plaint,
Correct.
then it is a termination of the suit.
Correct.
Therefore, writ petition is not maintainable. Only you have to file in a revision.
But my application is rejected, my lord. Suit is not terminated.
No, that is what the effect of that order, if it is terminated, then you have to be filed. That is what that number of cases are there, Mr.
Yes, my lord.
And all cases are filing under the CRP only. That is why that office has been raised that up.
My lord, in this
See, any cases, if that application, pendency of the case, then only they can file. See that this thing.
I went through the order, my lord. Here the application is pending, suit is also pending, my lord.
No, that is what that effect of the order, if it is termination, then also you have to file in a CRP.
My lord, in this case, there's a patent illegality on the order because I'm just seeking for.
That can be challenged in that CRP also, Mr. Patent illegality cannot be challenged in that CRP.
But 227 is also available.
No, 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 that is not
ready.
there. That is the judgment is there on that.
My lord, the same judgment, Agarwal versus Sudhir Mohan, my lord. Same judgment, my lord, the Honorable Supreme Court says, remedy under Article 227 cannot be taken away. It is an absolute constitutional remedy. In that particular set of facts, if on the merits, it is found that 227 is violated.
Yes, we will have it Monday. We'll show that judgment.
Yes, my lord. Tuesday, my lord.
Tuesday, yes. Tuesday.
Hearing in, serial number 43 adjourned. Hearing
Note
interlocutor,
that point will.
serial number, hearing interlocutor application matter, serial number 44. Gopala Krishna N for appellate.
In this case, my lord, correction. Paragraph 11,
Yes.
paragraph 11, lordship was pleased to grant 1,42,500 towards loss of future income. That is not reflecting in tabular form and final order, my.
My lord, before that, my lord, my case is passed over.
We'll call it after
At
that,
4:30, judgment is likely to be passed.
4:30,
Yes, because trial court has posted the matter for 4:30, judgment.
judgment.
That's the reason I moved the matter. And
Yes.
there is one office objection which is complied with.
Yes,
If
wait, Mr. Gopal Krishna, I will take passover and we will come back.
If
What
I,
is-
Passover.
23, serial.
Last over matter. Serial number 20, Mahesh M.
My lords, I appear for the petitioner in this matter.
Yes.
My lord, the order under challenge is a rejection of an amendment application, which is filed by me.
Furnishing of death certificate of the plaintiff before the trial court. Adana. Who is plaintiff is dead.
No. Plaintiff, plaintiff one was the LR of the original plaintiff. She recently died, my lord, before passing of the order. So this case is not yet been taken before the lower court to implead her.
Where is the plaintiff?
Plaint is at page 39, my lord. Amended plaint is at page 41.
41. Yes, who is dead?
My lord, now the first original plaintiff was Nanjundappa. Then the LRs were brought on record in 2024. So Ratnamma, the LR number 1, died
Yes.
recently on 24/11/12/2024.
Ratnamma is
December
dead, huh?
24th, she died.
Yes.
Yes.
Yes, that's
So
all.
that was
Yes,
not
what
brought
is your
before
case?
the.
Yes, what is your case?
My lord, I had filed an amendment application to bring certain facts on record. My suit is for declaration of title because I perfected the title by adverse possession.
Hmm.
Now, what am I lord? This suit was filed in 1996 by my father, who's an illiterate, my lord. At that time, then there was a suit was dismissed for non-prosecution. It was brought before this High Court in 2027 and 2021. It was restored.
Yes.
When the matter was posted for evidence, my lord, the LRs note that the main fact was not brought in the plaint. That is, my lord, because when I claimed adverse possession, the fact that I need to prove that I am in possession of the property. My lord, the disputed property is adjacent property of my property, which was in possession of me from way long, from 60, 70 years.
Yes.
While converting my property, I had used this property also, which I claim adverse possession, and I have formed the sites in that property.
Now, what is that you are challenging?
No, the rejection of my amendment application.
What is that what is that amendment you sought?
That's what I mean. I sought an amendment to bring the fact that I have formed sites in the disputed property and I am in possession of the property. There are katas issued by the municipalities so far as that properties are concerned.
No, you are seeking for a suit for adverse possession.
Correct.
Yes.
I need to prove my possession from way long, 1994 only, before filing the suit.
When you have filed an application, Mr.
This I filed only in November 2024.
No, what is the stage?
Stage was it was posted for evidence.
Evidence.
Yes.
Why you have not taken this contention at the time of filing an plaint?
Well, at that time, my father, who was illiterate, has not brought the. He has said that I am in possession, but to prove that fact, he has not stated that I had formed the sites and a kata has been issued. But that fact was not inadvertently left out by the.
When your father died?
Father died way long, my lords.
Year 2014.
2014.
When you have filed an application for amendment?
Amendment 2024.
How many years after the death of your father?
My concern, my lord, when the father died, the suit was dismissed for non-prosecution and it was under challenge before this court in a writ petition in 2017.
Yes.
Because I had filed a miscellaneous, then MA I had filed. Then
What
I
is
came
the reason given by the trial court?
Reason, my lord, the trial court says that the fact which I want to bring changes the nature of the suit. It doesn't change the nature of the suit. That's my concern.
It's page number 32.
Page number
32.
32. What is stated about present?
Yeah, para number 11.
Declaration permanent.
On the last line of page number 11, my lord. Separately taken by the plaintiff will certainly change the nature of the
Yes.
suit.
Heard. Issue notice. Stay of further proceedings. In OS number 235 of 1996. Pending in the file of senior civil judge. JLFC Chintamani till next date of hearing.
Much obliged.
But already 3 decades over in that your suit, Mr.
I-
Still
I-
you don't
I-
want, yes,
Cell number
Obliged.
23,
Obliged,
Chandrana Tarigake.
yes.
Petitioner. My lord, the office objections are complied with except one, my
Here
lord,
to be filed, yes,
the IA
yes.
objections to the application for appointment of commissioner was not enclosed.
Yes.
That is placed before the
Yes.
court. Suit is one for,
One submission. I represent respondent number 4, my lord. I undertake to file wakalat, my lord. I'm representing Patta Panchayati, that is government.
No, they are saying that today it is posted for audit.
Please, it is
Then-
posted for judgment, my lord.
Yes.
Then it will become infructuous if I not grant any interim order.
My lord, may I take your honors to, my lord, they have the entire proceedings earlier to this writ
No,
petition, my lord.
You are ready
Please,
to argue.
Please, I'm
Wait, I will hear you.
please.
Yes,
my lord,
yes, Mr.
suit for a permanent injunction
Yes,
restraining the respondents. All respondents are all government, not the state by deputy commissioner, revenue inspector, village accountant, and Pattana Panchayat.
yes.
Plaintiff claims that A schedule, plaintiff A schedule at page 21, my lord. Page 21 is the A schedule. Plain A schedule is his work property, absolute property, to which B schedule is a kumki, that is lakti.
Yes,
On B schedule, it is the pleading that they have the right to enjoy B schedule as a privilege.
yes, Kumki land.
Kumki, yes, my lord. Kumki under section 79 of the land revenue. My lord, the Kumki privilege is not taken away by the deputy commissioner. There is no extinguishment of Kumki.
Yes,
The government, the officials try to enter upon the B schedule by
yes,
forming a road.
yes,
That was way back in 2015.
yes.
Then the plaintiffs filed this suit for permanent injunction. There is an order of status quo passed by this honorable court in operation. My lord, the written statement is filed and at present, an application for appointment of commissioner is filed. My lord, in between, there are various proceedings. Twice it has reached this honorable court.
Yes, when you have filed an application for.
Application was filed on 28/11/2024, annexure D.
2024.
Yes, my lord.
Now, what was the stage there?
The stage is after the evidence, my lord. After the evidence, because
That evidence has over.
evidence was over somewhere in October.
Yes,
October. And
Yes.
soon after that, this application is filed.
yes,
In the application I have stated at page 32, facts to be noted by the court commissioner.
32.
But it begins at page 31. 32.
Yes.
Facts to be noted. Number 2 may kindly be seen and number 4 may.
Yes,
To note that the A schedule property is agriculture land and portion of which consists the coconut garden, reservoir, thrashing yard, farmhouse, cattle shed, etc. And adjoining the A schedule property on its western side of the B schedule property is situate. That is identity of B schedule. Then kindly come to next item number 4. To note that the B schedule property is enclosed with the old mud dare with the thorny fence on its north, east and south, and to note that the entire suit A schedule and B schedule properties form a single compact block, because this is in the possession of the plaintiff since 60 years.
yes,
And it is by a single compact block. My lord, to note that there exists no road or pathway, much less public road of 15 feet width on any portion of suit A schedule property, or suit B schedule property.
Yes,
Then to note that property, that can be skipped, my lord.
yes.
Then 7, to note that the entire suit B schedule property and A schedule property are fully developed and there are only agricultural developments in the said property. 8, to measure and identify entire suit A schedule and B schedule properties and to show the name in the sketch to be prepared. My lord, this application, objection is filed and
Why it is rejected?
rejected because, my lord, I need to say, my lord, there was a direction in the MFA earlier that suit should be disposed of at the earliest.
Yes.
My lord, thereafter, the suit got transferred to another court. Where the suit was transferred, that court, without notice to the plaintiff, once a suit is transferred, a plaintiff and defendant should be notified. A memo was filed by the defendants that there is a date fixed by this honorable court, therefore you dispose of the suit. Without notice to the plaintiff, not to the counsel, the court straight away dismissed the suit, passed an order. That was questioned by me before this honorable court. The court under 226, my lord, though it is there was a decree, this honorable court took note of the fact that grave injustice is caused to the plaintiffs if it is not heard, took up the matter and set aside that order, remanded and directed the trial court to dispose it of within a particular period. My lord, what happened? The judge, the court wrote a letter to this honorable court requesting for extension of time. My lord, this court, there is no audience to me. This court said already court has fixed the time. Therefore, before 30th of...
No, matter when posted for extension, your name will be shown in that cast list.
But we have no say. It is between the letter by the...
No,
and I was not heard. That was... I was not heard. The court said letter is... It is second time.
What is the date of this thing? Court has granted time to dispose within that time.
My lord, 30th January
Hey,
2020. Today is the last date.
You could have filed an application for extension in that. You can file it.
My lord, because this itself was going on day by day.
No, unless...
Could have, my lord.
Otherwise, my order will be contrary to that earlier directions.
True, my lord, true. Therefore, the learned presiding...
Now also you can file an application before the court. These are all the instant. Therefore, time may be extended. Otherwise, see that position of the trial court.
No, that is why. That is why, man. Why this order came, it is under such a pressure, this court expressed that my hands...
That's what I'm understanding that.
My lord, if the court permits even now within half an hour, I shall make an application for extension. But there is this order stands, my lord, because the court's hands are bound because of that.
This will hear. Then in the meantime, you file an application there and brought to the notice of the court for extension. Then we will, otherwise...
I shall.
Yes.
Right now, I will send word and make an...
Yes.
This application, under those circumstances,
Yes, I can understand
without referring to the judgment, my lord, the recent judgment,
Yes,
which
yes,
my lord was referring earlier.
Yes.
Straight away, the court says it is collection of evidence. I shall make an application within half an hour. I will correspond with my counterpart. Under that circumstance, the court also was is bound by the earlier order. It was not. Therefore, the application came to be rejected. Is my respectful submission.
Yes.
If the court permits, I will make a submission before the court that tomorrow itself I will make an application,
Yes,
and
before the-
judgment may be deferred for a day or two.
Yes, the 2 days will let them do it there.
My lord, one submission. My lord, what is stating, my lord, 28/1/2024. My lord, earlier, my lord, they have, whenever the matter is posted for arguments, they used to come with an application. Totally, my lord, 56 application was filed by the plaintiff, my lord, till today. Whenever the matter is posted for arguments, other than that, my lord, on 2 occasions, my lord, matter was posted for judgment. There also, my lord, they have advanced the matter and they have recalled stage to address the arguments and also to lead additional evidence for the.
No, see, now they want only that.
And then, my lord, may kindly come to page 42 of the order of the.
Subject to that extension of the time will undertaken by the affidavit of the parties. They should not claim any further adjournment. And on the basis of that commissioner report also, they should not adduce any further evidence.
My only one submission,
Is
my lord.
for the purpose of that, helping the court to decide that.
Please.
Now, recent judgment said that it can be filed at, see, actually earlier, there was an understanding that commissioner application will be filed after that evidence. Now
Yes,
that
yes.
it can be filed at any time.
Anytime, and the guidelines are fixed. Under what circumstances a commissioner?
It can be issued and that commissioner can be appointed.
My lord, it's a suit for permanent injunction, my lord.
Yes.
Admittedly, my lord, survey number 172/1A is the government land. It's not a private land, my lord.
I do
Last
agree.
has adduced the evidence. They have not raised any objection during the course of past examination. They have not even suggested any suggestions for the Tahsildar. Then a village accountant has adduced evidence. Then chief officer of the Panchayat has addressed the adduced evidence, my lord. There they have not even made any attempt to file application during that time, my lord. And the matter is posted for judgment. They have filed application, and that too, my lord.
Now that whether that revenue authority is claiming the rights that it is a government land on the Kumki or not, that is
No,
the
my lord,
that is the
revenue record for this present year, my lord. RTC stands in the name of government, Sarkari Jaga.
No, is
Yes,
it?
my lord.
No, Kumki,
They have not referred to
B
Kumki, my lord.
Karab, these are all that government land. It is for the benefit of that adjacent land. owner. That is
Vargada.
what the-
My lord, that Kumki is not even referred in the revenue record from past 1964 to till today. There is no reference of Kumki in that said land.
Kumki is never referred.
Please.
It shows
It's a government land. There is no A Karab or B Karab in the said land.
My lord, because it is Sarkara, then only I have the right to claim that privilege.
No, which land is Kumki and all? How can you identify?
Schedule B is the Kumki
No,
to
no, no.
Schedule
In
A.
that revenue records,
Yes.
how will you identify that which is that government land, which is that Kumki land, which is your property?
Yes.
Your property,
Now,
it will
my
be
lord,
there in.
Yes, board standing orders of Madras, that lays down that if one is a Vargadar of a property, adjacent to his property, if there is a government land for 100 links in the government land, he gets the privilege. He gets only the privilege. He has no right. That privilege is under the board standing order. In the RTC, it will never be shown as Kumki. Kumki, because it is not a right, it's a privilege. We need to establish.
No, that is true.
Yes.
See, some area it is showing that Sappu Good Day.
Suppu Good Day. Yes.
Some area it is there
Yes.
Karab. It will not be shown in that RTC.
It will not be shown in the RTC.
Otherwise, all land adjacent to you can claim that government land is.
Therefore, it says 100 links from the work property. 100 links. That is what, in the 1974 judgment, Chandrasekhar's judgment, it says it's only a privilege which
No,
can
all
be.
properties adjacent to that, if it is a government land, from 100 links, that is a Kumki.
If it is used for the benefit of work property, not all the lands. Suppose there is a non-agriculture land adjacent to work.
That has to be established by that.
Yes.
My lord,
Yes.
the application for Kumki privilege, my lord, that was been dismissed by the DC, Deputy Commissioner, my lord.
Is it, Mr.?
Please,
My lord,
I will produce the document, my lord. If this honorable court permits, I will produce. Kindly have it tomorrow, my lords. I will produce those
My
documents.
lord, my lord, if I am permitted,
Yes.
Akrama Sakrama Committee has rejected the application for regularization.
Regularization, not that Kumki, it's not in a Kumki
Yes,
land.
the Kumki privilege can be.
You utilize, but you can't
Yes,
claim as a
Kumki
right.
privilege can be regulated only by the Deputy Commissioner. By withdrawing that privilege, extinguishment is permissible. If an extinguishment is permissible, that gives a right to the Vargadar to challenge that such an order. Here, there is no extinguishment. There is no
My
extinguishment.
lord, difficulty is, my lord, villagers are accessing the said road, my lord.
No,
That was blocked by the plaintiff by order of this honorable court. there is no access for the villagers to
No, no,
travel from
not
one
by
place
the
to another
orders of
place,
this
my lord.
court. Not
My
by
lords,
orders of this court.
may I take your honors to kindly take?
Now, are you cultivating that land?
Yes, I have stated so.
No, that Kumki land you
Yes, Kumki privileged property I am utilizing for better utilization of work property.
Can you give that way of that passing that villages, then problem will be solved.
Please, my lord.
My
That
lord.
is the reason. my
Otherwise,
lord.
tomorrow if you lose in that suit, you will lose entire Kumki extension property.
My lord, if there is if road is given, then the entire property is lost by itself. Because kindly see a schedule to the
My lord,
B,
my-
it's only
one
point.
small submission. One small submission.
Let him complete.
Please,
my lord,
Wait,
let
wait.
him-
You complete that.
My lord,
Yes.
schedule B may kindly be seen at page 21.
Yes.
That is 172/1A dry 0.70 acre. That is the
Only that.
only 70 cents. If that is, and the photographs were placed before the court in MFA, which would prove that there is no road at all. Now, somebody is behind me, my property. They want access to their property through this property. They have instigated the government officials to do all that.
No, that person has no other way to come to his.
He has. Not only he, others also have, others have not approached.
Yes.
And he also does.
Anyhow, that we will have it on Monday. In the meantime, you move that. Till then, I will direct it to defer that orders.
Please,
Yes.
please.
My lord, one submission. The road width is 80 feet, my lord. Length is 80 meter, width is 20 meters. That's it, my lord. 20 feet. That's it. What they are claiming 0.17 cents, which can be used by them, but only with respect to 80 feet width, my lord. They are obstructing the
No,
villagers.
that,
And they are not even allowing us to.
It will comes to how many feet? It covers entire extent.
No, my lord. Yes, my lord.
Yes.
Portion of the, it doesn't cross.
Goes by
straight.
corner of the property, my lord.
No, that's for you both to settle that matter. That is not the concern here.
My lord, even Tahsildar has adduced the evidence with respect to that only, my lord.
But
Not
when I have suggested, if the parties are ready to settle, you can approach the parties in that local, you can settle it.
We being a government undertaking, government authority, my lord, we cannot.
No. You are for a panchayat.
Please, my lord.
Yes, that is state government cannot go and this thing.
Yes.
Given any concession. Panchayat can sit and say that if anybody is even that owners, panchayat can settle that by convincing the parties to for a public purpose. You can leave that road and all. But if it is in a Kumki land, it is for the government to decide. Now that whether it is in a Kumki or not, it has to be decided.
It has to be decided by the court.
If it is a Kumki, then he has a right. Kumki right cannot be extinguished by the DC.
It can be extinguished by the deputy commissioner.
By order, DC can be do it.
Yes.
Already the application was rejected, my lord, deputy commissioner.
That is.
Application has been rejected for regularization.
Yes, Akrama committee.
That is different. That he claiming that I am a owner of that property. That means to say, grant that land for me.
Yes.
That has been rejected.
That has been rejected.
As long as he is there, he can utilize, but he cannot alienate that property. That is what that Kumki writes. Yes, heard. You will take notice to whom, Mr. Government
Respondent number
advocate is
4.
directed to take notice. 1 to 3. So and so learned counsel take notice to 4. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate and 1 set on so and so. Stay of further proceedings in OS number 68 of 2024. Pending in the file of Principal Civil Judge JMFC Kundapur. Till 5th, leave this matter on 4th. In the meantime, you get it this thing.
Please.
Serial number 29, G. Narayan.
Yes. In spite of granting 3 times to comply that office objection. Office objection is not complied. Suit is of year 2002. Order which is challenged this of year 2022. Even the matter is called in that morning session, none appears, even afternoon session, none appears, it appears. Petitioner is not interested in prosecuting, dismissed for non-prosecution.
Hearing interlocutory application matter, cell number 44, Gopal Krishna N. Parvati, appellant.
Appointment.
Balakumar.
In this case,
Yes, Mr. Gopal Krishna, what is this?
Paragraph 11, Lordship please to award 1,42,500 towards loss of future income. That is not reflecting in the tabular form and final order. That is left out.
Where is that?
Paragraph 11. 1,42,500 was awarded towards loss of future income. Earlier, no, the tribunal was not awarded any amount compensation towards
Para 11, 1,42,500 account loss of
future income. That is not reflecting in paragraph 16.
service report, upper limbs, so and so. Kumar Swamy, who is the evidence of report. Yes,
And
loss
also
of
in
future
the-
income 1,42,500.
500.
Yes.
And in final paragraph 17, order the climate
Legal expenses, so pain and suffering, nourishment to loss of income during the later period, loss of immunities, future, yes, madam, ಮುಂದೆ.
ಮತ್ತೆ ಫೈನಲ್ ಆರ್ಡರ್ ಇದೆ ಒಂದಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 17 ಅಲ್ಲಿ ಕ್ಲೈಮೇಟ್ ಎಂಟರ್ ಟೋಟಲ್ ಕಂಪನ್ಸೇಷನ್ 14
Loss of, yes.
ಅಲ್ಲಿ 15 lakhs 39 percent.
IA 1 of 2025 is filed for correction of the judgment dated 24 September 2024. In paragraph 11 of the judgment, court has awarded 1,42,500 rupees for loss of future income. In the operative portion, in the chart, that compensation in respect of loss of future income has been not included. The application is allowed. In the chart, loss of future income of rupees 1,42,500 has been awarded. And in the total allo bandilla?
ಬಂದಿಲ್ಲ.
Yes. A total ಮಾಡ್ಬಿಟ್ಟು. Total compensation awarded by the so and so is modified to so and so with interest. Yes.
Cell number 45, Srinivasa KN.
Yes. Where is Srinivas? None appears. Use this matter of 2 weeks, 4 weeks.
Cell number 46, adjourned. Cell number 47, Varun S for petitioner.
Yes.
Petitioner, my lords. Both are petitions arising out of 2 commercial suits that have been filed, my lords.
Yes.
Suits are by a bank for recovery of arrears from the borrower, my lords,
Yes.
till the time the suit was filed. And even for a period of
Why
8,
that IFR stay?
the my lords, matters next.
Of respondents.
I have served all the respondents, my lords. I wanted to inform my lords what the matter is about. Or should I take my lords through the affidavit of service too?
Yes,
So that
very
service is complete, my lords. I filed affidavit of service as well.
Served hand summons.
Served hand summons, my lords. R1, hand summons he has refused, my lords. Local bank official in Trivandrum has gone to him and tried to serve it upon him. He's refused, but he has acknowledged on WhatsApp, my lords.
Yes.
That, my lords, will find.
No, you have filed an affidavit to service of notice to 1 to 4.
I filed, my lords. It's
Yes.
on record. In both matters, I filed.
Learned counsel for petitioner has submitted that. A petitioner has filed an affidavit stating that court summons issued this court and summons issued to the respondent by order of this court on 15/1/2025. The respondents are refused to.
Respondent number.
Respondent, all respondents.
My lords, respondent number 1 has refused to take hand summons, but he has acknowledged on WhatsApp, my lords. I've just produced the screenshot there.
3, 4.
2 also, my lords, I have that address is not to be found. Again, I've served on the counsel and served by email as well, my lords. Counsel who appears in the trial court, I've served upon him, and in email, I've served the respondent number 2.
In service of, refused to take hand summons in service of notice to 1 to 4 is held sufficient. Yes, what is this matter?
Lords, Matter is very simple, my lords. My contention is that the counterclaim filed by the borrower, I was just apprising the court, my lords. I file a suit for recovery, my lords, on
Yes.
the ground that my borrower, he has taken a housing loan from me, but he has not repaid me, my lords.
Yes.
My lords, till the point that I filed the suit in March 22, up until the following year, my lords, he doesn't make a whisper about any counterclaim. Then for the very first time, as a counterblast to my suit, he files a counterclaim, my lords. Relief sought in that counterclaim. Would I please take, my lords? My primary contention, my,
That counterclaim application is filed.
I'm sorry, my lords.
Who has filed the counterclaim application?
Respond number 1, my lords, my borrower.
Yes, what is that, when that application is filed?
My lords, the application,
What the stage?
it's been disposed, my lords. It's been, he has filed a counterclaim. I filed an application seeking rejection on the ground of bar of limitation. That's been rejected and therefore we are before, my lords.
Yes.
My lords, my two grounds I'm urging
What is
based on,
that you are challenging here?
I'm challenging the impugned order, my lords, by way of which my rejection application has been dismissed. And I had taken two
Rejection of the plaint.
rejection of the counterclaim, my lord. Indeed, rejection of plaint in the counterclaim. I am
Yes.
the plaintiff, my lords. And he's,
Plaintiff.
yes, indeed,
No,
my lords.
you
Respondent
sought for rejection of the counterclaim.
filed by respondent number 1 before, my lords.
Yes.
And my grounds for seeking rejection were twofold, my lords. One was that it is barred by limitation grossly, my lords, 9 years.
No, his application
Please.
for is our additional written statement for counterclaim. He has filed a counterclaim along with that written statement or subsequently?
Along with the written statement. He has filed a counterclaim with the written statement, my lords. That
Now
is
you
not my
sought
ground.
for rejection of the
Rejection of the,
Yes.
please, my lord.
Where is your
Sorry, my lords.
application?
Perhaps I was not clear. May I please take my lords straight away to page number?
No, where
Wait.
is your application for?
My application seeking rejection on the grounds mentioned, my lords, page number 41, petition compilation.
41.
Please, ma'am. 42, my lords, will find the prayer portion of the application.
Yes.
Rejection of the counterclaim, my lords. I-
To reject that. Yes.
I have,
Why it is rejected?
my lords, the impugned order by way of which it is rejected, my lords will find.
First, on what ground you are sought for rejection of
Please,
the counterclaim?
please, my lords. The twofold, my lords. One is that the counterclaim is barred by limitation, grossly barred by about 9 years.
What is that relief sought in that counterclaim?
Relief sought, my lords, is declaratory relief. Declare that an instrument executed in 2015
Yes.
has to be read in such a way that it casts duties on the plaintiff. If I may just put this in context, my lords, I have filed a commercial suit asking for him to repay the due amount on the housing loan. His counterclaim is, no, I am not liable to repay the loan that I borrowed. It was the bank which had the duty to make sure to pursue the developer, make sure that the developer finishes the development of the scheduled property, hands it over in a very clean and neat manner to the borrower. And because the bank has not done it, he seeks a declaration going as far back as 2015, my lords. May I just point out where he mentions any whisper of a cause of action in his counterclaim, my lords?
Yes.
Because that, my lords, Article 58 of the Schedule to Limitation Act, 3 years from the date when the cause of action arises.
Yes.
Now, admittedly, where he says the cause of action arises, I'll just draw my lord's attention to. Kindly come, my lords, to page 21 of the petition. His counterclaim begins.
Yes.
My lords, have page 21. Now, my lords, may please take straight away page 27, my lords, may please come to.
Yes.
There is para 11, my lords.
Yes.
So, from the bottom, about the 6th line, my lords, ever since the year 2015.
Yes.
I just want to point out, admittedly, in his own counterclaim, when he says the cause of action
Para
arises.
13, 15.
My lords, para 11 on page 27.
No, 27 will come para 11, end of that para.
Please, end of that para, about 6 lines from the bottom, my lords.
Yes.
Ever since the year 2015, my lords have. From the bottom, about 6 or 7 lines.
No, in the para 11.
11, my lords, indeed.
In this way, the first defendant is causing a wrongful loss despite having.
My lords have para 11 of his counterclaim, my lords. Do my lords have para?
Page 27.
Page 27. Do my lords have para 11?
Yes, para 11.
Please. Para 11 starts, my lords, with the averments in para 12 of the plaint. Please. In that very same page, my lords, from the bottom about 6 or 7 lines, ever since the year 2015. Towards the,
It is not para page 27, it is page 26.
my lords have this.
Ever since 2015 is a para page 26.
My lords, there are 2 writ petitions. If my lords have, the contents are the same, my lords.
Yes,
I'm
yes.
sorry. I'm sorry for the inconvenience.
26, yes.
Please. My lords, it reads, ever since the year 2015, plaintiff, which is the bank, and the second defendant, who is the builder, knew very well about the personal aspects of the first defendant. So admittedly, my lords, he says in 2015 cause of action arises. My lords, if I may just give some
But
context.
you are not seeking any interim order.
My lords, I'm only seeking that his counterclaim be rejected.
Now that a final order has to be passed.
Fine, lord, but my lords, if it is my own suit, my lords, I'm
No,
seeking.
now that service is completed, their name has to be shown, then matter has to be posted.
Very well, my lords.
For the interim order, we can be considered, but no interim order can be granted in this case because it is your suit.
Quite so, my lords. Could any date before 5th, could it be given, my lords, before 5th? Because 5th is the next date. It's my own suit. About 20 lakh rupees is due from the borrower. But what's happened is they played mischief by filing a counterclaim. They have driven.
Yes, we'll have it on 5th.
Grateful, my lords.
5th, yes.
Deeply grateful.
Service said sufficient, another lock on, yes.
Yes.
Yes. In next matter also same.
Please.
Yes.
Cell number 49, Vandana PL for petitioner.
My lord, may I? Lord, I beg to, my lord, represent the counsel for the petitioner.
Yes.
My lords may kindly have, my lord, the order passed by this honorable court on, my lord, 2/8/2024. My lord, may I just read this, my lord? This order makes, my lord, things very clear.
Yes.
The learned counsel for senior counsel appearing for the petitioner draws attention of this court to the previous order dated 16/5/2024 and submits that the petitioner has undertaken before this court through its chief financial officer that the company will deposit 20 crore rupees with respondent Bbmp on or before so and so, out of which a sum of rupees 3.5 crores would be deposited on or before 1/6/24. Learned senior counsel submits that even before the completion of 31/7/24, the last date for payment of the entire amount of 20 crores as undertaken before this court with ARO Gandhinagar subdivision once again threatened the petitioner with the notice dated so and so stating that if an amount of rupees 31 crore is not paid under the OTS scheme, action will be taken to attach the immovable property, bank account, etc. Bbmp will initiate the criminal proceedings under section so and so of the Act. The learned senior counsel submits that firstly, it was impermissible for the ARO to have issued such a notice even prior to 31/7/24. Secondly, it is submitted that as undertaken before this court, the petitioner has deposited rupees 20 crores, the details of which has been given in paragraph number 4 of the affidavit. Learned counsel for so and so appearing for the Bbmp submits that on instructions, respondent has not deposited 20 crores as undertaken before the court. Nevertheless, this court is of the considered opinion that such statement cannot be made by the learned counsel without getting clarification at the hands of the concerned officer, having regard to the statement made in paragraph number 4 of the affidavit filed along with the application. It is also equally important to warn the officers concerned of the Bbmp not to take any action contrary to the orders passed by this court. When time was given to the petitioner company to make the payment before so and so, the ARO could not have issued such a notice on 24/7/24 calling upon the petitioner company to make payment beyond what was undertaken before this court. Having regard to the misadventure at the hands of the ARO, Gandhinagar, directions are hereby issued to the Chief Commissioner Bbmp to ensure that no notice is issued by the ARO or any other officer subordinate to the Chief Commissioner without permission of the Chief Commissioner of Bbmp. Release this matter on so and so. Needless to observe that no action whatsoever shall be taken by the respondent authorities in respect of the properties belonging to the petitioner company herein till the next date of hearing. My lord, this is what the case stands as of now. Kindly, my lord, see now what they will do, my lord. Annexed, my lord, now the IA which is filed. My lord, when this being, my lord, when, yes, my lord, this happened, my lord, on 7/8. In fact, all the amounts were deposited without cross-checking. They had made a statement. This honorable court reprimanded them. As of today, my lord, the matter stands at that. The matter is seized before the civil court.
What has happened on that 7/8?
On 7/8, my lord, they came to lock, my lord, the mall.
No. 7/8, what
Matter was adjourned.
The matter was urgent, my lord. The matter was urgent and it is pending before this very petition, my lord, which is pending before your lordships for consideration. Now kindly see, my lord, the fresh notice issued by them, which is filed along with the IA, which seeks for your lordship's consideration, my lord, urgently. My lord, fresh notice is dated 24/1/2025. My lord, last time Yes, last time they were warned. They will not do anything. They will not precipitate the matter as the matter is pending before two forums, my lord. One, before the civil court, where they had sought for, my lord, extinction of the suit under 711, which has been dismissed, and the suit is for evidence. Secondly, my lord, the one-time settlement scheme which was opted has already been agreed upon. Now, my lord, in spite of last time's warning, they would issue this notice, and kindly, my lord, go to page number, my lord, 14. My lord, internal page number 3. My lord, they would extract the tabular
Where
statement.
you are referring, madam? What is here?
My lord, I am referring at these annexures which is made with the IA, my lord. The fresh notice which they have issued. Page number 16 to the IA, my lord.
Yes, we'll see.
Page number 16 to the IA.
Yes.
Kindly, my lord, see this. First of all, this notice itself is contemptuous. On top of that, kindly, my lord, look at the audacity. On page number 16. ಪಾವತಿಸಿದ ಮೊತ್ತಗಳನ್ನು ಕಳೆದ ನಂತರ ಒಂದು ಬಾರಿ ಪರಿಹಾರ ಯೋಜನೆ, that is one time settlement, ಅವಧಿಯಲ್ಲಿ ಬಾಕಿ ಪಾವತಿಸಬೇಕಾಗಿದ್ದ ಮೊತ್ತದ ವಿವರ. Then, my lord, they would calculate the one-time settlement which is agreed upon by them from 2009-10 to 2024-25. The total amount, my lord, is about 13 crores 7 lakhs, which has already been paid in excess. Now, my lord, over and above, after this amount we have deposited as undertaken. Kindly, my lord, now see, my lord, the next column. ಒಂದು ಬಾರಿ ಪರಿಹಾರ ಯೋಜನೆ ಅವಧಿಯ ಮುಕ್ತಾಯದ ನಂತರ ಪಾವತಿಸಬೇಕಾಗಿರುವ ಮೊತ್ತದ ವಿವರ ಅಂತ ಹಾಕಿ, ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್, ಒನ್ಸ್ ಅಗೇನ್ 2009-10 ಇಂದಾನೆ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದು. 2024 ತನಕ 24-25 ತನಕ OTS ಆಗೋಗಿದೆ. OTS ಆಗೋಗಿರೋದನ್ನ ಬಿಟ್ಟು ಮತ್ತೆ ಇನ್ನೊಂದ್ಸಲ 2009 ಇಂದ 2010 ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಮತ್ತೆ 30 ಕೋಟಿ ನೀವು ನನಗೆ ಕೊಡಿ. My lord, when the matter is pending before this honorable court, and my lord, kindly see the audacity, my lord, what they would do. Page number 17, the last paragraph.
Yes.
ವ್ಯತ್ಯಾಸದ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ವಿಫಲರಾದಲ್ಲಿ ಬಾಕಿ ವಸೂಲಾತಿಗಾಗಿ ಪಾಲಿಕೆ ಕೆಳಗಿನಂತೆ ತೆಗೆದುಕೊಳ್ಳಬೇಕಾದ ಕ್ರಮಗಳಿಗೆ ನೀವೇ ಹೊಣೆಗಾರರಾಗಿರುತ್ತೀರಿ. ಇದಿಷ್ಟು 8 times till today they have locked them all, my lord, in the wee business hours of the day, unauthorized, my lord, by high-handed action. My lord, kindly see one order, my lord, one judgment passed by this honorable court on one of the occasions. My lord should kindly have writ petition page number 46, my lord. Writ petition page number 46. A judgment passed by this honorable court. I'll straight away take your lordships to, my lord, the operative portion which is on page number 50.
Yes.
The writ petition is allowed. The action of the respondents in locking, sealing and seizing Mantri Square Mall so and so is to hold to be one without authority of law. However, liberty is reserved to take coercive action against the Bbmp for non-payment of property tax in terms of 4 and 5 of section 148. 4 and 5 of section 148, my lord, remains the same. It only, my lord, permits them to take recovery process only with respect to movables. My lord, once again, this is, my lord, 8th time, my lord, they have done this. Last time, my lord, in spite of this order, they contempted and locked the premises. We paid, my lord, before this honorable court 20 crore rupees.
No, that every year you have to pay that tax.
My lord, every year we are paying. Kindly, my lord, look at the fresh notice which is issued, my lord.
Cannot be locked and seized mall at any time, even if it is next year, it is also not paid.
No, my lord, next year is not even due. Kindly, my lord, see the fresh notice, my lord, which I was.
This order passed by that writ petition for that year.
Yes.
It is not for ever.
ಇಲ್ಲ coercive steps ತಗೋಬಾರ್ದು ಅಂತ. Kindly, my lord, have the fresh notice, my lord. I have to, my lord, pay the taxes. It has to be paid. Please, my lord, have page number 16 of, my lord, the IA which is filed. My lord, till 24-25.
What is that?
One-time settlement is paid. It's clear. One-time settlement, it is paid and cleared.
What is the suit for?
Suit for, my lord, redetermining the, my lord, valuation, number one. Number two, my lord, they have.
Where is the plaintiff?
The plaintiff, my lords, may kindly find, if your lordships would kindly see, my lord, the TI order, the order sheet, my lord, of the writ petition, page number 51, my lord.
Yes.
My lord, there are two suits. Page number 51, my lords would kindly see the prayers extracted.
No,
in the teeth of all these things.
Only related to this case, you show me that which is the suit.
My lord, both are related to this very suit, my lord.
No.
If your lordships could kindly
there are
have,
two
my lord,
cases.
page number 112 of the writ petition.
No, here there is two cases or one case before me.
Only one case before your lordships, my lord.
Yes, yes. Now that, what is that suit for?
That suit is for, my lord, there are two different suits, my lord. Both are now, my lord, together. The relief claimed under the suit is the valuation which is done by the Bbmp authorities is without taking into consideration
Where is the plaint? I want to see that prayer.
my lord should kindly, my lord, have page number 112, my lord, 111, my lord, it is extracted. Page number 112 ಅಲ್ಲಿ.
Yes.
My lord, the entire background is extracted. If your lordships could kindly go to page number 113.
No, this is, which case you are referring, Mr. 113.
OS number 8510, my lord, 8501, order sheet. My lord, writ petition paper 113, my lord.
113 page is that some order, defendant including their
Yes, yes, my lord. Yes. ಅದು client ನನಗೆ ರೆಡಿಯಾಗಿ ಸಿಗ್ತಾ ಇಲ್ಲ. That is the reason, my lord,
I want to know that plaint, Mr. What is the prayer? What is that order you are challenged?
We will.
This application can be filed here? Yes.
Yes, my lord. Yes. Your lordships are right, my lord, in posing that question to me, my lord. I will satisfy your lordships on that.
Yes.
Now, my lords may kindly see the last order is very, very clear by this honorable court. In view of the fact that I have already deposited.
No, this is not a writ petition under 226.
Illa.
Application under application. It is 227, only order passed by the trial court on that I can be examined. Whether I can be examined that subsequent orders also.
In fact, greatly obliged, my lords put me a right question. Last time also ಅದನ್ನ ಇದನ್ನೇ ಕೇಳಿದ್ರು ಅವರು. ಆಗ this honorable court was pleased to say that this entire matter is now pending in a suit, the assessment, etc. Therefore, a writ petition was filed on GMCPC. Therefore, my lord, this honorable court, my lord, took up the matter to hear. In fact, this was precisely one of the objections raised by my learned friends on the other side.
GMCPC, it is only under 227.
Howdu. 227 only. Now, my lord, what they would do, last time also when the matter is pending, I deposited 20 crore rupees because this honorable court directed me to do that. This 20 crore rupees of deposit also, my lord.
Two things, Mr. Senior Counsel.
Yes, my lord.
227, any order passed by the trial court can be challenged.
Yes, my lord, yes.
This court has granted some interim order violating that. Again, they pass any order, it amounts to a contempt.
Yes, my lord.
Whether like in a writ petition under 226, you can file an application under 227 is the question.
In fact, my lord, I rightly your lordships put it across to me.
Therefore,
as a matter of strict.
We'll go to that plaint.
Howdu. My lord, if your lordships could kindly allow me, my lord, to take your lordships to the plaint. My lord, I am afraid if the plaint is, my lord, reproduced here, but certainly, my lord, we will place the plaint also.
Yes.
Plaint is not produced, my lord, with the petition.
That is that. How can that by application your writ petition is entertained? In all other cases, office objection has to be raised to that plaint.
Alla, my lord, ಆಗೇನಾಗಿತ್ತು ಅಂದ್ರೆ kindly, my lord, see the reason why the writ petition was entertained. Kindly, my lord, see what we challenged before this honorable court. If your lordships would kindly go to, my lord, the second order, which is on, my lord, page number 113. 113 order ಆಗಕ್ಕಿಂತ ಮುಂಚೆ, the civil court passed an order saying that civil court, my lord, while dealing with the suit, passed an order that I must immediately deposit before the Bbmp authorities all the money which was claimed by them.
We'll come one by one, step by step. First plaint,
yes, yes.
Then what is that order you are challenging is writ. Then we'll go that whether such application can be filed or not.
Agboth. May I request, my lord, it's a bit of urgency. Can I request this matter to be taken up tomorrow, my lord, so that we place the plaint?
Yes, tomorrow. Yes. Leave this matter tomorrow.
ಅದು 31ನೇ ತಾರೀಕು ಬಂದು ಹೊಡೆದಾಕ್ತಿವಿ. ಅದು ಇದು ಅಂತ only, my lord, urgent reason which prompted us to come before your lord.
Not tomorrow.
Tomorrow, my lord.
Tomorrow.
So grateful, my lord. I am greatly obliged.
No, tomorrow is an half day. Day after tomorrow,
My lord, tomorrow,
day after
ಅಲ್ಲ
tomorrow,
ನಾಳಿದ್ದು
Saturday
my
is
lord ಅವ್ರು ಬಂದು
sitting.
ಮತ್ತೆ ಲಾಕ್ ಆಗ್ಬೋದು my lord. But only thing is my lord, since they have my lord warned us on 31st ಒಳಗಡೆ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ ಬಂದು ಲಾಕ್ ಮಾಡ್ತೀವಿ ಅಂತ. That is the only, till then my lord, if they don't precipitate my lords may kindly take up on Saturday.
No, first we'll take it on Saturday, yes.
Serial number 50.
Till then my lord, let them not precipitate the matter my lord. 31ನೇ ತಾರೀಕು ಒಳಗೆ ಕಟ್ಟಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ.
Let us see on first, Muatan day, if they want to do it only on first. Till first, don't do anything, mister. We'll see on the first. First, let us see that I can entertain all these
Yes,
things.
yes, this oral direction is more than sufficient, my lord. My learned friend Karthikeya, my lord, is very fair, my lord.
Yes, yes.
We trust him.
Yes,
We trust
yes.
him. So grateful, my lord. So grateful, so grateful.
Serial
Petition,
number
Lord.
50, yes,
Please for a
petitioner,
All the respondents are here, my lord.
request for a date, my lord, in this matter.
Serial number?
50, my lord.
50, my lord.
Yes.
This is on our memo that we've got the matter listed before your lordship, my lord. All the
Date being
respondents.
fixed, my lord, senior is held up in court. all
No,
of
this is application filed for vacating.
vacating.
Yes, that's right. All,
And audience will be for them. Yes.
so all the
Yes, my
respondents
lord,
here,
date.
we are the respondent defendants. This matter can be disposed of very easily, my lord. But your lordship may have page 11.
Right, we'll see that, what is that urgency under, then.
Your lordship may have page 11 of the writ petition.
Yes.
That's the prayer. I just want to point out the prayer to my lord.
Yes.
A writ of certiorari or any other order, etc., to set aside order dated 6/4/2004,
Page number
11, my lord, of the writ petition.
11, it is not there.
Even without that prayer, I can just tell my lord in 2 minutes what this matter is.
Yes. Yes, you just explained.
Yes, a suit is filed by him against all of us. Now,
For what?
for setting aside a registered sale deed of 1971.
Yes.
He files it in 2024. But for a moment, I leave that aside. For a moment, I leave that aside. Now, what the trial court does is, it issues summons, but does not give any ad interim ex parte order under 39(1) and 2. Now, he's aggrieved by that. He files this writ petition. In that writ petition, he says, because I was not granted an ad interim ex parte injunction, please grant me that ad interim ex parte injunction. And this honorable court passes an order on 25/4/2024. If you're not have that
Yes,
order.
yes, what is that order?
Yes, it's a 2-line order, which is the reason why this matter can go very easily.
Yes,
Your lordship has it?
yes.
It says, issue emergent notice to the respondents. In the meantime, parties are directed not to alienate, encumber, create third-party rights over the suit, scheduled property till the next date of hearing. Liberty is reserved in favor of the respondents to seek modification or vacation of this order. Now, he files this writ petition.
No, now your application is pending there.
Yes,
All respondents appear.
please.
I will direct it to dispose of.
That's all. That's all.
Senior has to make.
That's
some
the only
submission, my lord.
request.
Kindly pass our, my lord, I'll bring.
Pass over, yes. That is what they, other than that, he can't make any,
That's all.
his application is there. Let him dispose of that application. That's
right.
How you can object it, Mr. Yes.
I don't know why he seeks.
Pass our, my lord.
Pass over, you ask.
Very well.
We can also, less this weight of this paper also. In that office, yes.
All I would request, my lord, is to simply observe that when the trial court is to dispose of his 39(1) and 2, it should do so uninfluenced by the fact that this court had granted an ex parte ad interim.
No.
That's all.
This is only for that limited period.
But that's right.
They have to be considered on merit.
So
Yes.
long as it is uninfluenced, I have nothing further to say.
Yes, we'll fix the date, next date of hearing, both has to be completed argument. Within that 2 or 3 weeks, let them pass an order.
In fact, on the 4th, the matter is listed for his reply on my 7/11. I have done my arguments there.
Yes.
On the 4th, he is to reply. He has already sought time to reply twice on my 7/11.
Then why can't you press for that?
I am pressing for that, and that matter is now listed on the 4th. Final opportunity granted to him to argue on 7/11.
Let him argue on that.
Quite right.
That IA is decided, then it's become.
Matter ends. But
Yes.
then my only respectful submission is, my lord, I don't want him to go before the trial court and say, Look, prima facie, the case exists. Why? Because the Honorable High Court granted this interim.
Let him come and say on 4th, we will going to argue on that application.
That's right.
Let them decide, then we can decide this. If that your IA is allowed and this become infructuous.
Alternatively, instead of keeping it pending before my lord passes the order which my lord just proposed. And as a matter of fact, that's the only order that can be passed.
Yes, yes, let us see, let it come, yes.
Cell number 51, Rakesh P. Bhatt for petitioner. SV Prakash.
Hearing for petitioner in this case.
Yes.
The IA is, my lord, seeking for dispensation of the impugned order annexure A, page 12, my lord. It is a copy uploaded from the net. I have produced, my lord.
Yes.
I will produce. My lord, facts of the case, my lord, is it is a divergent finding.
Yes.
My lord, suit filed by the respondent herein, who is a plaintiff.
Yes.
My lord, he sought for an injunction on the ground that, my lord, there was an agreement between my vendor and him that there should be a passage on the southern side of the property.
Suit for?
Suit for, my lord, injunction.
Yes.
Plaint is at, my lord, annexure C, page 36.
Yes. You are the defendant.
I am the defendant in the suit.
Yes. Now, what is that order you are challenging?
My lord, the order is divergent finding. The trial court rejected his application on the ground that, my lord, earlier he had filed 2 suits. There he had claimed on basis of different agreement.
Now
And-
that, what is that injunction he has sought?
My lord, not virtually, my lord, not to interfere with possession. That is not to construct on that passage area. But virtually, my lord, it is an injunction which is passed against me. Now, my building is constructed, which is half constructed, my lord, which is there.
Now
Annexure
that,
M.
what is that appellate court has said?
Appellate court, my lord. Appellate court has allowed the appeal and has granted injunction.
What is that injunction
My
granted?
lord, annexure, my lord, annexure A, my lord, page 31.
What is that order has passed?
Making any construction, my lord, the defendant is family members under them are hereby restrained from making any construction in the suit scheduled property till disposal of the suit.
What is that order passed by this court?
My lord, till
My lord.
today, my lord, there is no interim order. After lapse of 1 year,
No,
my lord,
what is that position of the construction?
Construction annexure M. Annexure M, my lord, page 92.
Yes, matter, it is halfway under the construction.
my lord, without adhering to the building plan, my lord,
No,
my property is situated, my lord.
you will say he can put up further construction in accordance with law after obtaining necessary, if there is any plan and all.
ಅಲ್ಲ
And-
ಪ್ಲಾನ್ ತಗೊಂಡಿದ್ದಾರೆ ಪ್ಲಾನ್ ತಗೊಂಡ್ಬಿಟ್ರು in violation of the plan.
They have challenged it. It is rejected.
That's why, my lord, this time.
No, we are saying that he has to put up in a construction in accordance with law after obtaining necessary permission from the competent authority. If you say that is not necessary, you deposit that amount. If you fails, what is the loss cost to him because of not construction, that has to be compensated.
My lord, my
Other-
respectful.
no, see, if it is permit, he can't claim any equity. Admittedly, he is constructing. If you want to construct, let him construct after taking all permission in accordance with law.
My lord, kindly have it next week any day.
Why?
My lord, my respectful submission, my lord, after hearing both,
See,
my respectful, my lord,
therefore, he is before this court.
after hearing both sides, my lord, this honorable court, my lord, not granted interim order. Because, my lord, your lordship kindly see the photographs. Himself produced the photographs. My lord, he without leaving setback, without.
Say, if there is any, without taking any permission from the competent authority, if it is constructing,
ಅಲ್ಲ ತಗೊಂಡು
liberty is also given to you, given a complaint to that competent
lord.
authority to take an action.
With respect to that, they have given the complaint. They have given the complaint, it is rejected, saying that it is in accordance with sanction plan, it is there.
Writ petition for what?
My lord, we have submitted representation to the municipality. My lord, they hand in glove with the petitioner. My lord, they have not taken any action against the
What has happened to
petitioner.
that writ petition?
My lord, that is pending
Where?
before this honorable court.
We'll call that writ petition along with this.
Please.
My lord, kindly, with respect to this, my
My lord.
simple submission, my lord, with respect to
No,
this,
they will
ME,
call that writ petition along with this.
please, my lord. My lord, if,
Leaves this matter.
No.
my lord, my construction,
Yes. We'll see that, Mister. If that writ petition is there, we can direct them to take an action in that also.
No, my lord, it is not representation. They had, my lord, they had filed an appeal saying that it is in it is,
Yes, I know that,
an order is passed saying that, my lord, it is in accordance with sanction plan. It is that order which is challenged before this honorable court in the parallel proceeding.
WP number.
in respect of that. Very good scheduled property. The writ petition is pending in WP number so and so. Leave this matter along with the so and so next week. Yes.
My lord, date may be fixed, my lord, from,
And 10th.
please, my lord.
Yes.
Much obliged.
Cell number 52, Iremated Maheshaya.
For the respondent.
Madhukar M. Deshpande.
My lords, in the last occasion, my lords have directed the petitioner to avail the remedy of stay before the coordinate bench, my lords. The RFA was listed day before yesterday, and after hearing, my lords, the coordinate bench has dismissed the stay application. So, my lords, my submission is that since the coordinate bench has dismissed the stay application, nothing survives in this writ petition, my lords. The only reason
No.
this writ petition was filed.
Let give the brief facts. I forgotten everything. Let give that. Yes.
Please.
Suit
Lord, this
for
is a-
specific performance, my lord.
You have filed a suit for?
No, my lord.
I have
The
filed a suit for
respondent filed a
specific
suit for
performance, my lords.
specific
I am the
One of them has to be argued. Wait, let him argue that his case. Yes.
Suit for specific performance filed by the respondent against the husband of the petitioner and present petitioners, my lord.
Yes.
During the pendency of the suit proceedings, my lord, husband of the first petitioner died, my lord. The present petitioner, since all the proceedings were managed by the husband of the petitioner, my lord, the petitioner could not approach the advocate, my lord, and the suit came to be decreed in favor of the respondent, my lord. Thereafter, the respondent filed execution petition, my lord. In execution petition, my lord, when the notice has been issued to the present petitioner, my lord, petitioner approached the honorable court and filed application for stay the further proceedings and for necessary application, my lord. That application came to be rejected and appointed the commissioner to execute the seal deed, my lord. Thereafter, the petitioner approached this honorable court by filing this petition, my lord, by saying that since huge delay occurred to file the appeal, some protection is need to the petitioner to protect the property, my lord, because the petitioner are today itself in possession of the property, my lord. This honorable court granted interim order, my lord, and I have filed RFA, first appeal, my lord. And a notice also issued to the present respondent appeared, and the court day before yesterday, my lord, allowed the application filed for condonation of delay, my lord, and dismissed the application for stay without going on merit, only simple reason by saying that since already seal deed has been executed by the court commissioner, nothing is survived for pending the stay application, my lord. This is a day before yesterday, my lord, without going on merits in first appeal, my lord.
Oh,
Thereafter,
I can't say that
No,
other
one
than
can
just
submission.
pass that
Yes,
matter,
no,
it's
no, no,
merit
one can
or not.
submission. My lord,
We have to
thereafter-
challenge
yes, my
it
lord.
before that.
Now,
That's
the
one
SLP is
submission.
pending before the honorable apex court, my lord. We have filed apex court SLP, my lord.
You go and approach that.
Because of that reason, my lord,
That's one
I
respected
request your
submission.
lordship to grant 2 weeks time, my lord, to get the, because my lord, now the SLP is, this is day before yesterday. This honorable court, coordinate bench of this honorable court passed an order in RFA, my lord, and we have filed SLP also, my lord.
Yes.
That is the reason, my lord.
Yes, let us see that the SLP is pending.
Really, to avoid multiplicity of proceedings, my lord, I request
If
your
that
lordship.
interim order is vacated, then SLP is allowed, then he will be.
Lords,
We'll
the-
wait for that. We'll grant
Lords,
to-
the only reason the writ petition was filed, seeking the interim relief of filing the RFA, my lords. My lords, for just a moment, my lords may kindly have the order dated 12 to
Merits ಮೇಲೆ ಇದುವರೆಗೂ ಏನು
2024.
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ appeal
12
ಅಲ್ಲಿ.
to 2024, my lords. The order passed by this honorable court. Lords, the only reason this honorable court has granted stay is for the limited purpose. I may be permitted to read the order dated 12 to.
ಆಯ್ತು RFA ಅಂತ ಹೇಳಿದ್ರು ಈಗ law provided for an appeal. Now this court,
ಅಲ್ಲ,
now
merits
I
ಮೇಲೆ-
have to pass
ಅಲ್ಲ,
that.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಬರೀ ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ ಮೇಲೆ
Technical
ಫಸ್ಟ್
ground
ಅಪೀಲ್
ಅಲ್ಲ,
ಅಲ್ಲಿ ಫಸ್ಟ್
ಸ್ವಾಮಿ,
ಅಪೀಲ್ ಅಲ್ಲಿ
the-
ನಾನು ಆರ್ಡರ್ ಶೀಟ್ ಕೂಡ ಹಾಕಿದ್ದೀನಿ. RFA
The
ಆರ್ಡರ್
only reason, my lords, this writ petition was filed only because of that, my lords, seeking the interim relief of filing RFA and getting stay order in the RFA, my lords. Since, my lords, both the remedy which is seeked by the petitioner.
Now that the SLP has been filed, he knows that he will raise such a objection. Therefore, 2 days only he has filed an SLP.
ಅಲ್ಲ,
My lords,
ಮೊನ್ನೆ
this is not
ಮೊನ್ನೆ
a case
ಸಂಜೆ
for
ಆರ್ಡರ್
filing
ಆಗಿರೋದು
the
ಸ್ವಾಮಿ ಅದು.
SLP, my lords. The decree was passed in the year 2022. And also, my lords, only after the in the execution proceedings, my lords, we have filed an application for the appointment of court commissioner. And after that, my lords, we have deposited the entire sale consideration and sale deed has been executed.
And after that, my lords, the RTCs are standing in my name. So only after the delivery of possession warrant, my lords, issued against the petitioner, they filed this writ petition.
But
seeking-
in the meantime, there is, her husband has died.
we have filed a memo stating that the defendant
Is not contested.
suit was contested, my lords. This is the statement, my lords, made by the petitioner before the coordinate bench also. It was not appreciated, my lords. I have filed the entire order sheet of the OS before the coordinate bench. And after that, my lords, the coordinate bench has passed a detailed order. I may be permitted to pass on the order, my lords, passed by the coordinate. ಹಾಕಿದ್ದಾರೆ.
Thing is observed by the coordinate bench of the honorable court in appeal. ಅದ್ರಲ್ಲಿ ನಾವು expert ಮತ್ತೊಂದು ಏನು observe ಮಾಡಿಲ್ಲ. Seal deed execute ಆಗಿದೆ, ಅದಕ್ಕೆ not fair by.
You may be permitted to contest before the coordinate bench, my lords. This writ petition, the prior mentioned in the writ petition itself is wrong, my lords. The
What is
petition, please, lords, may kindly have the prior column, my lords, mentioned in the writ petition. Page number 5, my lords.
Yes.
Where I may be permitted to read, my lords. The petitioners respectfully pray that this honorable court may be pleased to issue writ of certiorari quashing the order dated 59/23 passed by the first additional civil judge and JMFC at Davangere on IA filed by the respondent under section 151 of the CPC in execution number 54 of 21, produced at annexure A. Now, my lords, may kindly have annexure A, my lords. The page number 7, my lords.
What is that order he has challenged?
My lords, the prior which is mentioned in the writ petition is not concerned with the annexure, my lords. Because the annex,
Which is that 30th?
is challenging the annexure A, my lords. The order passed by the
No,
prior
where is
court-
that 30th 1/2024 order?
Please, my lords. That is at page number 12, my lords.
Yes.
That is the order passed by the executing court, my lords. We have after the sale deed has been executed, we have filed an application for the delivery of possession, my lords. And after hearing, my lords, the executing court has passed the delivery of possession warrant against the petitioner. And now, my lords, the petitioner has approached
Yes,
this order.
challenge that order.
Yes, challenge that order.
That is correct. Then that is what that is prayer.
Before the coordinate bench, my lords, he has to challenge the decree first, my lords. Initially, my
No,
lords,
degree has to be challenged before that other court. See, degree against that appeal lies.
appeal lies.
Here he has filed an appeal.
Please, my lords.
In the meantime, you have filed an execution. Any
Not
order
in the
passed in
meantime, not in the meantime, my lords, immediately after the
degree ಆಗಕ್ಕಿಂತ ಮುಂಚೆನೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. You have filed an execution. Against that, any order passed under that execution court on interim application, writ is maintainable before this court.
It is maintainable, my lords.
But the wording is not correct. He sought certiorari, it is not certiorari. But anyhow, you have challenged that order. Seek for an set aside in that. It is not 226, 227. But ultimately, order is that he has to challenging that order dated 30th 1/2024.
31/24, my lords.
Correct. That is the order which is passed in favor of you.
Passed in my favor, my lords.
That he has challenged. Nothing wrong with that.
ಸಾಲಕ್ಕೆ ಅಂತ 6 ಲಕ್ಷ ತಗೊಂಡಿದ್ದೆ. With interest ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. 60 ಲಕ್ಷ ರೂಪಾಯಿ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ. That is the fact.
No, we are not concerned that there is a degree against you. Yes, we'll grant 2 weeks time. In the meantime, you have, yes. But the request of counsel for the petitioner as a last chance, leave this matter up to 2 weeks.
No, sir, date may be fixed, my lords.
On 18th. Yes,
Please.
18th February.
Bill number 53, C. Shankar Reddy for petitioner.
Permission to come on records of LRs of deceased petitioner number 2. Yes. Petitioner number 2 is dead. What is the relationship between the LRs and the, who are the LRs, Mr. Wife and son? Who is appearing for other side?
Respondent served unrepresented.
Yes. IA 1 of 2022 is filed for. Yes, filed for permission to LRs of petitioner number 2 to come on record. Peruse that affidavit for the reason stated in that accompanying affidavit. IA 1 of 2022 is allowed. LRs of deceased petitioner number 2 is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cast title. What about that deceased R4 and 5? Yes. 2 weeks time is granted to file necessary application to bring LRs of R4 and R5. 13 again. Yes, weeks time is granted to pay the process to issue notice to 13.
234 matter, serial number 1, Umashankar MN.
Yes, what is the suit for, Mr.? Now, what is that order you are challenging?
Deposit, we sought for deposit of parent securities. So rejected. Proceedings of stay. Now some of the dependents have already compromised the matter.
Yes.
When the order, 15.
Yes. Page number?
15.
Yes. You are the plaintiff. Suit for specific performance. Yes.
Disposal of the suit at the first hearing.
Suit for first hearing, yes.
What is not at issue? And where at the first hearing of a suit, it appears that the parties are not at issue on any question of law or fact. The court may once pronounce the judgment.
Yes.
On next minute, one of several defendants not at issue, where there are no defendants than one, and any one of the defendants is not at issue. With the plaintiff on any question of law or fact, the court may at once pronounce the judgment for or against such a defendant, and the suit shall proceed only against the other defendants.
Yes.
Whenever a judgment is pronounced under this rule, a decree shall be drawn up in accordance with such judgment, and decree shall bear the date on which the judgment was pronounced.
Yes.
Now, in the next 3 minutes, parties are at issue. Where the parties are at issue on some question of law or fact, issues have been framed by the court hearing after the court provided. If the court is satisfied that no further argument or evidence, then the parties can at once adduce required upon such of issues as well sufficient for the decision of the suit, and no injustice will result from the proceeding with the court forthwith. The court may proceed to determine such issue, and if the finding thereon is sufficient for the decision, may pronounce the judgment accordingly, whether the summons has been issued for the settlement of issues only or final disposal of the suit. And now, because can you take a compromise decision? That is why I filed application at page 10, at page 5.
Yes.
At page 5 and application.
Yes.
15 rule 2, that is section 151, that is article 226.
Yes.
And I've stated that now the defendants fighting event are not at an issue with the plaintiff.
Now, where is your plaint?
Plaintiff, not a plaintiff injury.
Now, you can make out in that page 21.
Yes, ma'am.
No, page 21 al obre idare. Now, you have filed in a suit. Who has executed that sale agreement?
A sale agreement is executed by defendant number 1 to 11.
That means respondent number 1 to 11.
Yes, ma'am.
They are there.
All of them are here, except defendant number 1 to 4. Ma'am.
Who are 1 to 4?
1 to 4 are also signatories. They will also make compromise in future.
Yes.
Literally, defendant number 4 to 11 minutes, they are ready for compromise. And the 11 and 11 to 14 are formal parties. That will come, they are not signatories to the agreement of sale. No, under the agreement of sale, you have to come take page 18.
Yes.
Page 18, para 10 minutes.
Yes. Page 18.
18, para 10.
Page 18 of what?
18 of compromise. ಅಲ್ಲಿ 18 ಅಲ್ಲಿ
Correct. 18 and 10 ಬರಲ್ಲ. 18 is the affidavit ಏನೋ ಇದೆ.
affidavit ಅಲ್ಲೇ ಸ್ವಲ್ಪ. Compromise petition start from page 10 minutes.
ಇದು writ petition and ಇದು compromise. Yes. Page
18.
Yes. Yes.
10. The subject subsequently from time to time, the sale consultation has been enhanced under the 6 agreements of sale.
Yes.
There it is mentioned as 29/1999, 30/10/2009, 23/2014, 25/3/2015, 16/2006, 15/2/2017. And below that, in respect of distribution, it is submitted the petitioner has paid the following amounts. The respondent hearing under the 6 agreement of sale, and respondent has received the sale in witnesses. The total is 1 lakh, 1 crore 65 lakhs below.
Other next page, next page. In the submit of the total sale consideration amount has been enhanced from 20 lakhs to 3,76,000, 3 crore 76,000, 80,000. And the balance sale consideration amount of 2 to 11 lakhs 80,000. But this now under the agreement of say 3 groups are there.
Yes.
2 groups are before the submitted. One group they will come. My respective submission is to the 2 groups, both of all the 2 groups have signed the compromise petition and at page 21.
Yes.
Page 21 only, and we are giving them the balance sale consideration amount. Para 7.
Yes.
70 lakh 60,000 each.
Yes.
70 lakh 60,000 they have accepted.
Yes.
And then, since these parties are not at all an issue, but since proceedings have been stayed, therefore our compromise petition is filed before the Assembly court. So we will submit the same before the trial court. But that is the petition is pending. And this compromise can be recorded. And
No, only in respect of that.
respondents file to 11.
Now, what is that order you are challenging in this writ petition?
The permission sought to deposit the sale consideration amount, the balance sale consideration.
Yes. Now that amount you are giving, distributing that parts.
That's all. And they are ready to execute the registered sale if, as and when the 1, 2, 3, 1, 2, 4 are ready. They may execute for both. The local council is also here.
Yes.
They also find the Wakala.
Yes.
Therefore, my respective submission is, in respect of these persons, a decree may be drawn, direction may be issued to the trial court to draw the decree.
Yes.
And rest of it, my lord, they will also come and file another compromise petition.
No, but what is that effect? You can't get it, say, sale deed.
That cannot be done, but compromise will not allow today after the
Yes. Tell it.
DDs, the parties, all the parties are present, 2 DDs in their favor.
No, you are appearing for
5 to 11.
5 to?
5 to 11.
5 to 11.
Yes, sir.
All 5 to 11 are agreed.
Agree.
5 to 11 you are representing, Allah.
Yes, sir.
Allige 12, 13, 14.
1 to 4.
One.
Only one important.
Yes, we'll dispose of this and you do it remaining in the trial court, or you will.
Some may be disposed of. Direction to draw the decree. But in respect of that, 1 to 4 and 11 to 15, we go through. That will also be done.
Yes. No, that we can do it in the trial court if they come for an agreement. Why you have to pen this writ petition?
Not necessarily.
Yes.
Not necessarily.
Writ petition. Yes. This petition is filed by plaintiff. You are mentioned in that compromise, you are giving that. Yes. Yes. Filed. This writ petition under 227 of Constitution of India, challenging, seeking direction. What is that challenging that order dated? By examination, what is that relief in this writ petition? Calling the records of so and so, file and a learned additional judge and examine the same. Watch that 11/9/2023 order another.
Although not rejection of application.
Because,
Deposit of.
yes, seeking, set aside that order dated 11/9/2023, passed on IA number 3 in OS number 30 of 2023, passed by learned additional senior civil judge JMFC Chandrapatna. This court on 10/1/2023 has issued notice to the respondent. Further proceedings in OS number 30 of 2023 is stayed till next date of hearing. So and so learned counsel has filed a wakalat for respondent number 5.
5 to 11.
5 to 11. Now only 5 to 11 has agreed for settlement.
Yes, yes.
Yes. The respondent number, the petitioner and respondent number 5 to 11 has settled that matter and they have filed a compromise petition under order 15 rule 2 read with section 151 of CPC and 227 of Constitution of India. The parties, the petitioner and respondent number 5 to 11 are present before this court. They have been represented by their counsel and they have been recognized by their counsel. They have submitted that. Bane. ಬೇಡ ಅವ್ರು ಯಾಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲ ಅದಕ್ಕೆ ಬಿಲ್ ಅಪಿಯರ್ ಆಗಿ ಯಾಕೆ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮತ್ತೆ ಬೇಡ ಅದೇನೆ ಎಸ್ ಎಲ್ಲರೂ ಒಪ್ಕೊಂಡಿದ್ದೀರಲ್ಲ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್ ಆಲ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 to 11 they are submitted that they are agreed for that settlement. The compromise petition is taken on record. Same is extracted below. The above petition is disposed of. The trial court is directed to draw a degree in respect of only in respect of defendant number 5, 6, 5 to 11. Yes. In respect of other parties is concerned, suit may be continued if the parties filed in a compromise petition. Same may also be considered in accordance with. Yes, with that, wakalat is taken on record. With that observation, writ petition is disposed of. For where? What is the next date there in the trial court? You prepare ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ ಹಾಕೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲ any date if you say I will direct it to appear on that trial. ಅದು ಕೊಟ್ಬಿಡಿ ಅವರು ಡಿಟಿ ಸಿಗ್ನೇಚರ್ ಫಸ್ಟಿಗೆ ಆಗಲ್ಲ ಆರ್ಡರ್ ಎಲ್ಲ ಹೋಗ್ಬೇಕಲ್ಲ. ಆನ್ 11th 12th ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ತಗೊಳ್ಳಿ. ಆರ್ ಎನಿ ಸ್ಯಾಟರ್ಡೆ 15th. Parties are directed to be appear before the trial court on 15th. Yes, without any further notice. Yes. 50? Correct.
Serial number 50. Passed over matter, serial number 50, signature. Passed over matter, serial number 50, Rajshekhar S.
Yes, where is Rash? No, that is what you have to get instruction. We will dispose of in your favor. Writ petition will be allowed.
Quite right.
No, you are allowing that writ petition. You have to ask your senior. What is that? Huh? No. This is not that any complicated matter. Yes. On 4th, you get instruction. We will dispose of the matter. This is what the court has observed. Tell him that we will
I
have
thought
that.
may have it on the 3rd in that case, because on the 4th, the matter is listed before the
Yes, 3rd. Yes, 3rd. We'll dispose of that. Yes.
May I make an extraordinary request, Lord? I come from Delhi to assist my lord. Would your lordship consider having it at 2:30? It's a very short matter.
No, you appear through VC. You need not come here.
I shall be here because I have to travel to Mysore for that matter.
Yes.
So, which is the reason why I was only subject to what my lord says.
Yes, Monday, it's 2:30.
2:30.
2:30, it will not come in that list 2:30, but matter if it is reached earlier, it will pass out to 2:30. Yes.
Very
I
well.
think your presence is also not necessary. It is only.
I believe so. Your lordship.
Let us see, it is for your convenience. Yes.
But I'm so obliged.
Yes. Yes. Interim order granted earlier is extended till next date of hearing. Leave this matter on 4th. Yes.
On 3rd, my lord.
No, 3rd, please.
B group matter, serial number 54, Hari Krishna Pramod for petitioner, Vardarajan MS.
Writ petition arises out of a dismissal of an order 7 rule 10 application. The application has been filed on the premise that the suit is a commercial suit and therefore has to be prosecuted before the commercial courts. Kindly look at the impugned order. The impugned order is at page 16 of my petition.
No, it is filed before that regular court.
It is filed before a regular. The suit is pending before the city civil court. My
pre-act-
contention is that it has to go before the commercial court.
Pre-act suit.
No, your application under Order 7 Rule 11 is dismissed.
7 Rule 10 for return of plaint.
Return of.
Return of plaint.
Yes. Now, what is that? On what ground you are saying that it is not maintainable?
Kindly come to the impugned order itself. The impugned order page starts at page 16. The reasons start at page 19.
Suit for?
It is a suit for damages arising out of a lease agreement. The lease agreement admittedly is for a commercial property. Kindly come to page 19. 19 is the reasons in the impugned order. At the bottom of the page, your lordships will see para 10.
Page 19.
Page 19, para 10.
Yes.
On the bottom of page 19, para 10.
Yes.
This suit is filed by the plaintiff against the defendant for recovery of a sum of rupees 1,20,31,348 as damages and interest on it, electricity charges to rupees so and so, and an interest on that amount of rupees so and so. Total suit claim of the plaintiff is 1,22,01,493. It appears from the pleadings of the plaintiff that the plaintiff is the landlord and the defendant is the tenant. In pursuant to the lease agreement dated 13/10/2006, the defendant was inducted into the property of the plaintiff as a tenant. The plaintiff terminated the tenancy of the defendant by issuing a notice dated so and so. On so and so, the defendant evicted from the suit scheduled property in view of the decree passed in a proceedings prior to this. From April so and so to June 2014, the defendant was in wrongful possession of the suit scheduled property, and therefore defendant is liable to pay damages, interest claimed thereon, including electricity charges. This is a summary of the suit. Yes. Now kindly come to para 11. This is pertinent. It appears from the pleadings and the documents produced by the plaintiff that the plaintiff has rented the premises to the defendant for commercial purpose. The learned trial court observes that it was for a commercial purpose. Moving further, the security agreement entered into between the plaintiff and the defendant dated 13/10/2006 was relating to an immovable property used exclusively in trade and commerce. The trial judge observes that the property was used exclusively for trade and commerce. Then, if the claim of the plaintiff against the defendant made in the present suit is based on the said agreement, definitely the dispute is one as defined under section 21C7 of the Commercial Codes Act 2015. But the claim of the damages, interest claim thereon, including electricity charges and interest thereon by the plaintiff from the defendant in the present suit, is not based on the said agreement. It appears from the entire pleadings in the plaint that the claim of the damages, interest claim thereon, including electricity charges and interest thereon by the plaintiff against the defendant.
Counsel, after termination of the tenancy, I think a similar matter, it was, I think somewhere I missed that judgment. Supreme Court said that it is not a commercial. In that Dharwad bench, similar order has been passed. That the trial court has said that it is maintainable. Then appeal has been, writ has been filed before this Dharwad bench. The council has referred to Supreme Court judgment. There Supreme Court has held that, yes, it is not a commercial dispute. It is arising out of from the Chennai. I think similar matters yesterday also.
There is, in fact, the landmark judgment of the Supreme Court on this point is Ambalal Sarabhai.
See, there is no doubt that your transaction agreement is commercial.
Please.
Once termination of the contract, then it is not on that basis of the contract. Therefore, it is not a commercial dispute. Supreme Court rejected that interim order. The senior counsel appearing for that Chennai, he said that let it be matter be there for academic purpose. Supreme Court has passed an order and kept it. I have that. It is 1.5 pages judgment.
I will also look into that judgment.
Just find it.
Just to clarify on your lordship's point, the explanation to order section 2 of the Commercial Codes Act. Your lordships may just have explanation.
Yes. You see that matter which has been arised before that Dharwad, on the basis of the Supreme Court judgment, I am about to dismiss that, allow that writ petition. The counsel appearing for other side, he took time to verify. Then last day of my roster, it came. I said, I want to pass an order. Then he said that anyhow that bench is changing. He sought for a time. I am urgent. But still I have that number. I find out that number.
I will also look into it.
I find that in that internet 2 days back, what has happened to that order? That matter is still pending. It has been urgent. Then next bench said one of the judges disabled. It has been urgent and all. I thought that if the judgment has been disposed of, they may be referred that order.
I understand.
You find out that.
I will look into that. Your Lordship may
days I
kindly have the
searched for that
explanation to
edit.
section 2, because explanation to section 2 is very clear.
Yes.
This is the explanation to section 2 of the Commercial Courts Act, which says a commercial dispute shall not cease to be a commercial dispute merely because
Their explanation?
explanation to section 2. Your Lordships will find this after Roman number 22
Yes,
of
first
section 2.
explanation.
There is an explanation.
Yes.
Please. A commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of immovable property or for realization of monies out of immovable property given as security, or involves any other relief pertaining to immovable property. So this is what is relevant to this dispute as it stands
See,
today.
here, yours is covered under that, which is the class agreement.
We are saying it comes under subclause 7, Roman number 7.
7.
Which is agreements relating to immovable
related to
property
that
used exclusively for trade and
Say that agreement term is over, then it cannot be. That's what.
I understand.
Sure also.
So
That's
the difference in this case would be that today the plaintiff's suit is not arising primarily out of that agreement. The plaintiff's suit today is a claim for damages. There is no dispute as far as that is concerned.
Immovable property used exclusively in the trade or commerce. See, if you are claiming any benefit on that agreement, then they said that if tenancy has been expired, then you cannot seek that on the basis of that commerce. Somewhere that I am not sure that, but just
In fact,
to find out that
there are several judgments of our own High Court and in fact,
weak minutes. I know the decision.
you see, it is not that old recent decision.
I will look into it.
Yes.
The matter may be, I will also just look into it.
Yes, yes.
My only apprehension is the
I have
matter is listed on the
forgotten
7th for cross-examination of their witness. If in case because it is in the B group, if the matter does not reach, I will again have to move the memo.
No,
So-
that you will have it on even 6th. In the meantime, you both of them.
It is posted on
10th.
10th.
Allah, it is posted on 7th before the trial court for cross-examination.
7th, it is there for cross-examination.
Cross-examination madly Allah.
Allah, I am saying suit is only not maintainable.
Case is posted for final arguments.
No, one
Illa,
thing,
illa. My applications for cross have been allowed.
you are the plaintiff.
He is the plaintiff.
No, you are the plaintiff.
I am the plaintiff.
No, you are benefited if it is transferred to the commercial court, speedy disposal.
Argument
Otherwise, you are
ಬಂದಾಗಿದೆ final argument ಗೆ.
Huh?
Final argument ಬಂದ
Argument
trial is over.
Allah,
I know that.
the trial has not been completed. They had led evidence. The cross-examination was taken as nil.
ಎಲ್ಲ ಆಗಿತ್ತು ಇವಾಗ ಒಂದು ಅಯ್ಯ ಹಾಕಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ
Can it be
Because
transferred the stage?
otherwise I am cross-examined in full.
No, it cannot be transferred to the stage. It has been stopped.
It is de novo proceedings before the commercial court.
Innova.
It will be a
cannot-
de novo.
You know
In fact, there is a Supreme Court judgment which clarifies that it has to be
Then
de
you
novo.
just see that, find out that
that next 6th or 7th.
6th, we'll have it on 6th.
Much.
Yes. From last 2 days, I searched, I didn't get that.
I will look into it. We'll find it. Much.
Bill number 55, M. Shiva Prakash for petitioner, Jairama Bhatt, yes.
For respondent.
Yes.
I'm for petitioner. Kindly have next week, madam.
Yes, at the request of counsel for the petitioner, place this matter next week. Yes.
Cell number 56 adjourned, cell number 57, Manu Prabhakar Kulkarni for petitioner,
Please,
Pampa
Lord.
Patike.
Yes.
My application under order 7 rule 11 is rejected.
Hmm.
The two main grounds are registrar of companies is shown as a defendant.
No, it is order 7, rule 11.
Please, my lords.
Hmm.
The registrar of companies is shown as a defendant.
Hmm.
But the registrar of companies is and an
Rejection of order 7, rule 11, Mr. Patil. Is it writ is maintainable or this thing?
Your lordship may please see section 8 of the Commercial Courts Act. I go down-
Commercial court, or it is commercial court, it will not come
Please.
because revision is bought.
Please,
That's what in regular court it is.
please, my lords.
Yes.
No interim relief is sought in the suit.
Yes.
Therefore, there is no urgency. Application is filed seeking dispensation under section 80.
Yes.
Registrar of companies is shown as defendant number 2.
Yes.
I file a 7 rule 11 saying if there is no interim relief sought, dispensation cannot be granted, suit must be rejected. Without disposing of the application seeking leave, which is IA number 1, IA number 3 comes to be rejected. This, my lord, in brief, I have.
What is that IA number 3?
Please, my lords. IA number 3 is under order 7 rule 11. That is my application. May I, my lords, submit a list of dates?
Before proceeding further,
Yes.
for the consolation of the petitioner, we have filed an application for amendment and deletion of respondent number 2 registrar.
Yes.
And also a prayer wherein that registrar was referred. That also we have sought for amendment. It is filed. My learned friend has filed his objections. It is likely to be taken up next date.
If that amendment is allowed, then his ground for rejection would not be, that is what that he is saying.
My lords, I bow down. That is one ground. My second ground, my lords, is under 12A of the Commercial Courts Act. Lord, under 12A, pre-institution mediation is to be conducted in respect of all defendants.
Yes.
So far as defendant number 2 is concerned, pre-institution mediation is not conducted. Therefore, my lords, my respectful submission would be that the filing of the suit is irregular, both under section 80 and under section 12A, and a subsequent deletion will not come to the aid. The only remedy would be to reject the plaint, because even after rejection of plaint under 7 Rule 13, by curing the defect, fresh plaint can be filed. But on the date of filing, if it is irregular, my lords, in partial automation, Supreme Court has said that 12A compliance is mandatory. If it is not done, the only remedy therefore is rejection. They can't subsequently say, I will delete. That would be my one contention. Lord, the second contention would be that there are now 4 suits pending between the parties. One suit has been filed by the very same plaintiff
Yes.
against me in respect of the very same agreement before the civil court. He files a second suit against me before the commercial court.
Yes.
Can he, my lord, split the cause of action like this? One suit partially in civil court, one suit partially in commercial court, which is maintainable? That also would be the question.
Now that, have you, according to you, it has to be commercial court or in a civil court?
Lord, my respectful submission would be that all these...
It's in no court.
Yes.
There he has taken a contention that I should go to commercial court. On his advice, we filed in commercial court. Now he takes a contention, I should go to civil court.
Yes.
Lord, my respectful submission would be that I have also filed a suit in civil court in respect of the same subject matter. That my respectful submission after, my lords, having seen 4 suits would be that a commercial suit is not maintainable on this point.
No, why you have not filed an application for rejection of this plaint on that ground?
My lord, I have. This is one of the grounds.
No, you have said that commercial suit is not maintainable.
My lords.
On what ground?
No, my lords. On that ground, I have not.
How can you say that it has to go to the civil court?
That ground I have not taken.
Then?
But other grounds I have taken. My lords, will your lordship kindly see the list of dates for a moment? Everything will become clear. Okay.
Yes, we will take it this matter some other day.
Lord,
today, I don't think.
Suit is going forward day by day. Will your lordship will not consider staying the suit? Because
What is that next date?
next date is on Monday.
In respect of commercial suit, there is no question of any interim order being passed by any court.
Yes.
Lord, there is no such law. As far as I know,
Yes.
under 227.
As far
courts,
as
my lords,
I
the
will
lordship
answer,
has
I will answer his contention. Mediation is done in respect of a cause where parties are likely to settle. There is no question of registrar settling anything with me.
No,
Therefore,
What is
pre-mediation.
that section says?
Please, my lord.
Please, my lord. Section 12A of the commercial
Yes.
code.
Yeah, there should be, for these contentions and understanding of the provision,
No, we'll see
there
that.
should be some
12.
12A, my lords.
section.
A suit,
12A, yes.
please, my lords. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts a remedy of pre-litigation mediation in accordance with such manner and procedure as may be prescribed by the rules made by the central government. For the purposes of pre-litigation mediation, central government may authorize so and so.
Now, the intention of that legislation is that,
Please, my lords.
is there any possibilities of settling that matter
Please, my lords.
instead of dragging here?
Please, my lords.
Now that you are saying that you have the parties for the pre-litigations mediation,
Please, my lords.
only that registrar,
Please, my lords.
how that matter can be settled with that registrar with that plaintiff?
My lord.
Plaintiff.
My lord.
And see, if that, now that they are filing an application for deletion of the the registrar, now how it will affect that 12A?
Lords, my respectful submission would be there is a judgment of the Supreme Court of 2024, where the Honorable Supreme Court has said it is no more discretionary, it is mandatory.
It's mandatory. We have undergone that.
Therefore, if it is not done and a suit is filed, then suit has to be rejected because subsequently they cannot cure a defect which is not curable.
That is true. Why the 12A has been incorporated in the act is,
Please, my lords.
if it is possible to settle, you settle it and
Please, my lords.
avoid that litigation.
Please, my lords.
Can that matter be settled in the presence of that registrar?
Please, my lords.
No, with registrar, with registrar,
Yes.
in the presence Allah.
With the registrar, what is his role for settlement?
Lords, my respectful submission is please kindly see explanation to section 2C. It specifically says if government is a body, even then commercial suit is maintainable. Therefore, if government is a defendant, he must carry. Your lordship may please see explanation B to section 2C.
Yes.
Your lordship may please see, my lords. 2C defines a commercial dispute.
Yes.
Then your lordship may please come to the
Government can be
explanation.
party. There can be a relief of recovery of money from government.
Explanation B.
Yes.
A commercial dispute shall not cease to be a commercial dispute merely because B, one of the contracting parties is the state or any of its agencies or instrumentalities or a private body carrying out public functions. Therefore, my lords, if the plaintiff believes that a commercial dispute has arisen with a government body, under explanation B, if he says no, although
See, if it is established that registrar is nothing to do with this case,
please, my lords,
then object of the 12A is to be defeated, because that again one more multiplicity of the proceedings. Again here,
Word
that
used
is not the
is-
intention.
there is a
Word
prayer
used is
specifically.
contracting party.
There
Word
is a
used
specific
is
prayer.
contracting party.
Yes,
There is a specific prayer sought.
yes.
Contracting party.
There is a prayer against the registrar.
What is that?
Page 59 of the writ petition.
What is the next date in that trial court?
Monday, my lords.
We'll have it on Saturday.
Lords.
ಅದಕ್ಕೇನು ಸಂಬಂಧ ಇಲ್ಲ. ನನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. He may reject the
Argue on
amendment
that.
application.
That is decided.
What is it that they want?
No, not in the
There is no
evidence.
decree against them. I have not sought for
My
execution.
argument would be, my lords, that amendment application cannot cure such a defect. That argument I cannot make.
Argue it. They may reject it.
Lords, my difficulty is I can't make that
No,
argument.
if it is rejected, then you have a strong case here.
Okay, you will have a better case.
Then a part.
Lord, my difficulty is I can't make that argument because my 7 Rule 11 is already rejected.
7 Rule 11 is.
The rejection of order 7 rule 11,
Please, my
how
lords.
will affect that deletion of that the party in that? If party who is in a necessary,
Please, my lords.
then they cannot be deleted. That should be your arguments. How he is necessary? Without his presence, suit cannot be decided. That is the point you have to be decided.
Lord, my case is that
Then
there is
we'll have it on Tuesday.
Please,
Tuesday, my lords.
Yes, Tuesday.
On Monday, my lords, we'll take adjournment. Let the court be,
Fourth
let
and
the
fifth.
commercial court be directed.
I thought that they are proceeding further. They are hearing on that application.
Application.
Let
He
them
has
hear
filed-
what is there in that.
My learned
It
friend
will
is
not
not allowing that application
to
to
your
be heard.
case. By arguing on that application or deciding on that application will not prejudice your case. We'll have it on Tuesday. Yes.
Fourth and fifth ನನಗೆ ಸ್ವಲ್ಪ ತೊಂದರೆ ಇದೆ. ತಾವು any other date is.
Sixth.
Please.
Yes.
Lords, it's in B group. Will it can be called, my lords, higher? Otherwise, it may not reach. It's in B group.
It will reach. See, you are, for your case only, I sat till 5.
So great.
So serial number 67 maldat.
Serial number 60.
67 maldat. Serial number 67. Some urgency maldat.
67
maldat. 67. Some urgency maldat.
What is that urgency?
That order 3 rule 1 maldat. Order 1 rule 3 was rejected maldat. GPA application was rejected. Now the case is shut down for my evidence maldat. The trial court is not granted time for maldat.
See, from 2023, what are you doing?
My lord, it is not yet reached maldat. I have moved the matter maldat.
Except Monday and Tuesday.
Please, maldat.
Any other date, you ask that to take the date.
My lord.
My lord,
my
serial
lord,
number
serial
68, my lord.
65.
50? 58 Tuesday, Saturday.
My lord,
Saturday.
serial number 65.
Serial number 68, my lord.
65.
ಅವೆರಡು ದಿನ ಬಿಟ್ಟು ಬಾಕಿ ದಿನ ಕೊಡಿ.
Sir, 67 on short date. Sir, 67 ಯಾವಾಗ ಕೊಡ್ತೀವಿ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೈಕ್ ಆಫ್ ಮಾಡ್ಲಾ?
Sir, 65.
ಥರ್ಡ್ ಫೋರ್ತ್ ಬಿಟ್ಟು ಬಾಕಿ ಡೇಟ್ ಯಾರಾದ್ರೂ 59 ಯಾರಾದ್ರೂ ಇದ್ದೀರಾ? 59 ಹೇಳಿ ಮತ್ತೆ ಬೇಗ. ಇವತ್ತು 60
ಸರ್ 68.
61 ಎಲ್ಲ ಇದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಅವತ್ತು ಇದೇ ತರ ಆಯ್ತು ಇದಕ್ಕೆ 62 ನೀವೇ ಹೇಳಿ ಸರ್. ಈ ಸಾಟರ್ಡೆ ಇಲ್ಲ ಸರ್, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬಿಟ್ಟು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತು, ವೆಡ್ನೆಸ್ಡೇನಾ? ಅದೇ ಫಿಫ್ತೇ ಬರುತ್ತೆ ತಿರ್ಗಾ. ಫಿಫ್ತ್ ಎಲ್ಲರೂ ಫಿಫ್ತೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಸೆವೆಂತಾ ಸಿಕ್ಸ್ತಾ ಹೇಳಿ ಬೇಗ. ಸಿಕ್ಸ್ತಾ ಎರಡೂನಾ ಸರ್? 64 ಸಿಕ್ಸ್ತಾ?
Sir, 65.
65
Sir, 10. Monday. Sir, sir, interim order extension.
66 10ನೇ ತಾರೀಕು
ಸರ್ ಅಲ್ಲ
8ನೇ ತಾರೀಕಲ್ಲಿ ಹರೀಶ್ ಯಾವ ಡೇಟ್ ಬೇಕು ಕೇಳಿ.
ಹತ್ತಕ್ಕೆ ಮೇಲೆ
ಮೇಲೆ ಅಂತ
ಅತ್ತೆ ಕೊಡಿ ಸರ್.
10 ಬಿಟ್ಟು
ಮೇಲೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ. ನೀವು
ಆಯ್ತು 11 ಕೊಡಿ.
13
67 ಒಂದು ಯಾವಾಗ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್. 67 ಯಾವಾಗ ಕೊಡಿದ್ರೆ ಅರ್ಲಿ ಕೊಡಿ ಒಂದು. ಯಾವ್ದು ಅದೇ ಡೇಟ್ ಕೊಡಿ ಅರ್ಲಿ ಯಾವಾಗ.
ಯಾವಾಗ ಅಂದ್ರೆ 5ನೇ ತಾರೀಕಿಗೆ ಕೊಡ್ತೀನಿ.
5 ಬಿಟ್ರೆ
ಇಲ್ಲ 5 ಆದ್ಮೇಲೆ ಯಾವ್ದು
5 7 ಕೊಡಿ.
7 6 ಗಂಟೆ ಯಾವತ್ತಾಗಲ್ಲ.
8
8 ರಜೆ 9 ರಜೆ ಗೊತ್ತಾಗ್ಲಾ?
5 ಕೊಟ್ಬಿಡಿ ಹೋಗ್ಲತ್ತ. ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಸರ್.
68
ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತಾವಲ್ಲ.
ಆಟೋಮೆಟಿಕ್
ಇಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ ಹೇಳಿ. 68 69 ಎಲ್ಲ 50 ಆದ್ರೆ ಅವತ್ತು ಈ ತರ ಕಾಯ್ಬೇಕು ಸರ್. ಸಂಜೆವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಆಯ್ತು ಬಿಡಿ 5th ಹಾಕಾಯ್ತು. ಬೇರೆ ಎಂಟ್ರಿ ಮಾಡೋದು
ಸರ್ ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್
ಆಯ್ತು. ಬೆಳಗ್ಗೆ ಬಂದು
ಸರ್ 64
ಈಗ ಕೊಟ್ರೆ ನಾನಿದ್ದೆ
ಸರ್ 60
ಸಾಹೇಬ್ರಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ನಾನು ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೇನೆ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆನೆ ಸಾಹೇಬ್ರಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಅವರು ಡೇಟ್ ಕೊಟ್ರೆ ಮಾತ್ರ ನಾನು ಕೊಡಕ್ ಸಾಧ್ಯ. ನನ್ನ ಕಡೆ ಕೊಟ್ಟೆ 10 ದಿವಸ ಅಂತ ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ. ಅವರ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಬಿಡು ಅಂತ.
ಸರ್ 64 6ನೇ ತಾರೀಕು ಕೊಟ್ರಿ 7ಕ್ಕೆ ಮಾಡ್ಬಿಡಿ. 7 ಅವರೇ ಪಿಟಿಷನರು, ನಾನ್ ರೆಸ್ಪಾಂಡೆಂಟ್. 7ನೇ ತಾರೀಕು ರೈಟ್ ಸರ್.
ಎಂಟ್ರಿ ಮಾಡಿ ಎಲ್ಲೆಲ್ಲಿದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ ಆಟೋಮೆಟಿಕ್. ಆಯ್ತು ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದೆಲ್ಲ ಅದೆಲ್ಲ ನನ್ಗೆ ಹೇಳ್ಬೇಡಿ
ಸರ್. ಒಂದ್ ಮಾತು ನೀವು ಫೋನ್ ಮಾಡಿ ಪ್ಲೀಸ್ ಸರ್.
ಹೇಳಿದ್ರೆ ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ
ಸರ್.
ಮಾಡು ಅಂತ ಹೇಳಕ್ಕೆ ನಾನಲ್ಲ ಹೊಣೆ, ಅದು ಬೋರ್ಡ್ ಬ್ರಾಂಚರ್. ಅವ್ರು ಯಾರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ
ಸರ್ ಅವ್ರದ್ದು
ಮೇಡಮ್. ಅದ್ರ ತಲೆನೋವೇ ಬೇಡ. ಒಂದ್ ದಿವಸ ನಾನು ಎರಡಪ್ಪ ಸೀಜೆ ನನ್ನನ್ನು ತರಿಸ್ಕೊಳ್ಳಿ. ಕ್ಲೋಸ್ ಮಾಡಿದ್ಮೇಲೆ ನೀನ್ ಯಾರು ಹೇಳಕ್ಕೆ ಅದನ್ನ. ಇನ್ನೊಂದು ನೀನ್ ಸಾಹೇಬ್ರು ಹೇಳಿದಾರ ಅಂತ ಸಿಜೆ ಅವ್ರ ಕರೆದು ನಾನು ಕೇಳಿದ್ದಾರೆ. ಅಲ್ಲಿ ತನಕ ಹೋಗಿದೆ. ಮೆಮೊ ಇದ್ರೆ ಅವನು ಕನ್ಸರ್ನ್ ಯಾವನ್ ಲೇಟ್ ಆಗಿ ಕಳಿಸ್ತಾ ಅವ್ನು ಆನ್ಸರ್ ಮಾಡ್ತಾನೆ. ಬೆಳಗ್ಗೆ ಅಫಿಡವಿಟ್ ಹಾಕಿ ನಾನೇನ್ ಮಾಡ ಸೀಜೆ ನನ್ನ ಹಿಡ್ಕೊಂಡು ಲೀಸ್ಟ್ ಲೇಟ್ ಆಯ್ತು ಅಂತ ನಾನು ಆನ್ಸರ್ ಬರಲ್ಲ. ನಿಮ್ದೊಳ್ಳೆ ಅವ್ರವ್ರ ಕೆಲಸ ಅವ್ರವ್ರು ಮಾಡ್ಬೇಕು. ನಂದೇ ಇನ್ನೂ ರಾಶಿ ಕೆಲಸ ಇದೆ. ಇದೇ ತರ ಎರಡಪ್ ಮಾಡಿಸಿ ಕೊನೆಗೆ ನನ್ನನ್ನು ಕರ್ಸಿ ಅವ್ರು ನಿಲ್ಸಿದಾರೆ. ಅಲ್ಲಿ ಸಿಜೆ ಡೈರೆಕ್ಷನ್ ಏನಿದೆಯೋ ಅದು ಫಾಲೋ ಮಾಡ್ಬೇಕಲ್ವಾ ಅವರು. ಮಾಡ್ಲಿಲ್ಲ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ, ಅನುಭವಿಸ್ತೀನಿ. ಆತರ ಎಲ್ಲ ಕೇಳಲೂಬಾರ್ದು ನೀವು. ಹೇಳಿ ಅಂತ ನಾನು ಹೇಳಕ್ಕಾಗತ್ತೆ ನಮ್ಮ. ನಾನೊಬ್ಬ ಕೆಲ್ಸಗಾರ ಇಲ್ಲಿ. ಈಗ ಸಿಜೆ ವಿರುದ್ಧ ನಾನು ಹೇಳಕ್ಕಾಗತ್ತ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಸೇರ್ಸಪ್ಪ ಎರಡಪ್ ಮಾಡಪ್ಪ ಅಂತ. ಲಿಸ್ಟ್ ಇಶ್ಯೂ 4 ಗಂಟೆಗೆ ಆಗಿರುತ್ತೆ. ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡು ಅಂತ ನಾನು ಹೆಂಗೆ ಹೇಳಕ್ ಬರುತ್ತೆ? ವೆಬ್ ಪೋಸ್ಟ್ ಆಗಿರೋ ಲಿಸ್ಟ್ ನೀವು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡ್ತೀವಿ. ವೆಬ್ ಪೋಸ್ಟ್ ಆಗಿರೋ ಲಿಸ್ಟ್ ರೀ ಇಶ್ಯೂ ಮಾಡಕ್ ನಾನು ಯಾರು? ಹಂಗ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಕೊನೆಗೆ 5 ಗಂಟೆಗೆ ವೆಬ್ ಪೋಸ್ಟ್ ಆಗಿರೋದು ಯಾಕೆ ಅಂತ ಕೇಳಿದಾಗ ನನ್ನ ವಿರುದ್ಧ ಇಷ್ಟುದ್ದ ಎನ್ಕ್ವೈರಿ ಆಗಿದೆ. ಆ ಥರ ಎಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವ್ರ ಕನ್ಸರ್ನ್ ಯಾರು ಅವ್ರೇನಾದ್ರು ಜವಾಬ್ದಾರಿ ತಗೊಂಡ್ರೆ ಮಾಡಿಸಿ. ಎಲ್ಲದಕ್ಕೂ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಗಲ್ಲ. ಫೈನಲ್ ಐತೆ. ಎಲ್ಲಿ?
ಅದ್ರ ಕೆಳಗಡೆ ಇವೆಲ್ಲ.
ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತಾ ಅದು? 13ನೇ ತಾರೀಕಿಗೆ ಹೋಗಿದ್ದು. ಈಗ ಸಾಹೇಬ್ರಿಗೆ ಏನು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರು ಎಲ್ಲ ಮಾಡಿದ್ರು ಆ ಪ್ರಕಾರವಾಗಿ ಅದನ್ನ ಈ ಲಿಸ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿಸ್ಬೇಕು. ನಿಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ಇನ್ನೊಬ್ರು ಸೀನಿಯರ್ ಮೇಡಮ್ ಅವ್ರು ಗೊತ್ತಾಗುತ್ತೆ. ಯಾರಿಗೆ ಹೇಳಿ? ಹಲೋ ಯಾರಮ್ಮ ಮೇಡಮ್? ಬೆಳಿಗ್ಗೆ ಬಂದಿರೋದು ನೀವು? ಸರಿ, ನಿಮ್ಗಾಲೆ 13 ಹೋಗಿ 13 ವಿಧಾನಕ್ಕೆ ಕೇಳಿ ಯಾವ ತರ ಯಾವ ಕರೆಕ್ಟ್ ಆಗಬೇಕು, ಯಾವ ಪೆಂಡಿಂಗು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದಿಲ್ಲ. ಈಗ ನಾನು ಫೈಲ್ ಕಳಿಸ್ತೀನಿ, ಕ್ಲೀನ್ ಆಗಿ ಆ ಪ್ರಕಾರವಾಗಿ ಹಳೆ ಆಗ್ಬೋದಾ? ನೆಕ್ಸ್ಟಿಗೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಡು ಆಗ್ಬೋದಾ? ಆಯ್ತು. ಈಗ ನಿಜನ ಅದೇ ತೆಲುಗು ಆರ್ಪಿ 8 about ಕಳ್ಸೋದಲ್ಲಮ್ಮ, ಅಲ್ಬಮ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಕಳ್ಸ್ಕೋಬೇಕಾಗುತ್ತೆ. ಯಾಕಂದ್ರೆ ಡಿಲೇ ಆಗ್ಬಾರ್ದಲ್ಲ, ಯಾಕಂದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಬೇಕು. ಅಲ್ಲ ಕಳ್ಸ್ಕೊಡೋದಲ್ಲ, ಅಲ್ಲ ಇದಕ್ಕೆ ಪ್ರೊಸೀಜರ್ ಏನಿದೆ ನೋಡ್ಬೋದು. ಏನಮ್ಮ? ಹೇಮಂತ್ ಚಂದ್ರ ಸಿಂಗಲ್ ಮಾಡಿ ನೀವು ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ಟು ಬೇಗ ಏನಾದ್ರು ಇದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. ಅದು 48 ಮುಂದಿದೆಯಮ್ಮ. ಇಷ್ಟೇ, ಇನ್ನೇನು ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ, ಒಂಚೂರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಪಾಪ, ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ ಟ್ರಾನ್ಸಿಟ್ ಆಗುತ್ತಲ್ಲ. ಸರಿ, ಅದೇ ಏನಾದ್ರು ನೀಟ್ ಫುಲ್ ಹೋಗಿಲ್ಲ ಎಲ್ಲಿ ಹೊಟ್ಟಾಯ್ತು ರೆಕಾರ್ಡ್ ಅದು ಹಾಕಿ ದೊಡ್ಡದು ಇವತ್ತಿತ್ತಲ್ಲ, ಅದೇ ಗಲಾಟೆ ಮಾಡಿ. ಎಲ್ಲಿ ತಗೊಂಡೋಗ್ಬಿಡ್ತಾರೆ. ಅಲ್ಲಿ ನಾನು ಆ ಕಡೆ ಹೋಯ್ತಲ್ಲ ಅದು ಮತ್ತೆ ನಾನು ಮೇಡಮ್ ಫುಲ್ ನೀವು ಬಿಚ್ಚಿರ್ತೀರ ಅನ್ಸುತ್ತೆ. ನೋಡಿ ಬೇಗ RP 226 ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಟು ತಗೊಂಡೋಗಿರ್ತ. ಅದು ಅಷ್ಟು ಫುಲ್ ಕರೆಕ್ಟ್ ಅದೇನೆ. ಸಪ್ರೇಟ್ ಹಾಕಿದ್ರು ಒಳ್ಳೇದೇ. ಯಾಕೆ ಸುಮ್ಮನೆ ತಲೆನೋವು ಮಾಡ್ರಿ. ಈಗ ತಾನೇ ಅದನ್ನ ಹೇಳಿದೆ, ಆಗ್ಲೇ ಸಾಹೇಬ್ ಬಿಲ್ ಕೇಳಿದ್ರು, ಅವ್ರಿಗೆ ಹೇಳ್ಬೋದು ಓಡೋಗಿ ಸಪ್ರೇಟ್ ಹಾಕ್ಬಿಡಪ್ಪ ಫುಲ್ಲು.
कुछ समय पश्चात प्रयास करें।
ಸೆವೆನ್
ಅಲ್ಲ
ಹಾ
7 ಡಿಸ್ಪೋಸಲ್
7 ಇದು ಬರ್ಕೊಂಡಿದ್ಯಾ ಡೇಟ್ ಎಲ್ಲಾನು ಅಪ್ಡೇಟ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಯ್ತಲ್ಲ.
ಯಾವಾಗ
ಅವ್ರು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ತಿರ್ಗಾ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು 64 7ನೇ ತಾರೀಕು ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಕೊಬಿಡ, ಅವ್ರೆಲ್ಲ ಖಾಲಿ ಆಗೋರು
64
7ನೇ ತಾರೀಕು ಬೇಕಂತ, ಮುಂದಕ್ಕೆ ಬೇಕು ಅಂತ ಕೇಳ್ಕೊಂಡ್ರು.
ಆಮೇಲೆ
ಅಷ್ಟೇ ಬಾಕಿದೆಲ್ಲ ಬರ್ಕೊಂಡಿದ್ಯಾ? ಹಲೋ ಸರ್. ಸರ್ ಅರ್ಜೆಂಟ್ ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ಗೆ ಕಳಿಸ್ಕೊಡಿ ಸರ್ ಬೇಗ. ಸಿವಿಲ್ ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ಗೆ ನಿಮ್ಮವ್ರ ಯಾರು ಕಳಿಸ್ಕೊಡಿ. ಕಂಪ್ಲೇಂಟ್ಸಿಗೆ ರೆಕಾರ್ಡ್ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ. ದಿಲೀಪ್ ಅಂತಿದ್ದಾರಾ? ಅವ್ರಿಗೆ ಎಸ್ ಒ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ. ಅಲ್ಲಿ ಇಬ್ಬರು ಎಸ್ ಒ ಇದ್ದಾರೆ, ಒಬ್ಬರೇ RP ಎಸ್ ಒ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಸರ್ ಬೇಗ. RP ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ ಎಸ್ ಒ ಅವರು ಧಾರವಾಡದಿಂದ ಫೋನ್ ಬಂದಿತ್ತಲ್ಲ, ನಾವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಸರ್. ಓಕೆ.
ಡಿಸ್ಪ್ಲೇ ಬರದೇ ಇರೋದು.
ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ ಸರಿ ಹೋಗಿತ್ತು, ತಿರ್ಗಾ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತಂತೆ. ಸರಿ ತಿರ್ಗಾ ಮಾಡಿದೀವಿ ಅಂತಾನೆ ಹೇಳ್ತಾವ್ರು. ಡಿಸ್ಪ್ಲೇ ಸರಿ ಮಾಡಿದೀವಲ್ಲ ಅಂತ. ಹಲೋ ಆಯ್ತು. ಹಲೋ ಇಲ್ಲ ಇಲ್ವಾ ಫಸ್ಟೇ ಕೊಟ್ವಲ್ಲ. ಇಲ್ವಾ ಯಾಕೆ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಒಂದು ಯಾವ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹಲೋ ಎಲ್ಲಿಗೆ ಇಲ್ಲ ಸರ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ ವೆರಿಫೈ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ತರ್ಸ್ಕೊಳಕ್ ಹೇಳಿ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಇಂದ ತರ್ಸ್ಕೊಳ್ತೀನಿ ಬಿಡ್ಬಿಡಿ ಅಲ್ಲೇ ಇದೆ ಈಗ ತಾನೇ ನಾನು ಮಾತಾಡಿದೆ ಅವ್ರು ಧಾರವಾಡದಿಂದನೂ ಮಾತಾಡ್ಸಿದೀನಿ ಹಲೋ ಹೇಳಿ ಯಾರು ಹೇಳೋದು ಹೀಗೆ ನಮ್ಮ ಟೆಂಬರ್ ಇಲ್ಲ ಆಯ್ತು ಹಲೋ ಹೌದೌದು ಹೇಳಪ್ಪ ನಾನು ಅವ್ರ ಎಸ್ ಹತ್ರ ಮಾತಾಡಿದ್ದೀನಿ ನೋಡಪ್ಪ ಬೇಗ ಧಾರವಾಡದಿಂದನೂ ಫೋನ್ ಮಾಡಿ ಸರಿ ಒಂದ್ ಸ್ವಲ್ಪ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಬೇಗ ಬಾಪ್ಪ ಎಷ್ಟೊತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರಿ ನೀವು ಮತ್ತೆ ಅವ್ರು ಇಷ್ಟೊತ್ತು ಕಳ್ಸಿರ್ಬೇಕಲ್ಲ ಬೇಗ ಬನ್ನಿ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಕ್ಲೋಸ್ ಆಗೋಗುತ್ತೆ ನಾನು ಹೇಳಿರ್ತೀನಿ ಬನ್ನಿ ಅಲ್ಲಿ ಎಸ್ 50. Sorry, 25. Sorry, 25. ಇದು ಧಾರವಾಡದಲ್ಲಿ ಮೆಮೊರಿ ಮಾಡಿ ಸ್ಕೂಟನಿ ಬ್ಯಾಂಕಲ್ಲಿ ಕಾಯ್ತಾ ಇದೆ. ಧಾರವಾಡದಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತಿದ್ದಾರೆ. ಅದೇ ಅಲ್ಲಿಂದ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈಗಲೇ ಕಳಿಸಿ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ನಿಮ್ಮ ಕೈಲಿ ಬಂದಿದ್ರು. ಅವ್ರಿಗೆ ಸಮಾಧಾನ ಅವ್ರ ಕೈಗೆ ಕೊಡ್ತಾರೆ ಸಮಾಧಾನ. ಸುಮ್ಮನೆ ಗಲಾಟೆ ಅವ್ರು ಇದ್ದಾರೆ ಕೊಡಿ. ಅಡ್ವೊಕೇಟ್ ದಿಲೀಪ್ ಅಂತ ಬಂದಿದ್ದಾರೆ. ಮತ್ತೆ ಅವ್ರಿಗೆ ಆರಾಮ ತುಂಬಿ ನಮ್ಮ ತಲೆ ತಿಂತಾರೆ ಬಂದಿಲ್ಲ ಅಂತ ಕೆಲಸ ಆಗುತ್ತೆ. ಸರಿ ಆಯ್ತು. ಸರ್ ಇಲ್ಲ ಸರ್ ಇಲ್ಲ ತಗೊಂಡ್ಬೋದು ಎಷ್ಟೊಂದು ತಗೊಂಡ್ಬೋದು ಉಳಿದಪಟ್ಟ ಯಾವ ಬ್ರಾಂಚ್ ಹಲೋ ಈಗ ಯಾವ ಬ್ರಾಂಚ್ ಸರಿ ಅಮ್ಮ ಈಗ ಯಾವ ಬ್ರಾಂಚ್ ಬಂದಿದ್ದಾರೆ ನಾವು? ಹಲೋ ಹಲೋ ಅಲ್ಲಿ ಒಂದೇ ನಿಮಿಷ ನಮ್ಮ ಮಾತು ಕೇಳಿ ಫೈಲಿಂಗ್ ತಗೊಂಡು ಸಾಂಗ್ ಮೇಡಮ್ ಅವ್ರ ಕೈಯಲ್ಲಿ ಸಾಂಗ್ ಮೇಡಮ್ ಅಂತ ಯಾರು ಸ್ಕೂಲಲ್ಲಿ ಬ್ರಾಂಚ್ ಬಂದ ಸರ್ ಸಾಂಗ್ ಮೇಡಮ್ ಅವರೇ ತಂದಿದ್ದಾರೆ ನೋಡಪ್ಪ ಪೇಜ್ ಫೈಲಿಂಗು. ಹಲೋ ದಿಲೀಪ್ ಅವರೇ ಸರ್ ಸಾಂಗ್ ಮೇಡಮ್ ಯಾರು ಬಂದಿದ್ದಾರೆ? ಸಾಂಗ್ ಮೇಡಮ್ ಅವರೇ ಕೈಯಿಂದ ತಂದಿದ್ದಾರೆ ಕೊಡಿ ಸಿಕ್ಕಪ್ಪ. ಮತ್ತೆ ಯಾಕಪ್ಪ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋರು ನೋಡೋದಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. ಹಲೋ ಸರ್ ದಿಲೀಪ್ ಅವರೇ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. ಹಲೋ ಹೇಳ್ತಾ ಇಲ್ಲ ಸರ್ ಅವ್ರು ಹೇಳ್ಬಿಡಿ ಸರ್. ಸರ್ ಪಾಸ್ ಆಗೋರು ಹೋಗ್ಬೇಡ ಅಂತ ಹೇಳಿ ಸರ್ ನಾವು ಹೇಳಿದ್ದೀನಿ ಅಲ್ಲೇ ಆರಾಗುತ್ತೆ ಪಾಸ್ ಆಗುತ್ತೆ. ಪಾಸ್ ಆಗಬೇಕು ಪಾಸ್ ಆಗಬೇಕು ನಮ್ಗೆ ಯಾಕಂದ್ರೆ ನಾನು ನಂಬರ್ ಪಾಸ್ ಆಗೋದು ಅಲ್ಲೇ ಏನೇ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು ನಮ್ಗೆ ಹೋಯ್ತಪ್ಪ ಬಾಕ್ಸ್ಗೆ ಅದು ಫುಲ್ ಹಾಕಿದ್ದೀರಾ ಆರ್ಡರ್ ಶೀಟ್ ಸಮೇತ? ಸರಿ ಅಂತ ಇವ್ರು ಹೇಳ ಅವ್ರ ಕೆಲಸ. ಯಾವ್ದು ಇಷ್ಟೊಂದು ಫೈಲ್ ನಾಳೆದಾ? ಕನೆಕ್ಟೆಡ್ ಇದ್ರೆ ಕೊಟ್ಟು ಕಳ್ಸಿ, ಅದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಿ ಬೇರೆ ಕಡೆ ಹೋಗುತ್ತೆ. ಹಾ ಹಾ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆದ ಫೈಲು ಇನ್ನು ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ, ಕೊಟ್ಟು ಕಳ್ಸಿ ನೀವು. ಕ್ರಿಮಿನಲ್ ಬ್ರಾಂಚ್ಗೆ ಕಳಿಸ್ತೀವಿ. ತರ್ಸ್ಕೊಂಡಿಲ್ವಾ ನೀವು?
ಇಲ್ಲಿದೆ ಅದ ಬೋರ್ಡ್ ಕಳಿಸ್ಬಿಟ್ಟಾ?
ಹಾ ನಿಮ್ ಪಾಡ ನೀವು ಬೋರ್ಡ್ ಕಳಿಸಿ. ಅಲ್ಲಮ್ಮ ಈಗ ಕನೆಕ್ಟ್ ಆಗಿದಾವ ಎಲ್ಲ?
ಇದೆ ಸರ್.
ಎಲ್ಲ ಕ್ರಿಮಿನಲ್ RP RF ಎಲ್ಲ
ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಹಾ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಏನಂತ ಆಗಿದೆ?
ಅದೇ ಸೀನಿಯರ್ ಜಡ್ಜಸ್.
ಯಾವತ್ತಾಗಿದೆ?
ಅದು ತುಂಬಾ ಹಳೇದೆ ಸರ್, ಹಳೆ ಫೈಲ್ ಅದು.
ಮೇನ್ ಫೈಲ್ ಯಾವ್ದು?
1070. ಅದಕ್ಕೆ ಕ್ರಿಮಿನಲ್
ಹಾ ಯಾವತ್ ಮೂವ್ ಮಾಡಿದ್ರಮ್ಮ ಇದನ್ನ?
ಇದು ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಇರಮ್ಮ ಅವ್ರಿಗೆ ಯಾವತ್ ಮೂವ್? ಸರಿ ಆಯ್ತು, ಸರಿ ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅರ್ಜೆಂಟ್ ಮೆಮೊ ಅಲ್ಲ, ಅರ್ಜೆಂಟ್ ಇದಕ್ಕೆ ನಾನು ಹಿಂದೆ ಬರೀತೀನಿ. ಈ ನಾಳೆ ಬರಲ್ಲ, ನಾಳೆ ಅರ್ಧ ದಿವಸ ಇದೆ. ಜೊತೆ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟ್ರು ಅಷ್ಟೇ. ಆಮೇಲೆ ಸಾಹೇಬ್ರು ಲೀಸ್ಟು 2 ಇಶ್ಯೂ ಆಗೋಗಿದೆ. ಈಗ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ 3ನೇ ಲಿಸ್ಟು. 3ನೇ ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಸಾಹೇಬ್ರ ಪರ್ಮಿಷನ್ ಬೇಕು, ಜೊತೆ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟ್ರು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೋಸ್ಟ್ ಮಾಡಕ್ ನಾನು ಹೇಳ್ತೀನಿ. ಯಾವತ್ತು? ಸಾಟರ್ಡೆ ಬರಲ್ಲ RFA ಒನ್ಲಿ ಫ್ರೈಡೆ. ಅರ್ಥ ಆಯ್ತಾ? ನಾಳೆ ಹಾಫ್ ಡೇ, ಫೇರ್ವೆಲ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಶಿವಶಂಕರೇಗೌಡ. ಜೊತೆಗೆ ಆಲ್ರೆಡಿ 2 lists ಆರ್ ಆಲ್ರೆಡಿ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್. ಸೊ ಇವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ನೀವೇ ಹೇಳಿ. ನನ್ನ ಪರಿಸ್ಥಿತಿಲಿ ಇದ್ದೀನಿ, ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಹೇಳ, ನಿಮ್ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್ಗೆ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಹೇಳ್ತೀನಿ. ಆಗ್ಬೋದಾ? ಪಟ್ ಹೇಳಿ. ನಿಮ್ ಸೀನಿಯರ್ ಕನ್ವಿನ್ಸ್ ಮಾಡು. ನಿಮ್ಗೊಂದು ಚಾನ್ಸ್ ಸಿಕ್ಕಿದೆ ಇವಾಗ. ಸರ್ ನಾಳೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೂ ಹೇಳಿದೆ, ಸಾಹೇಬ್ರಿಗೂ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡೆ. ಸಾಹೇಬ್ರು ಹಿಂಗೆ ಹೇಳೋದಂತ ಹೇಳಿ ಜಡ್ಜ್ ಮೇಲೆ ಅಷ್ಟೇ. ಏನ್ ಮಾಡೋದು, ತಪ್ಪಿಸ್ಕೋಬೇಕಲ್ವಾ? ಆಯ್ತಮ್ಮ. ಶುಕ್ರವಾರ ಇವ್ರ ಯಾರು ನೀವು RFA ಪೆಂಡಿಂಗ್? ಇವಾಗ ಅಲ್ಲಿದ್ದಿರೋದು
2 months ಆಯ್ತು. ಮಂಡೇ ಇಂದ ರಿಪೀಟ್.
ಓಹೋ
ಆಗಿದೆ
ಸರಿ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಹಾಕ್ತೀನಿ.
ಸರಿ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಹಾಕ್ಕೊಡ್ತಾರೆ. ಫ್ರೈಡೆ ಥರ್ಸ್ಡೇ ಹೋಗಿ ಅವ್ರಿಗೆ ರಿಮೈಂಡ್. ಅವ್ರು ಇರಲ್ವೇನೋ? ಅವ್ರ ಎಸ್ಸೋಗೆ ರಿಮೈಂಡ್ ಮಾಡಿ. ಆಯ್ತು, ಇಲ್ಲ ನಂಗೆ ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ಆಯ್ತು, ನಂಗೆ ಹೇಳಿ, ನನಗೆ ಹೇಳಿ. ಅವ್ರು ಬಂದು ನನಗೆ ಹೇಳ್ತಾರೆ ಬಿಡಿ, ನಿಮ್ಗೂ ತಲೆ ತಿನ್ನಲ್ಲ. ಸರಿನಮ್ಮ? ಆಯ್ತಾ? ಯಾರು ಅಡ್ವೊಕೇಟ್? RFA ಯಾರು? ಇಲ್ಲ ಶಾರು, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿಮ್ ಸೀನಿಯರ್ ಹೆಸರು ಹೇಳ್ತಾ ಇದ್ದೀರ ತಾನೆ? ಸರಿ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಅಲ್ಲ ನಾನು ನಿಮ್ಗೆ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳ್ಬೇಕು, ತಲೆ ಕೆಡ್ಸ್ಕೊಂಡಿಲ್ವಲ್ಲ. ಈಗ ಇಷ್ಟೊತ್ತಿಲ್ಲ ಯಾರೋ ಬಂದಿರೋ ದೊಡ್ಡ ಜಗಳ ಆಗಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಹತ್ರ ಹೋಗಿ, ತಿರ್ಗಾ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಸಾಹೇಬ್ರ ಹತ್ರ ಬಂದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡಿ, ಈಗ ತಿರ್ಗಾ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್, ತಿರ್ಗಾ ನಾನು ಸಾಹೇಬ್ರು ಹೋದ್ರೆ ಸಾಹೇಬ್ರು ಕಳಿಸ್ತಾರೆ ಅಷ್ಟೇ ಮನೆಗೆ. ಥ್ಯಾಂಕ್ ಯು, ಥ್ಯಾಂಕ್ ಯು. ಆಗ್ಬಿಟ್ರೇನ್ರಿ? ಇನ್ನು ಇಷ್ಟೊಂದು ನೋಡ್ಬೇಕಲ್ಲ, ಇನ್ನು ನೋಡೋದು ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾರೆ ನಮ್ಗೆ. ಏನಾದ್ರು ಉಲ್ಟಾ ಪಲ್ಟಾ ಮಾಡ್ಕೊಟ್ರಿ ಇನ್ನು ಅದಕ್ಕೊಂದು ಮಾತು ನಿಮ್ ಚೇಂಬರ್ ಅಲ್ಲಿ. ನೀನ್ ನೋಡಿಲ್ಲ ಬೆಳಗ್ಗೆ ಬರ್ತವೆ ಫೋನ್ಗಳು, ಈಗ ಬರಲ್ಲ. ಈಗ ಅವರು ಮನೆಗೆ ಹೋಗ್ಬಿಡ್ತಾರೆ. ನಮ್ಗೆ ಬೆಳಗ್ಗೆ ಇಲ್ಲಿ ಕೋರ್ಟ್ ನಡೀತಾ ಇರ್ತದೆ, ಫೋನ್ ಹಾಕೊಂಡು ತಲೆ ತಿಂತಾರೆ. ನೀನ್ ನೋಡಿಲ್ಲ, ಅದ್ ಮಾಡಿಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಿ, ಎಷ್ಟು ಎಲ್ಲಾ ಪೇಜಲ್ಲಿ ನೋಡ್ಕೊಂಡ್ಬರ್ತೀವಿ. ಒಂದು ಫೈಲ್ಗೆ 20 ಆರ್ಡರ್ ಶೀಟ್ ಇದ್ರೆ 20 ಪೇಜ್ ತಿರುಗಿಸ್ಬೇಕು. ಮಾತಾಡಪ್ಪ ಆಯ್ತು. ಇದು ಇವಂದು ಕೊಟ್ಬಿಟ್ಟು ಬಂದ್ಬಿಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ ಸರಿ ಆಮೇಲೆ ನಮ್ಮ ಒಬ್ರೊಬ್ಬರ ನಾವು ಧಾರವಾಡದಲ್ಲಿ ಯಾರೋ ಇತ್ತು. ಮಹೇಶ್ ಎಲ್ಲಿದ್ದೀರಾ? ಏನ್ ನಿನ್ನೆಯಿಂದ ಫೋನೇ ತೆಗಿಲ್ವಲ್ರಿ? ಈಗ ಎಲ್ಲಿದ್ದೀರಾ? ಹಂಗಾರೆ ಸಿಕ್ಕಲ್ಲ ಇವತ್ತು. ಹಾ, ಏನಾಯ್ತು ಅದು? ಈಗ ಅವರೇ ಮಾಡ್ತಾರಂತ ಅಥವಾ ಅದಕ್ಕೆ ಸಾಹೇಬ್ರು ನಿನ್ನೆ ಯಾರು? ಹಾ, ನೀವ್ ಇನ್ನು ಮಾತಾಡೋದ್ರಲ್ಲೇ ಇದ್ದೀರಿ. ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲಪ್ಪ, ಅದ್ ಸರಿ, ಅದ್ ನೋಡೋಣ. ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡೋದು? ಸರಿ, ಆಯ್ತು ಆಯ್ತು. ಕೊಡಿ. ಹಲೋ ಮೇಡಮ್, ನಮಸ್ತೆ. ಟೋಟಲ್ 11 ಇಂದ ಟೋಟಲ್ ಹಿಂದೆ ಮ್ಯಾಟ್ರೋಡ್ ಅರ್ಜೆಂಟ್ ಇತ್ತು, ಮೂವ್ ಮಾಡಿದೆ. ನಾನು ಅವಾಗಲೇ ಎಸ್ఓರ್ಗೆ ಹೇಳಿದೆ, ಇನ್ನೊಬ್ರು ಎಸ್ఓರ್ಗೆ ಹೇಳಿದ್ದೆ, ಸ್ವಲ್ಪ ಕೊಡಿ. ಮತ್ತೆ ಧಾರವಾಡಕ್ಕೆ ಹೋಗ್ಬೇಕು. ಯಾಕೆ? ಅಲ್ಲಮ್ಮ, ಈ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ಬಿಡಿ, ಆಮೇಲೆ ನಾನು ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ, ಡಿಸ್ಪ್ಯಾಚ್ ಅವ್ರ ಹತ್ರ. ಸ್ವಲ್ಪ ಬೇಗ ನಾನು ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂತೀನಿ. ಹಾ, ಅಲ್ಲಮ್ಮ, ಮಂಡೇ ಲೀಸ್ಟ್ ಇನ್ನೂ ಮಾಡ್ಸಿಲ್ಲ. ನಾನು ಇನ್ನೂ ಬೋರ್ಡ್ ಬ್ರಾಂಚಿಗೆ ಕಳಿಸಿ ಲೀಸ್ಟ್ ಬೇರೆ ಆಗ್ಬೇಕು, ಲೀಸ್ಟ್ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು. ಅದು ಇನ್ನೂ ಕೆಲಸ ಇದೆ. ನೀವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ರೆ ನಿಮ್ಮಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಇಷ್ಟೇ, ಸ್ವಲ್ಪ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ರೆ ಬಾಕಿ ನಾನು ಬೋರ್ಡಲ್ಲಿ ಮಾತಾಡ್ತೀನಿ. ಅವ್ರು ಯಾರ ಹತ್ರ ಅವ್ರು ಸೀದಾ ಸರಿಯಮ್ಮ ನಿಮಗೆ. ಈಗ ಕೇಳಿ ಒಂದೇ ಒಂದು ನಿಮಿಷ ತಾಳ್ಮೆಯಿಂದ ನೀವು ಕೇಳಿಸ್ಕೊಳ್ಳೋದಾದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಒಂದು 5 ನಿಮಿಷ ಅವ್ರು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಕಂಪ್ಲೇಂಟ್ಸ್. ಒಂದ್ 5 ನಿಮಿಷ ಕೊಡಿ, ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ನೀವೇನಾದ್ರು ಮಾಡಿ, ಹೋದ್ರೆ ಬರ್ತು ಇಲ್ಲ ನಾನು ಮಾಡೋ ತರ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೋಡೋಣ ಆಮೇಲೆ ಮಾತಾಡೋಣ. ಒಂದ್ 5 ನಿಮಿಷ ಕೊಡಿ ಅಮ್ಮ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಆಗ್ಬೋದಮ್ಮ. ಮೊಬೈಲ್ ಫೋನ್ ಫೋನ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ.